We are on the record for hearings in the matters listed on the North Dakota Industrial Commission hearing docket for March 25th. I'm David Garner, hearing examiner for these hearings. We're at the hearing room for the Department of Mineral Resources, Oil and Gas Division, and it is 9 a.m. On the docket, the following matters will be continued or dismissed. Case number 32110, continued. Case number 32211, continued. Case number 32648, continued to Friday. Case number 32652, dismissed. Case number 32653, dismissed. Case number 32656, dismissed. Case number 32662, dismissed. Case number 32663, continued. Case number 32664, continued. Case number 32685, dismissed. Case number 32461, dismissed. Case number 32477, dismissed. Case number 32394, continued to this Friday. Case number 31928, continued. Case number 31929, continued. Case number 31930, continued. Case number 31977, continued. Case number 32377, continued. Case number 32301, continued. Case number 32378, continued. Case number 32586, continued. Case number 32587, continued. Case number 32588, continued. Case number 32593, dismissed. Case number 31960, continued. Case number 31966, continued. Case number 31967, continued. Case number 31968, continued. Case number 31969, continued. Case number 32004, continued. The administrative docket starts on page 8 with case number 32667 and goes through case number 32004 on the supplement. These cases will be heard in the next room. Michael Zish. Audio recordings of the cases in the administrative docket will be placed on the Oil and Gas website by the end of the week. If you wish to appear on one of the matters in the administrative docket, please appear in the next room. If there is opposition to the matter, will be brought back into this hearing room to be heard, and your statements and evidence will be taken. We're actually going to jump ahead and begin with moving to case number 32666. Application of Petra Hunt LLC in accordance with North Dakota Century Code 3808041C to retroactively and prospectively allocate production of oil and gas from the USA 153-96-13A-24-1HS well drilled and completed on the spacing unit for the Charleston Bakken pool described as sections 13 and 24, Township 153 North, Range 96 West, and sections 18 and 19, Township 153 North, Range 93 West, McKenzie County, North Dakota, Charleston and Keene fields in the following proportionate manner: 25% section 13, 25% section 14, 25% section 18, and 25% section 19. And in order to allocate oil and gas production among spacing units to protect the correlative rights of all owners, including those in the overlap base spacing unit in the Charleston Bakken pool described as sections 19 and 20, Township 153 North, Range 95 West, to further proportionally allocate the 25% of production attributable to section 19 to section 20, resulting in 12.5% of production from the USA well allocated to section 19 and 12.5% allocated to section 20, and to modify the affected spacing and pooling orders to the extent necessary to accomplish the allocation of oil and gas production described above, or granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Petra Hunt LLC. Mr. Examiner, I have two witnesses I intend to call today. They're here present at the table with me. Mr. Mike Dewald and Mr. Jason Stengel.
Okay, why don't we get all the appearances out of the way to start? Anyone else appearing?
Jonathan Garris.
On behalf?
Law firm 1314 23rd Street South, Fargo, North Dakota. I represent three different trusts that are referenced as the Garris Family Trust in our response.
Okay. Will you be calling any witnesses?
No witnesses intended at the present time.
Thank you, Mr. Examiner. Lawrence Bender, P.O. Box 1854, Bismarck, North Dakota, appearing in this matter, case number 32666, on behalf of Continental Resources, Inc. With respect to a question you're likely to ask me about whether we're going to call any witnesses, first of all, you may notice that we filed our notice of appearance yesterday, noticing our opposition to the case. It's our understanding, based on an email that was sent out by your office a number of months ago, that would automatically push the case until Friday. So as a result of that, we indicated that we would have our witnesses called in person. Since the case is going forward today, we can't have our witnesses here in person. They will be appearing by telephone. Also, at this time, we respectfully request that this matter be continued until the regularly scheduled April docket. As you know, this is in essence a remand from the North Dakota Supreme Court, in which the North Dakota Supreme Court ruled that the Industrial Commission has the authority to do what Petro Hunt is requesting in this matter, but remanded the case because of notice. And we don't believe that Petro Hunt proceeded with proper notice. If you look at their application and the certificate of service, they gave notice to one party. They gave notice to Jonathan T. Garris, Garris Law Firm. Continental Resources, if this case is allowed to go forward today, will demonstrate that it has an interest in the lands that will be diluted as a result of the request of Petro Hunt, and it was not provided notice. Continental took an active role in this matter when it went to the North Dakota Supreme Court. The North Dakota Supreme Court made it abundantly clear that notice was required, and Continental Resources was not provided with notice. So in that regard, we request that the matter be continued until the regularly scheduled April hearings.
Any comment, Attorney Mann?
Yes, Your Honor, or Mr. Hearing Examiner. I would dispute that notice wasn't given or was not properly given. And I guess I would dispute sort of Mr. Bender's interpretation of that Garris Trust case. The Supreme Court in that case addressed notice, but nowhere in there did it indicate in any way, shape, or form that notice, like by personal service or by mail, anything like that was required. Thousands of spacing units have been established. Pooling orders have been, done through publication. In 380811, the legislature has given the authority to the Industrial Commission to, at their election, provide notice by publication. That's the way it's always been done, by publication, and that's never been determined by the Supreme Court to be insufficient. So notice was proper in this case, was appropriate, whether or not, Continental, bothered to look at the publication or, the dockets. That's, I guess, up to them. But I would dispute that there's any issue whatsoever with notice in this case. And Petro Hunt has its witnesses here. One of our witnesses came up from Dallas, so I think it's most appropriate to go forward with the case as scheduled.
Okay. So you oppose the request for continuance?
We would oppose the continuance.
Okay. Attorney Garris, any response?
We believe that the continuance is appropriate.
You do?
Yes. And we don't have any problem with it being extended into April.
Okay. I'm going to rule right now. The request for continuance is denied, and the request for telephonic testimony is denied. And I'm going to read you North Dakota Administrative Code 43-02-0388.2, entitled Hearing Participants by Telephone. In any hearing, the Commission may, at its option, allow telephonic communication of witnesses and interested parties. This procedure shall be as follows, jumping to subsection 2. Telephonic communication of an interested party, which in this case would be Continental, will only be considered if said party notifies the applicant and the Commission in writing at least 3 business days prior to the hearing date. Such notice shall include the subject hearing, the name and telephone number of the interested party, and the name and telephone number of the interested party's attorney or representative that will be present at the hearing. Attorney Bender, you can appear, but your witnesses will not be allowed to testify by telephone.
May I just briefly respond?
Sure.
The Commission also has a policy that if there is an objection to a case, it gets pushed to a Friday hearing. And if that had happened in this case, we made our objection yesterday, and if the Commission were to follow through with its policy that if there's an objection to a case, it be pushed off until the Friday, we will have our witnesses here in person. But you put us in an awkward situation. First of all, not you, but we've been put in an awkward situation of not being provided notice. And then we filed our notice of appearance yesterday, indicating our objection, thinking the Commission would go follow through its policy to push the case off until Friday. And as we indicated in our notice of appearance, we would have our witnesses here in person. But now we're being forced to go forward today, not get a continuance until April, and requiring our witnesses to appear in person, which is just impossible. So I state that for the record.
Your objection is noted. My ruling stands, and we can continue. I will call your first witness.
Your Honor,
Oh, I'm sorry.
we would question two things. I looked at the administrative record yesterday, and I did not see any kind of a referral from the Industrial Commission to you to serve as the examiner in this case. And I'm wondering if there is a referral from the Industrial Commission asking that you serve, and what questions you are being posed to exist under.
I believe there's a record that I'm certified as a hearing examiner for the Industrial Commission.
Right, but there is no referral from the Industrial Commission to exercise its jurisdiction through you. There should be some kind of a document signed by the three individuals who are on the Industrial Commission appointing you for this particular case and to perform a specific function and identify what questions of law and fact that you are supposed to derive from this application.
Okay.
And that was one of the things that you are aware of because you were the attorney representing the Industrial Commission in the Garris Family Trust case. So you know that's an issue that it was non-existent in the other case, and I find it to be non-existent here too.
Okay. Your objection, comment, what have you, is noted. I believe I've been properly appointed as hearing examiner, so I would proceed as hearing examiner in this case.
Okay, then we would question the standing of Petro Hunt to make any kind of a presentation until they establish that they are in fact a real party in interest as a result of an ownership interest in the minerals in Section 19 or in Section 20 of this application.
Okay, these are all arguments that were, I believe, you raised in your response to the application or something to that effect.
Well, we want to make sure that the
I'm going to allow briefing after this hearing, and so therefore you can re-raise those arguments in your briefing after this hearing.
Okay, can we ask that Petro Hunt identify now the interest in real property or real property interest, such as a mineral interest in sections 19 and 20, that they are asserting any right to go forward with? Because Petro Hunt is actually the operator of a well in a different section or different spacing unit that's been pooled in the past, and under the terms of both of those orders, that if there's any kind of modification of those prior existing rules, that spacing order and that pooling order is terminated. So how are they in a position where they can do anything to affect 19 and 20, which are in fact in a different spacing unit, and which they have no operator rights? I believe it's Corridor Oasis that are exercising those functions. And contrary to what Mr. Bender had indicated, the Supreme Court did not allow any application such as this because they are making no effort to modify the size of the spacing units, which is a statutory component that is necessary for the Industrial Commission to exercise its jurisdiction as it relates to spacing order. There's nothing being requested except a rehash of what has already been rejected because it has not basis in any statute or in the existing orders that forbid it. Both orders requiring that mandatorily the real property interests in each spacing order get their proportionate share of all production from any production in that spacing unit.
Okay.
Can't be given to someplace else.
These are all arguments that are more appropriate for the post-hearing briefs. I'm going to allow Petro Hunt to proceed, and I'll call you first witness. Okay. Mr. DeWall, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do. Mike, can I have you, excuse me, have you state your name, tell us by whom you're employed and what capacity, and then give us your business address.
Mike Dewald, employed by Petro Hunt. I'm a senior landman. Address is P.O. Box 935, Bismarck, North Dakota 58502.
And Mike, have you previously testified before this commission?
I have.
And have you had your qualifications received as that of an expert in land matters?
Yes, I have.
Okay. And are you familiar with the land matters that are associated with the overlapping spacing unit for the USA 15396 13A 24 1HS well? And Mike, just for convenience, I think going forward, I'll just reference that particular well as the USA well, if that's okay?
Yes.
Okay. And are you also familiar with the land matters that are associated with the with underlying spacing unit consisting of sections 19 and 20, Township 153 North, Range 95 West.
Yes.
Okay. I'd move that the testimony of Mr. Dewalt be received as that of an expert in this case.
Any objection?
None.
No objection.
Motion granted.
Mike, I'd like to start by briefly discussing some background leading up to Petro-Hunt's filing of the application in this case. And if you could just start by telling us a little bit about that USA well.
Yeah, so that USA 1HS well was drilled in fall of 2019. And this is a lease line well consisting of an overlapping spacing unit, 2560 spacing unit consisting of section 1324 of 153.96 and section 18 and 19 of 153.95. In that section 19 that is within that 2560 spacing unit is part of a base 1280 spacing unit of section 19 and 20. And that section 19 and 20 are pooled per NDC order 13922 and per prior directive from the NDIC, and to protect correlative rights, Petro-Hunt has been allocating production from the USA.
Objection. Lack of foundation.
Overruled.
Has been allocating production from the USA 1HS to both section 19 and 20. And Petro-Hunt previously received order number 33453 that affirmed this allocation of production, but this order was ultimately terminated by the North Dakota Supreme Court for procedural issues.
Okay. So, Mike, are you familiar then with that previous NDIC case? It was case 29902 that resulted in that order 33453 relating to allocation of production for the USA well?
Yes.
Okay. And then, so it's your understanding that the order required allocation of production from that USA well attributable to section 19 to also be proportionately shared with section 20?
Yeah, that's correct.
Okay. And had Petro-Hunt sought the order in that case to protect the correlative rights of all owners?
Yes.
Okay. And you're familiar with the recent Supreme Court, the Garris Trust case versus NDIC 2026 ND 25?
Yes, I am.
Okay. And you're aware that as part of that case, the Supreme Court had ordered that Order 33453 be vacated?
Yes.
Okay. And is it Petro-Hunt's position that production from the USA well that's attributable to Section 19, that still must be allocated proportionately to the owners in Section 20 to protect the correlative rights of all owners?
Yes.
Okay. And is that why Petro-Hunt has filed this application requesting that the Commission exercise its statutory authority?
Objection, Your Honor. I know we allow a lot of leading, but this is getting a little bit carried away.
Overruled.
So is that the intent of Petro-Hunt to file this application to exercise, asking the Commission to exercise that authority under 380804.1c to allocate production among the spacing units and proportionally from 19 to 20?
Yes, that's correct.
Okay. Let's go ahead and take a look at what's marked as exhibit number 1. And Mike, can I have you take a look at that and identify the USA well for us on there and the overlapping spacing unit for that well?
Yes, so on Exhibit 1, the USA 1HS well is identified with the dashed red line. And then the overlapping 2560 spacing unit is outlined in blue. That is section 13, 24, 18, and 19. And this exhibit also identifies the base spacing units that consist of that. Section 13, 24 is 1280. Section 18 would be a 640. And section 19 would be a 1280 spacing unit that's also been pooled.
Okay. So you're saying section 19 that's within the overlapping spacing unit is also part of a pre-existing laydown 1280 acre spacing unit with section 20?
Yep.
And you indicated that spacing unit had been pooled by order of the Commission?
That is correct.
Okay. And was that order 13922?
Yes.
Are you familiar with that order at all?
Yes, I am.
You know, does that order contain a provision providing that all owners of interests shall recover or receive without unnecessary expense their just and equitable share of production from said spacing unit in the proportion as their interest may appear in the
Same
spacing unit?
objection.
Overruled.
Yes.
Okay. So prior to establishment of the overlapping spacing unit, would all of the production from anywhere in sections 19 and 20 have been shared proportionately with all of the owners anywhere within section 19 and 20?
Yes, they would.
Okay. And prior to completion of the USA well, was all of the oil and gas produced from the setback area of 19 on the west half through the wells on that spacing unit shared proportionately with section 20?
Yes.
Okay. Now, Mike, if a new well were to be drilled that produces some of those same reserves from that setback area along the west half of section 19, but the revenue from that production attributable to section 19 is then cut off and not shared with section 20, would that protect the correlative rights of all owners?
No, it would not.
Calls for a legal conclusion. Overruled.
No, it would not. Setbacks were put in place to prevent the immediate drainage from outside the
Objection, non-responsive. Overruled.
Setbacks were put in place to prevent the immediate drainage from outside the spacing unit. A lease line well would accelerate the production of the reserves in that lease line, and if that production is not shared with Section 20, we would not be protecting correlative rights.
Okay. So, along those lines, if the production from the lease line well is not shared with section 20, would all of the owners of interest in 19 and 20 receive their just and equitable share of production from that base spacing unit?
Now, one more time, please.
Yeah. So, if that lease line well production, if that's not shared with section 20, would all of the owners of interests in 19 and 20 recover their just and equitable share of production?
Objection calls for a legal conclusion. Overruled.
Yeah, if it's not shared with Section 20, you wouldn't protect correlative rights.
Okay. And would section 19 then be recovering more than its equitable share?
Yes, correct.
And would section 20 recover less?
Yep.
Okay. Just briefly, if you can look, you've got the Clevmoen Trust well identified on that exhibit. Can you briefly walk us through how production should be allocated from that well in order to protect correlative rights?
Yeah, so again, on Exhibit 1, the Clevmoen Trust 1H well is identified on the east side of your map with a dashed red line. In the spacing unit for that well, Section 20, 21, 28, 29, 32, and 33, and the allocation of production is shared 1/6 to sections 21, 28, 33, 29, and 22. And a 1/6 goes to that base spacing unit that was pooled in section 19 and 20, and that 1/6 is partially reduced to 1/12 for section 19 and 1/12 for section 20. So section 19 would be allocated production, so that section 19 pooled unit would be allocated production from both the USA 1HS well and the Clevmoen Trust 1HS well. And this protects the correlative rights of the Garris Trust as the 1HS wells take oil from that base 1280 1920 that's pool that would otherwise been produced from those base 1280 wells.
Okay. So let's go ahead and look at what we've got marked as exhibit number 2. Using that exhibit, can you walk us through and explain how production should be allocated from that USA well in order to protect the correlative rights of all owners?
Yes, so the allocation of production for the USA 1HS well is kind of depicted on the top of this exhibit. The overlapping 2560 is identified, outlined in green, and the base 1280 that's pooled together of 1920 is identified, outlined in red. And the allocation of production is 25% to section 13, 25% to section 24, 25% to section 18, and then that 25% gets allocated to that base 1920 that's pooled. That's proportionally reduced to 12.5% to section 19, 12.5% to section 20. And then in the middle of that exhibit, I identified the spacing and pooling orders for both the overlapping 2560 and the base 1280. And then the bottom of the exhibit shows the calculation for that allocation of production.
And Mike, is that how production has been allocated from the USA well since first production?
Yes, it is.
And I think you testified earlier, so in order to protect correlative rights of all owners as required by statute, it's your position that you must continue to allocate that proportionate share of production attributable to 19 to section 20?
That is correct.
Okay. Mike, I want to ask you, is Petrohunt asking the commission to change the spacing unit for the USA well?
No, we're not.
Okay. In your opinion, would it be appropriate to change the spacing unit for the USA well?
No, I don't believe it would be. If you change the spacing unit, you'd basically be diluting the other sections, and you would section 20 would receive a higher interest and take away from the other sections.
Let me ask you to take a look at what's marked as exhibit number 3. Does that show what the impact would be if the spacing unit was expanded to pick up section 20?
Yeah, so exhibit 3 would highlight how it would look like if the spacing unit was expanded. You would basically go from a 2560 to a 3200. So the allocation reduction would be 1/5 to every section, which is 20%. And that would dilute sections 13, 18, and 24 and unjustly increase the allocation reductions to section 19 and 20.
Okay. So the owners in section 18 and the owners in section 13 and 24, they don't have that same relationship with section 19 and 20 with respect to the base spacing unit and the impact of the USA well on those pre-existing wells.
That is correct.
So if they don't have that same impact, that same issue, would it be fair to expand the size of the spacing unit and then dilute their interests by 5%?
No, that wouldn't be protecting the correlative rights.
And then would that result in the owners in section 20, if you did that, receiving more than their just and equitable share of production?
Yes, it would.
And would that be protective of correlative rights?
No.
That's all further questions I have for Mr. DeWald at this time, and I would offer exhibits 1 through 3.
Any objections to the exhibits?
No objection. No objection.
Exhibits are admitted. Any cross, Attorney Garris?
Yes. Mr. DeWald, you and I have never met before.
I don't believe so.
Did I ever appear in any time when you were testifying?
No.
Mr. DeWald, in this particular case, you've been hired by Petro Hunt.
Yeah, I'm an employee by Petro Hunt.
Okay. So how long has that relationship existed?
I've worked for Petro Hunt for 16 years.
In that capacity, are you familiar with the property rights of Petro Hunt?
Yes.
What property rights do they have in section 19 that's involved with this application?
I don't have that in front of me. I don't know if we have an interest in 19 or not.
Are you aware of any leases involving section 19 that are owned or operated or conducted or exercised by Petro Hunt as it relates to section 19?
I don't off the top, but I can supplement the record.
Would the same thing be true for section 20?
Yes.
Are you aware of any real property interests that are special to Petro Hunt that they are trying to protect in any application relating to sections 18 and 19?
We're trying to protect the correlative rights of all owners.
Okay. And Petro Hunt is talking about the USA well. Is actually they were the operator of that well. They put it in
Yes,
2019.
roughly.
And are you aware that that well is one of 2 authorized wells for the 4 square mile spacing unit?
Yes.
So is the USA well an authorized well for the 1,280 acre laydown, now called the base spacing unit?
I guess it wouldn't be.
It would not be, correct?
Well,
The USA well is an authorized well for a 4 square mile spacing unit hitting the Bakken,
yeah, that's correct.
and it is not an authorized well of the 12 wells that are authorized for the laydown 1280 spacing unit, correct?
Technically.
Technically or actually?
Well, probably.
If there's 12 wells that are authorized to develop the 1,280 acre spacing unit, and the USA well is not one of them, and does Petro Hunt have any leases with any property owners, mineral owners, in sections 19 and 20 that would allow the oil operator to give the money that's produced by an authorized well within an authorized spacing unit that's been pooled to another property owner?
Can you repeat the question?
Are you aware of any lease in the possession of Petro Hunt relating to sections 19 and 20 of the 1,280 acre spacing unit, which has been pooled, that would authorize the money produced by any of the 12 authorized wells be given to any other landowner in another spacing unit.
Like I said, I could supplement the record with Petrohunt's ownership in section 19 and 20.
Okay.
I
I would ask that you do that, and also, as part of that supplement, identify any lease or document that allows the operators of the USA well to give the money from production of that authorized well to anybody in a different spacing unit.
well, since it's taking oil from the base spacing unit of 19 and 20, we would have to allocate that production to section 20 to protect the
It- It's not taking it well from the base spacing unit. It may be taking it from the owners of section 19. But USA well is not an authorized well of the 1,280 acre laydown, is it? Are you aware of the statute that requires that the oil operator pay to the owners of the mineral interest in the spacing unit their proportionate share of all production from all authorized wells within that spacing unit?
Yes.
So wouldn't your statute or wouldn't your proposed allocation be violative of that statute, which is found at 380808 subsection 1?
No, I don't believe so.
In what way can somebody who is outside the spacing unit receive those monies?
Mr. Examiner, I'll object to the extent that this is calling for a legal conclusion, and these are legal issues that will be briefed, by both sides after the fact.
I'm going to overrule, but Attorney Garris, please keep your questioning. Do not duplicate what you're probably going to propose in your post-hearing brief, if possible.
Thank you, Your Honor. If the standard is set forth in 380808, which says, quote, each such pooling order must be made after notice and hearing and must be upon terms and conditions that are just and reasonable, and that afford to the owner of each tract or interest in the spacing unit the opportunity to recover or receive without unnecessary expense that owner's just and equitable share. What portion of that language from the statute would authorize the distribution to somebody outside the spacing unit?
Well, there's an initial spacing unit which was pooled, established in section 19 and 20, and since the USA 1HS well would be accelerating the recovery of oil within that lease line, which is part of that section 19 and 20.
Sir, where in
Reallocating
the original order, the 13922 order done in 2009, does it say that?
Well, I think the language of all owners of the interest shall recover or receive without the necessary expense their just and equitable share of production from said spacing unit. Production as their interest may appear in the spacing unit. I think that covers it because you are producing oil from that USA 1HS well from that section 19 and 20 spacing unit that was pooled per order 13920.
And my question, sir, is in the 2009 by year order 13922, which provides that all owners of interest shall recover or receive without not unnecessary expense their just and equitable share of production from said spacing unit in the proportion as their interest may appear in the spacing unit. Does it talk about the USA well, which was not drilled until 10 years thereafter?
Mr. Hearing Examiner, I'll object. He already answered that question, and again, we're sort of venturing into kind of legal arguments that are going to be addressed in the briefing.
It isn't, because he's identifying that the source of his justification in the spacing order, pooling order 13922, when there's nothing in there that says that.
Okay. I'm going to overrule it, but please be advised, I believe there is some duplication going, but we'll allow you to answer it if you can.
I essentially would have the same answer.
Say it again.
I would have the same answer.
Manson.
Same answer.
Same answer to what?
The question.
Where in the order does that appear when the well was drilled 10 years later?
You're talking about
You,
13.9.22?
you're right.
Yeah, my answer would be the same.
And your answer means what? Where in the order does it talk about a well that's drilled 10 years later?
Well, I guess it doesn't address the well 10 years later.
It doesn't address it, does it? Were you aware that Petro Hunt, for the first 3 years of production from the USA well, actually sent out a division order to the Garrett Family Trust that provided for them to get all of their property, and that there was an amended division order in 2022 that provided for a change in the distribution? What caused that change? Because there was 2 or 3 years of payment at the correct level, and then a change to a different, smaller amount.
I'm not sure what happened with that.
Okay? But you indicated you were aware, and that it's always been done since 2019. That's incorrect, isn't it?
Well, if there was a mistake, then we corrected it. And then,
Well, in 2019, if you check your records, the Garris Family Trust each received 100% of what they were entitled to.
well, there,
And in 2022, I believe there was a due division order that prompted this the earlier fight when Petro Hunt wasn't going to honor what they had done for 2.5 years before.
well, if,
Objection asked and answered.
Overruled.
Are you willing to supplement the record with the payments to the Garrett Family Trust starting from the first day of production to
Well, I mean,
establish that your testimony was false?
I mean, I'll object to that. I mean, it's up to Petro Hunt what evidence they want to put on to support their case. To the extent that the commission thinks additional information is necessary, we'll reply to any requests from the commission. But Mr. Garris doesn't get to dictate what information Petro Hunt does or doesn't provide in this case.
We would expect that they would present truthful testimony, Your Honor.
And I object to that. There's
Right, that's sustained. The implication there is unfair. The commission will decide what's appropriate for supplementing in this case.
Were you aware that when 13922 was created as a pooling order, it was on the basis of the spacing order for the same 1,280 acre spacing unit?
yeah, it would be for that spacing there.
And were you aware that at that time that the application of Petro Hunt was, excuse me, or whoever it was that was asking for that pooling order in 2009, that the North Dakota Industrial Commission made the decision that that spacing unit was in fact done to prevent waste and protect relative rights?
Yes.
What relative rights aren't being protected by honoring that order of 13922 going back to 2009?
I'm not arguing that it's not protecting correlative rights.
So if it was protecting correlative rights, what changed?
Nothing's changed.
So when they passed the order 3,323 in 2019 and created the 4 square mile spacing unit, which was pooled. See that? You recognize that was done in 2019?
Which order?
The order number 30323.
No. Yes. Okay.
Say it again.
I'm following you. Yes.
Okay. That application was also granted by the North Dakota Industrial Commission in order to prevent waste and protect relative rights, wasn't it?
Yes.
And that's the same order that recognized that the owners shall receive their proportion as their interest may appear in the spacing unit. Correct?
Yes.
And that's in the spacing unit as their quote, as their interest may appear in the spacing unit, unquote.
Yeah. And 19 and 20 were pooled together, so.
But we're now talking about the later one, the 4 square miles.
Yeah, no, I understand.
And so the USA well was drilled as a part of that 4 square mile spacing unit,
Yes.
which was properly pooled.
Yes.
And what relative rights have been changed after the 2019 that caused Petro Hunt to believe that the relative rights of all property owners weren't being protected?
Well, we needed to allocate production in section 20 to protect their correlative rights because that USA 1HS well was accelerating the drainage of oil along that lease line that would otherwise been produced
Well, isn't that
by the
another
base 1280 wells in section 19 and 20.
isn't that all another way of saying that the Industrial Commission screwed up when they established the first pooling order in 2009?
I wouldn't say that, no.
Well, because if it protected all the relative rights and nothing changed, and they did the same thing in 2019 and they protected relative rights, what changed thereafter? And what changed that would cause the Garris Law Firm or Garris Family Trust not to receive the same monies that they received for the first 2.5 years of the existence of the USA well?
No, we feel what we're doing, we're protecting correlative rights.
I have no further questions.
Attorney Bender, any cross?
Just a few questions. Good morning, Mr. DeWalt. May I call you Mike?
Sure.
Okay, Mike. Let's go to Exhibit 2. I think you covered this, but I just want to get it clear in my mind. You have on this exhibit depicted the overlapping spacing unit as well as the underlying base spacing unit. Is that correct?
Yes.
Okay. And what you're proposing, or what Petro Hunt is proposing, is that allocation of production, of proceeds of production from the USA well will go 25% to Section 13, is that correct?
Yes.
25% to 18, is that correct?
Yes. 25%
to Section 24, is that correct?
Correct.
And then the 25% that would be typically allocated to a 1/4 of a 2560 acre spacing unit would be split between Section 19, 12.5%, correct?
Yes.
And Section 20, 12.5%.
Correct.
So in essence, and if you don't like these words, just tell me what your words you would use. You're diluting what would typically go to Section 19 to Section 20 as well, 12.5% to each. Is that correct?
Well, I wouldn't call it diluting. I would call it properly allocating the production to 19 to also to 20.
But one of these sections in the 2560 will not get 25%. It'll get 12.5%. Is that correct?
That is correct.
Okay, and you covered this kind of quickly, and so I don't know that I got all the information, but I think you said you do not believe that Petro Hunt owns a leasehold interest in Section 19. Is that correct?
I would have to check.
Okay, you don't know here as you said today. You did not mention a few moments ago that you thought Petro Hunt did not own anything in Section 19.
I would have to check. I don't know.
Okay, and what about Section 20? What does Petro Hunt own in Section 20?
I would have to look at that. I don't know as I sit here.
Are there owners other than Petro Hunt that own in Section 19?
Yes,
Does Continental Resources own in Section 19?
I believe they do.
And as far as, are there other working interest owners besides Continental that own in Section 19?
Yes.
Okay. And there are mineral interest owners that own in Section 19 that do not own in Section 20. Is that correct?
I would believe so, yes.
Okay. And the Garris Trust owns in Section 19.
Yes.
And I'm looking at the Petro Hunt application, and it says that there's a certificate of service attached here, and listed on the certificate of service is John F. T. Garris, Garris Law Firm, DeMars Office Park, etc., etc. The Garris Law Firm was provided notice of this application. Is that correct?
Yes.
And why were they provided notice of the application? Is it because they owned an interest in Section 19?
I believe they're provided notice based off the NDIC's rules.
Off of the what?
NDIC rules.
But you don't know what those rules are?
I don't know the exact notice rules, but we're following what we're supposed to be doing.
Okay, so it's your testimony here today that the Garris Law Firm was given notice as a result of the rules and regulations of the commission.
I'm going to object. I mean, this is a legal argument with respect to whether notice was appropriate or not, and whether it was given in accordance with what the commission requires. We addressed that up front, that it was required. 380811, provides how notice can be provided in these cases, and it's at the election of the commission, can be done through publication. So again, I think notice was appropriate in this case. And again, it is a legal argument that can and will be addressed.
I'm going to allow him to answer. If he knows, he can answer. If he doesn't know, he doesn't have to answer. Or say I don't know.
Do you want to ask it again?
You need to. You want me to repeat the question? Why was Jonathan T. Garris Law Firm provided notice of this matter?
Well, we think we provided proper notice through publication, and the rest of your answer, I'm not sure.
Can you repeat the answer again? I'm not sure that I followed.
We provided notice was given per publication, and as why they specifically received the notice, I'm not sure.
So, do you believe that the case may be is that John T. Garris was provided notice because he represented a party that owned an interest in Section 19?
Yes.
Okay. And if John T. Garris, as counsel for parties that owned an interest in Section 19, was provided notice, why weren't other owners in Section 19 provided notice?
They were provided notice through publication.
Okay. So you picked out one party and gave them notice by personal service, but you didn't give any of the other parties notice by personal service. Is that right?
That is correct, but we provided everybody else notice by public notification.
Okay. Is it possible that Petro Hunt owns a larger interest in Section 20 than in Section 19?
I wouldn't know.
Okay. Did you provide ownership information as to who the owners were in Section 19 and Section 20 in the original application, or didn't you testify in that case?
I didn't testify.
Did you go back and review the exhibits that were presented in that case?
I did. I don't believe there was ownership given in that.
No further questions.
Before I go to the staff, Attorney Mann, you can redirect if you'd like.
I don't have any redirect.
Any questions from the staff?
I guess, does Petro Hunt plan to have engineering testimony, or is it
Yes,
all
we do.
land-related testimony? And is the Club Mullen well, has that been drilled already?
Yes. Yeah, it's been drilled. Yeah, we drilled that.
When was that drilled?
I don't have the date off the top of my head.
And the way that I guess you testified that you allocated the Club Mullen well to Section 19
Yes.
as well as 20, similar to how the USA 1 well was allocated. Is that
Yes.
Okay, that's all I have.
Before we jump into the next witness, I'm going to call
Yes.
it. Oh, I'm sorry.
Am I allowed to ask Garris questions too?
Sure.
So, have you been receiving payments for the Club Mullen well on your interest in Section 19 over the last however long?
I don't know. What has happened is, and I can represent, is that I got a letter from Petro Hunt proposing to do asking us to sign a division order relating to Section 19. And I wrote them a letter back saying we don't own any interest in Section 19. So don't talk to me about it. And that was prior to the decision of Garris Family Trust.
So you don't know if you've received any checks from the Clipmore well?
Well, to further add, after the Garris Family Trust, I wrote the same letter to Petro Hunt saying that here's a copy of the Garris firm opinion. We have received checks, but the Petro Hunt has not provided us with the information of production of what wells we are getting monies from, as required by law. And so we have received monies from Petro Hunt because we have a number of properties, but we do not know if it's from the Quevmone Trust.
Is that something that Petro Hunt could provide?
All the check stubs should have the wells are getting paid on, and we can provide that.
So does Petro Hunt issue a physical check, or
It does both.
so do you know if you've cashed the checks that have?
We cash checks that we receive, but we do not get the stubs indicating what wells it came from or how the monies were calculated, which is a violation of law. The last letter I wrote to Petro Hunt relating to this was, I think, about March 2nd of this year. But to the best of my knowledge, we would not, unless they're making payments a little faster than most oil companies, we would not have received any check except for possibly this month from us.
So I guess I would ask Petro Hunt, is it something you're able to provide as proof that those checks have been issued from the Clipmore well to?
I know we set up division orders, and I don't know if the payments for that well have gone out already, but the decks have been set up.
I guess I don't even know when the well was drilled, so I would need that as well.
Okay.
Drilled, completed, first production. That's information.
In fact, Your Honor, sir, I do have a copy of the last letter I sent off, which was on February 6th to Petro Hunt.
Well, I'll keep the record open after this hearing, so you can submit that as part of everything you submit. As I was saying, at this time, I'm going to take a 10-minute break now before we jump into the next witness. Okay, we are back on the record, and I'll now call Petro Hunt's second witness. Mr. Stengel, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, I do.
Jason, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
I'm Jason Stengel. I'm employed by Petro Hunt LLC as a reservoir engineer. My business address is 2101 Cedar Springs Road, Suite 600, Dallas, Texas 75201.
And Jason, have you previously testified before the commission?
Yes,
Have you had your qualifications received as that of an expert in engineering-related matters?
yes,
Okay. Are you familiar with the engineering matters that are associated with production from the USA well?
yes,
Okay. I'd move the testimony of Mr. Stengel be received as that of an expert.
Any objection?
None.
No objection.
Motion granted.
Jason, are you familiar with that previous case 29902 that resulted in order 33453 on allocation of production from the USA well?
yes,
And did you testify in that case?
I did.
Okay. And was it your position there that in order to protect the correlative rights of all owners, including those in Section 20, that production from the USA well needed to be allocated proportionally from Section 19 to Section 20?
Yes,
Okay. And is it your understanding that ultimately that order 33453 that did require allocation of production from the USA well attributable to Section 19 to go to the owners in Section 20 proportionately?
yes,
And was that allocation method in order to ensure that the correlative rights of all owners would be protected?
Production calls for legal conclusion.
Overruled.
yes.
Okay. Is your position changed in any way from the initial hearing in that case 29902 till now?
No, it hasn't.
So is it still your position that in order to protect the correlative rights of all owners, that production from the USA well attributable to 19 must still be shared proportionately with Section 20?
Leading. It's for legal question and leading.
Overruled.
Okay. Let's go ahead and take a look at exhibit number 4 then, Jason. Can you identify the USA well for us?
Yes, my Exhibit 4 is a map of the area. The grid in the background is section, township, and range. All the Middle Bakken and Three Forks wellbores are highlighted on the map, and they're also labeled. In the middle of the map, you can see some wellbores that are highlighted yellow. The north-south yellow well is the USA 1HS lease line well. The east-west highlighted yellow wells are the seven base unit wells in 19 and 20.
Okay. And Jason, are those 7 base wells that you referenced on that 19 and 20, 1280, are those competing for some of the same reserves of oil and gas from the setback area 19 as the USA well?
Yes,
Okay. So prior to completion of that USA well, would the oil from that Section 19 setback area produced through those 7 wells, would that have been all shared proportionately by all owners in the spacing unit?
yes,
Okay. After completion of the USA well, would some of that oil from the setback area in the west half of 19 now be produced through the USA well?
yes, that's correct.
Okay. And if the USA well is now producing some of that oil from Section 19, that same oil would not be produced from those 7 wells and then laid on 1280, would it?
Yes,
Yes. So let me rephrase. So, like, if the oil from the setback area 19, if it was being produced from those 7 laydown wells previously, follow me, and now you drill the USA well, and that's producing some of that same oil, would the wells in that laydown 1280 be producing less oil?
that's correct. Yeah.
Okay. And if the USA well is now producing some of that oil from the Section 19 setback, and less oil is being produced from those laydown wells, let me rephrase that. Sorry. Okay, I'll ask you this. So, if they're competing for the same oil in that setback, section west half of Section 19's setback, would those laydown wells ultimately be producing less oil than they otherwise would if the USA well wasn't there.
That's correct. Yes.
So then, if that's the case, and you cut out the owners in Section 20 from the production from the USA well, will all of the owners in that base spacing unit recover their just and equitable share of production?
No.
Okay. Let's go ahead and discuss then a little bit further how you determine that the USA well and those 7 wells on that base spacing unit are competing for the same reserves. And it's probably easiest if I have you take a look what is marked as exhibit number 5. And if I can have you kind of walk us through what you're showing in these tables and how you determine from that that the wells are competing for the same reserves.
Yes, Exhibit 5 has 2 tables showed, one for well production, one for water production. It is a production rate comparison of the time period before the frac and the time period after the frac. In this case, I picked the time period of the previous 90 producing days and the post 90 producing days for each well. I'll start with the oil production table. You have the well, previous 90 producing days, BOPD, post 90 producing days, BOPD, and the percent change. I'll go ahead and read the first well and then the change for the remaining wells. The Lorraine Federal 1X20H produced 71 barrels of oil per day before the frac, 96 barrels of oil per day after the frac, for a change of 35%. The Norby Federal 1620H had an 18% change. The Wilson Federal 820H had a 10% change. The Norby Federal 920H was shut into this period. The Norby Federal 9X20HA had an 83% change. The Norby Federal 9X20HB had a negative 1% change. The Wilson Federal 1X20H had an 18% change. The total oil production for that unit in the previous 90 producing days was 382 barrels a day. And after the frac in the post 90 producing days was 475 barrels of oil per day for a 24% change. The water production table is just like the oil production table. You have the well, the previous 90 producing BWPD, the post 90 producing BWPD, and of course the percent change. I'll read the first well and the change for the remainder. The Lorraine Federal 1X20H produced 20 barrels of water per day before the frac, 110 barrels of water per day after the frac for 450% change. The Norby Federal 1620H had a negative 9% change. The Norby Federal 920H had a 181% change. Norby Federal 920 was shut in. Norby Federal 9X20HA had a 42% change. The Norby Federal 9X20HB had a 40% change. The Wilson Federal 1X20H had a 0% change. The total water production for the unit in the 90 previous producing days was 128 barrels of water per day. After the frac in the 90 post-producing days, it was 281 barrels of water per day for 120% change. The observed changes in oil and water production post-frac demonstrate that the USA 1HS lease line well and the base unit wells are producing from a common source of supply and competing for the same reserves. Generally, a significant shift in production rates, whether positive or negative, within a parent well.
Your Honor, if he's going to read, perhaps we mark it as an exhibit and introduce it.
No, he can continue.
Following the stimulation of a child well serves as definitive evidence of inter-well interference and confirms that the wells are producing from a common source. Regarding the water production data, output in the base unit wells increased by 120%, a figure that far exceeds the 24% increase in observed oil production. This massive surge in water is a direct result of the fracture treatment performed in the USA 1HS lease line well, communicating with the base unit wells and introducing excess water into the system. This specific water signature is common across the basin and serves evidence that the USA 1HS lease line well is hydraulically connected to the base unit wells. Had the USA 1HS lease line well not been hydraulically tied to the base unit wells, no such increase in water production would have occurred. The hydraulic connection is further evidenced by the oil production data. The base unit wells experience an average 24% increase in oil production as a direct consequence of the USA 1HS lease line frac. By effectively tying the reservoirs together, the stimulation allowed the base unit wells to access the higher pressure reservoir of the USA 1HS lease line well. This pressure support is what drove the localized increase in oil output. Taken together, these rate changes confirm physical and pressure-based link between the USA 1HS lease line well and the base unit wells. Because the reservoirs are now hydraulically connected and interfering with one another, they are producing from a common source of supply and competing for the same reserves.
Your Honor, I oppose a rejection, non-responsive, move to strike.
Overruled.
Okay. So, a lot of information in there, Jason. But as you kind of took us through the table, did you indicated that kind of based on that data, is it your opinion that there is communication between the 7 wells in that laydown spacing unit and the USA well?
Yes.
Okay. And did you indicate that there was a hydraulic connection, between those wells?
Yes.
Okay. And with that hydraulic connection and kind of interference with one another, the USA well and those 7 wells in the laydown are now producing from the same common source of supply. Is that correct?
That's correct.
And are they competing for the same reserves in that western half of Section 19 setback?
Yes.
Okay. So, in your opinion, then, if you just arbitrarily cut off the owners in Section 20 from any of that production from the USA well, what's the impact going to be on their correlative rights, the owners in Section 20?
If you cut out the owners in Section 20, that would harm their correlative rights.
Okay. I have no further questions at this time. I would offer Exhibits 4 and 5.
Any objections?
No objections. No objection.
Exhibits are admitted. Attorney Garrison, any cross?
Yes, Mr. Stengel, you did testify in the earlier proceedings, did you not?
That's correct.
Your Honor, at this time, we would move to ask the court to take judicial notice of the entire file of the prior proceedings that resulted in the Supreme Court case of Garris Family Trust.
Any objection or comment?
No objection. I think that would be appropriate.
Okay, the record from the previous case will be included in this record.
Mr. Stengel, when you testified in that earlier proceeding, you testified 4 different times that the USA well does not drain Section 20, correct?
It is not draining reserves from Section 20.
It does not drain Section 20, does it?
It does not.
When the North Dakota Industrial Commission in Order Number 3323 in 2019 created the 4 square mile spacing unit that the USA well is an authorized well of, they did that to protect relative rights, didn't they?
Yes.
So didn't they, in fact, in Order Number 30323 at paragraph 9 say, this application should be granted in order to prevent waste and protect relative rights?
Yes.
That was one of their findings.
Yes.
And now you're telling us that the USA well is actually hurting correlative rights in Section 20 that's not drained? And that's what's causing this application?
The owners in Section 20 are pulled in to wells that, excuse me, let me start over. The owners in Section 20 own wells that are being harmed by the USA 1HS lease line well.
So did Petro Hunt shut down the USA well because of this harm?
No, Petro Hunt allocated appropriately to all the owners involved.
Where in the statute does it allow for the Petro Hunt to give it to Section 20 when it's not in the spacing unit for which USA well is an authorized well?
I mean, I'm going to object that calls for a legal conclusion. I mean, I know the answer to it, but I'm not the witness, and where that can be addressed through, the briefing.
I'm going to allow it. If he knows, he can answer. Sure. And you can address it in a redirect if you want. You can answer.
I can't answer regarding the statute.
You can't or you won't.
I don't know the answer.
If the statute requires that the people in the spacing unit receive their just and proportionate share, then doesn't that mean that you can't give it to somebody outside the spacing unit?
We're trying to protect the interest of the owners in the wells.
Well, who has jurisdiction to do that? Because the North Dakota Industrial Commission is already to protect the correlative rights, provided that all of the owners in the spacing unit are supposed to get their proportionate share. And you're giving part of it away.
The owners in the spacing unit that involve Section 19 and 20 are being protected because the base unit is getting allocated their share.
I'm not talking about the 12 acre
lease line
spacing unit. In the 4 square mile spacing unit that was created in 2019, and the polling order that resulted said that the North Dakota Industrial Commission was doing that to protect correlative rights. So what correlative rights were violated by the creation of a authorized well in the 4 square mile spacing unit?
I don't believe correlative rights were violated.
Then, and in the 2019 order, it also directed that all of the landowners in the spacing unit get their just share. So that means that Petro Hunt can't give it to somebody outside the spacing unit, can they?
I'm discussing the technical aspects of why owners in the laydown wells should be allocated production from the USA 1HS lease line well.
But that's subject to a statute that says that all of the owners in the spacing unit get their proportionate just share. And that doesn't mean anything about giving it away by the Petro Hunt or somebody acting on behalf of Petro Hunt. Let me ask you this way. In your job as a petroleum reservoir engineer, have you ever seen anything in Petro Hunt's possession that authorized it to give Garris Family Trust monies to somebody outside of that spacing unit for which the USA well was authorized to produce?
As an engineer, I'm demonstrating that the base unit wells are being
That's not the
harmed by
question
the
I'm
USA
asking.
1HS lease line well.
As an engineer working for Petro Hunt, have you ever seen anything in Petro Hunt's possession that authorized Garris Family Trust monies to be given to somebody outside of their spacing unit?
I don't work in that department that handles the money.
Well, would any department that you work for, have you ever seen that?
In my engineering world, I have not dealt with that
And
type of.
if the order of 2019 compels the property owners within the spacing unit, how, as an engineer, do you have the right to disregard their property rights protected by Constitution and statutes?
Are you saying the property owners who own interest in the wells in the base unit 19 and 20 are not being harmed?
That's what I'm saying.
Okay, I'm
But the USA well, that's in a different spacing unit.
testifying that the USA 1HS lease line well is actively harming the wells in sections 19 and 20, and we are trying to protect the correlative rights of all the owners in those wells.
Then perhaps Petro Hunt should shut it down if it's harming 7 other wells.
Why would we? We
Because you're
have
hurting
pulled
7 other
everybody in appropriately into the new lease line well to protect the correlative rights.
What correlative rights weren't protected in 2019 when the North Dakota Industrial Commission issued its order saying that they were protecting the correlative rights, and at the same time demanding that only owners within that 4 square mile proper spacing unit, which was being pooled, receive their proportionate share. What correlative rights are you trying to protect?
The owners of the wells within section 19 and 20,
The oil company or the mineral owners?
all of the owners involved,
Okay, then why don't you shut down the USA well?
because they're being properly protected.
What's that?
Because they're being properly protected.
Well, then if they're being properly protected, then you don't have any problem. You aren't.
I don't think we have a problem right now.
Well, if you're paying money to somebody who's not in the spacing unit, don't the people who are not being paid the correct amount of money have a problem?
I think we're properly protecting everyone's correlative rights.
Don't they have a right to their money?
If we're properly protecting correlative rights,
Okay,
they're
correlative rights
receiving
are
all
you
the rights to the money they are owed.
What correlative right are you protecting by giving people's money away without their permission and without contract?
I'm demonstrating that the base laydown wells have been harmed by the USA lease line well, and that is why we have allocated the production as we have.
What correlative right are you protecting?
Can you repeat the question?
What correlative right are you protecting?
In relation to what?
Disregard the order issued in 2019.
Can you read the order in 2019?
Sure. Paragraph 9 of the findings. This application should be granted in order to prevent waste and protect relative rights. It is therefore ordered all oil and gas interest in a spacing unit described as all of sections 13 and 24, Township 153 North, Range 96 West, and sections 18 and 19, Township 153 North, Range 95 West, Charlton, Walken Pool, Mackenzie County, North Dakota, are hereby pooled for the development and operation of the spacing unit. This pooling shall not determine or establish the specific acreage to be attributed to separately owned tracts or specific interest attributed to separately owned interest in such tracts or stratigraphic intervals. The operator of the wells for the spacing unit shall conduct operations in a manner so as to protect correlative rights of all interested parties. 4. All owners of interest shall recover or receive, without unnecessary expense, their just and equitable share of production from the spacing unit in the proportion as their interest may appear in the spacing unit. Just stopping at that point in time. Don't you see that they have already determined that they have protected the correlative rights, and all of the money are supposed to go to people in the spacing unit?
There are all of the owners in section 19 and 20 have an ownership of wells in section 19. And if you harm the wells in section 19, you're harming all of the owners in section 19 and 20.
Well, then if it's harming, if it's a harmful action to do the USA well, why didn't Petro Hunt shut it down?
Because we're properly allocating the production
There's
to
nothing
the
to do with
owners
allocation.
within
You are
all.
doing harm. Shouldn't you stop doing harm?
We aren't harming anybody.
Well, you indicated that USA Well was harming the 7 wells.
And we're properly allocating the production.
Well,
as
it's
a
not a
result.
question of you proper allocating. There's nothing in the statutes or the Constitution that allows that the North Dakota Industrial Commission has any right.
Yes, I believe he's trying to answer your question.
Where in that order does it say allocate?
Ask and answer. I object.
Sustained. You can ask your next question.
Were you aware that under the order of 2019, in the event the size of the spacing unit pooled hereunder is modified by the Commission, this order shall terminate as of the date of such order?
Again, I object. Asking for a legal conclusion.
If he knows, he can answer.
Can you repeat the question?
Were you aware that paragraph 7 of the orders of the North Dakota Industrial Commission reads, quote, in the event the size of the spacing unit pooled herein is modified by the Commission, this order shall terminate as of the date of such order?
No, you read it. What's your question?
Were you aware that that's what order number 7 was?
Well, excuse me. Order number 7.
Order number 7 of order number 3327.
3327.
Excuse me, 3323. The 2019 order of the Commission had 9 component parts of the order. Order number 7 of that 2019 order provided, quote, in the event the size of the spacing unit pooled herein is modified by the Commission, this order shall terminate as of the date of such order.
And what about it?
Are you aware of that order?
I have not explicitly read that.
Did the fact that you are not making any application to modify the size of the spacing unit, is that predicated upon that order that says that this order would terminate if you did?
I'm just demonstrating why the base unit wells are being harmed by the USA 1HS lease line well, and why all the owners in section 19 and 20 should be pulled in for technical reasons.
And are you aware that paragraph 8 of those orders said this order is limited to pooling the spacing unit described above for the development and operation of such spacing unit by the horizontal wells authorized for such spacing unit by order of the commission.
Objection.
This
has been
order does
answered.
not
Sustained.
modify.
Sustained.
It has not been asked and answered.
Sustained.
For what reason?
Because it was asked and answered in several different ways.
Well, I don't think I've ever got
Okay.
paragraph 8.
Okay, you can ask your next question.
Did when you recognize that the relative rights of the 7 oil companies owning the wells in the laydown 1,280 acre spacing, did Petro Hunt communicate with any of those oil company operators and say that we are adversely affecting your wells? Did you report that to those other oil companies?
What oil companies? With
The oil operators for the 7 wells in the laydown 1,280 acre spacing unit, which had been pulled. Did Petro Hunt notify those oil companies that and admit that their USA well was harming their production in the 7 wells that were authorized for the 1,280 acre spacing unit?
When we drilled and completed the well, I'm not intimately familiar with the process, but we, had a spacing hearing, pulling hearing, filed the permits and whatnot to get to the point where we, drill and complete, produce the well. At that point in time, if somebody had a disagreement with the well, they had plenty of opportunity to object to the well.
That's not the question. Did Petro Hunt, once it realized that it was adversely impacting the 7 oil wells that had been drilled in the 1,280 acre laydown spacing, did they put those oil companies on notice that we, Petro Hunt, have screwed up and we're violating your rights?
I'm going to object. There's no testimony that Petro Hunt ever screwed up on anything. That's not in the record and it's not correct.
Sustained.
Would you look into your files to find out if Petro Hunt notified the 7 operators of the wells in the 1,280 acre spacing unit to advise them of any recognized adverse impact upon their wells caused by the USA well?
There is a single operator in that unit. It's Oasis.
Is that Oasis?
We drilled the well to adequately produce the reserves from the reservoir. We have allocated the well to we allocated the well to all the owners that are involved in the spacing unit to protect the correlative rights.
And what did you do to correct the oil company's losses?
We included them in their ownership in the USA 1HS lease line well.
Were you aware that the Clevbone Trust was not originally designed as a lease line well?
Excuse me?
Were you aware that the Clevbone Trust well was not identified to the North Dakota Industrial School and its Industrial Commission?
Mr. Examiner, I'm going to object. I mean, there's no foundation for this question. I don't know, how Mr. Garris thinks he knows what the intention was, for the Clevbone Trust well.
Well, I can tell you, I looked at the well file for the Clevbone Trust, and I have a copy of a document filed on, it's dated July 3rd, 23, which identifies the proposed course for the well, and it would not be a lease line well.
You can submit that as a supplement to the record if you'd like, but I'm going to sustain the objection.
I have no further questions.
Attorney Bender, any cross?
Just a few questions. Is it Mr. Stingley?
Stengel.
Stingle. Okay, thank you. May I just call you Jason?
Yes.
Okay, thank you, Jason. You testified at the previous hearing, I believe you indicated 29902. That was back in March of 2023. Is that correct?
Yes.
And looking at your exhibit 4 here today, that looks very similar or identical to the exhibit that you presented in that case, E1. Is that correct?
That's correct.
Okay. And if I go to exhibit 5, is that similar to your exhibit E2 that you presented in 2023, except you have now added water production?
That's correct.
And there's been a lot of testimony, both on direct and on cross, about having, I think the words you used, as being harmed, that the wells in section 19 and 20 are being harmed by the USA well. Is that a fair statement of your testimony?
Yes.
Okay. And if I look at your exhibit 5 closely, and particularly the last column, if I follow the Lorraine Federal 1X-20H well across the line, and it says percentage of change, and it says 35%, that looks like from 90 days previous production to 90 days post-production, there was an increase. Is that how I read that? Am I reading that correctly?
Correct.
Okay. And if I go to the next well, and I'll try to move this along quickly, the Norby well, that's an 18% increase in production, correct?
Yeah.
And the Wilson is a 10% increase in production.
Yes.
Correct. And there's an NA. I assume that means not applicable. Is that correct?
The well was shut in.
Okay. And then the next Norby well, there's a change of 83% positive. Is that correct?
Yes.
And then the next Norby well, the 9X20HB, that's a negative of 1%. Is that correct?
Yes.
And then the Wilson Federal 1X-20H, that's an increase of 18%. Is that correct?
Yes.
So you total that up to a 24% positive increase in production in the 90 days post-drilling of USA versus pre-drilling of the USA. Is that correct?
Yes.
So how is that a harm of Section 19 and 20 if those 7 wells have increased in production?
It's demonstrating that the wells are competing or producing from a common source of supply, thus producing from the same reservoir. And thus the USA lease line well and the base unit wells will compete for the same reserves.
Okay. And where did the oil, in your view as a reservoir engineer or petroleum engineer, where did the oil come from that resulted in the increase in production that you indicate on your exhibit 5? Did it come from section 19 or did it come from section 20?
Section 19.
Okay. And what was the date of first production on the USA well?
It was September 2020.
And what's the vintage of first production on the 7 wells in the spacing unit?
You had 3 completed in late 2010, 2 completed in 2012, and 2 completed in 2014.
And even though you had production going back as far as 2010, you elected to only go back 90 days prior to production on the USA well in doing your calculations that you have on your exhibit 5. Is that correct? Is that correct?
Yes. Yes.
Okay. And you also then do calculations of post production for only 90 days again. Is that correct?
Yes.
And you indicated that the USA well came online in 2020. Is that correct?
Yes.
So you have over 5 years of production that you could have shown us on your exhibit. Is that correct?
There's much more production than I displayed.
And as a reservoir engineer, don't you get a more accurate depiction of what a well is capable of doing, or if it's been harmed by offsetting wells or improved by offsetting wells, the more production you look at?
Generally speaking, more data can give a better picture.
So why didn't you provide the commission with more data?
I did not think it was necessary to demonstrate that a hydraulic connection was created.
Is that all you're trying to demonstrate here today, is hydraulic connection, or are you trying to demonstrate that there was a harm to these wells that has to be compensated to Section 19?
I'm demonstrating that the wells are hydraulically connected, thus producing from a common source of supply and competing for the same reserves. And because the wells are communicating with each other, all of the owners and all of the wells need to be protected.
So you're really not looking at it in terms of harms, you're looking at it in terms of hydrologic connection.
They're competing for the same reserves, so the base wells have the potential to be harmed.
But you've already testified that the additional reserves that were recovered from these 7 wells, all that oil came from Section 19. Is that correct?
The owners in Section 20 are pulled together with the owners in Section 19 and have wells that are producing from Section 19.
That wasn't my question. You've testified, have you not, that the increase in oil production that you have depicted on your Exhibit 5 comes from Section 19?
Yes.
No further questions.
Any redirect, Attorney Matt?
Yeah, a little bit. Jason, I think there's maybe some misunderstanding, with Mr. Garris with respect to your testimony on when you discussed harm to the wells on that laydown spacing unit. When you're talking about harm, you don't mean like physical harm to their wells, correct?
I mean, they're competing for the same reserves.
So the harm would be that if oil gets produced from the USA well and doesn't then go to those laydown wells, that's the potential harm.
Correct.
Okay. And then you kind of touched on it with Mr. Bender as well. There is that communication you've testified to and competition, for those same reserves. In your Exhibit 5, that is essentially a snapshot in time, essentially, right?
Correct.
Okay, so while that shows, some positive impact at that particular point in time, a little bit of a bump maybe to those laydown wells in that base unit, eventually over time, because of that competition and communication, that could change, and the USA well would produce more and those other wells would produce less.
Yes, they're competing for the same reserves. So if the USA lease line were to produce a barrel, it's possible that the base unit wells would not.
Okay. And Mr. Garris asked you sort of what authority, like PetroHunt has. And again, I objected, said it was a legal question, but are you familiar with the statute NDCC 380804(1)(c)?
I have not explicitly read it.
Okay. Well, that statute provides in part that gives the NDIC the authority to allocate production from any field, pool, or area. Would you agree with that?
Yes.
And in the application, that is the authority under which PetroHunt is asking the commission to allocate production. Is that correct?
I believe so.
Okay. And again, that statute was recently addressed by the Supreme Court in the Garris Trust case, and there is a statement. I'll read it to you. NDIC therefore had legal authority to allocate oil and gas production among spacing units. So is that essentially what PetroHunt is asking the commission to do here, to allocate a portion of the production from 19, which is in the overlapping spacing unit, also part of that base spacing unit? You're asking to allocate that production to that base spacing unit, the owners in Section 20?
Yes.
Okay. And that's the authority under which PetroHunt is seeking the relief?
Yes.
Okay. That is all the questions I have for Mr. Stengel at this time. I'd offer exhibits 4 and 5 if I haven't already done that.
I think I admitted them. Yep,
So,
they're all set. Any questions from the staff?
Jason, just bear with me a little bit. Unfortunately, my computer's rebooting right now randomly. But I want to try to clarify, make sure the record is clear what the expectation or the expectation of what the existing wells are doing with respect to production. So at the time when the laydown 1280s was established and those wells that were drilled on that laydown 1280 were drilled and began producing, they were pooled to share oil between the two sections in that spacing unit, sections 19 and 20, correct? Yes. I realize you're not the operator of that well, but as the operator of plenty of 1,280 acre spacing units, I think it's fair to ask, any operator wouldn't be able to definitively state which section a given barrel of oil came off of. When you're talking about a 1,280 acre or 2 mile long well drilled across two sections, you can't tell which of the two sections that barrel came from. Is that a fair statement?
For the most part, we don't collect that type of data.
I mean, let me go a little further. Without doing something along the lines of adding chemical or radioactive tracers to the well, you wouldn't be able to tell which barrel came off of what area.
That's correct.
So when it comes to a subsequent well, a subsequent spacing unit that was established, being the 4 mile spacing unit, and that well that is now drilled on the lease line spacing unit, incorporating the 4 sections, you're not able to say which section any given barrel has come off of. It can come off of any one of the 4 sections included in the spacing unit, correct?
That's correct.
That's
That's the production of that USA
correct.
1HWS.
Yep.
Yeah.
The expectation, though, is that approximately 25% of 25% of that well's production is coming off of each of the 4 sections that were included in its spacing unit, correct?
Yes.
So you have section 30 that's been included in that, section 19, my apologies, that's been included in that 4 mile lease line spacing unit. And some of the production is from the USA well is coming off of section 19. Roughly 25% is what's expected.
Correct.
And when it comes to section 19 and the laydown wells that are drilled on the western portion of 19, those are the wells that are in competition for oil with the USA well on section 19.
Correct.
But it's not possible for anyone, probably, without a whole bunch of chemical tracer or radioactive tracer, and even then, probably, to definitively state what portion of oil is coming off of 19 versus 24 versus 13 versus 18.
I guess we could not definitively say exactly where the barrels came from.
So in this, and likewise, you couldn't say which, where any of the given barrels of oil coming off of 19, or coming off of 19 and 20 wells in 19 and 20. You couldn't say where those barrels are coming from definitively. Could you repeat that?
So again, same kind of question. The wells drilled across 19 and 20, you wouldn't be able to state whether any given barrel came off of 19 or came off of 20.
That's correct. Yeah.
Your expectation, however, is that because 19 has wells that are sharing to 20, they are entitled to hydrocarbons on section 19. So the owners in 19 and 20, because of that pooling that was established, are entitled to hydrocarbons coming off of 19 and 20.
Correct.
This new well on the 2560 is also producing some portion of hydrocarbons from section 19.
Correct.
The allocation that you're requesting is an attempt, my understanding based on testimony at least, is an attempt to make sure that the portion of oil that's coming off of 19, or the expected proportion of oil that's coming off of 19 from the USA well, gets attributed to 19. But because of the existing wells on 19 and 20, the expectation that you're laying forth here is that because those barrels on 19 could be produced by either the laydown spacing unit wells or this 2560 section line well, because those barrels could come off of either, the expectation or what you're presenting here is that the portion of the oil that is presumed to come off of 19 should also be shared with those owners in section 20, splitting that 25% that is expected to be coming off of 19 to the owners of 19 and 20 because of the potential reduction of barrels that could be expected from the laydowns on 19 and 20.
Correct.
The exhibit you showed, your exhibit 5, shows an uptick rather than a reduction in production off of those existing wells.
Yes.
Do you know when you were doing that exhibit? I guess how long has the USA well been producing?
Since September 2020.
So when you were doing this exhibit, did you notice if they have since seemed to indicate any reduction in productivity, or have they maintained, I guess, the new curve or the new decline curve that was established after the frac?
That's a complicated answer. If you can look back at my exhibit 4, you have the 7 laydown base unit wells. Surrounding that unit are 3 separate lease line wells that have been drilled after the 7 base unit wells. Those 3 lease line wells have all impacted the base unit wells. It's tough to tell exactly over a long-term period of data what's having more impact, but the data definitively shows all 3 lease line wells are impacting the base unit wells. They all just exhibited a change in oil production before and after the frac, and they all exhibited a big spike in water production compared to before and after the frac. Even the Cleveland Trust lease line well that just came on in August 2025, the same signature. So it's tough to tell with longer term data what is happening to the base unit attributed to one specific lease line well, because there's so much interference down there.
When the lease line spacing unit was established, Do you know if during that spacing unit discussion or during that case, if how Petro Hunt planned to allocate the proceeds from that, or allocate the payments from that well, if that was discussed during that spacing unit case?
I don't recall.
Again, your testimony, just to at least try to clarify, because I think it got a little muddy between cross reference or cross and the rest of the test. Or, sorry, the rest of the questioning from the case. Your opinion is that if a barrel of oil that could come off of 19 is produced by the USA well and only paid to section 19, your belief is that the owners in 20 are harmed.
Yes.
And if the same barrel of oil is produced, and let me back up. Can I ask you to elaborate on why they are harmed if it's only attributed to section 19?
Because if a barrel went to the USA 1HS lease line well rather than to the base unit wells, which it could have gone to the base unit wells, and you cut out the owners of section 20, that then that barrel, if it went to the USA lease line well, the owners of section 20 would not get a percent of their proceeds. If it went to the base unit wells, the owners would get a percent of those proceeds. To protect the owners, I'm sorry, but I'll simplify it a little further. The lease line well and the base unit wells are competing for the same reserves on the source supply. They're hydraulically connected. If the lease line well produces a barrel that could have been produced by the base unit wells, all of the owners in those base unit wells need to be protected. And if you arbitrarily cut out 20, then they're not being protected from reserves they could have produced.
And you made the argument on your Exhibit 3 that if 20 was included in the lease line spacing unit as a whole, and attributed 20% or 1/5 of the total production from the lease line well or the USA well.
That was Mike's exhibit.
Oh, apologies. I guess it's Petro Hunt exhibit, but I guess I'm going to ask this question. If 20% of the oil coming off of the USA well were attributed to 20 because it was included in the spacing unit, what is the impact to the owners on 18, 13, and 24?
Would you like me to answer that?
Maybe if you could take a stab on it, as far as what I'm trying to ask, I guess, and I'll clarify. If that barrel that came off of 19 were split 5 ways instead of 4 ways, it's not. I think everyone's testimony, everyone's position seems to agree that that barrel of oil came off of potentially 19, or at least one of the wells, or at least one of the sections in the stand-up spacing unit, and did not come off of 20 directly. I think everyone seems to be in agreement with that. I don't know if I'm testifying here. I'm just making a general statement. So in the hypothetical that a portion of the proceeds from the USA came off of 19, if Section 20 were included in the spacing unit on the whole, and it received 1/5, do you feel that that payment, or would that 1/5 proportionate share be protective of the other owners in 18, 13, and 24?
No, that would be harming the other owners. It would unfairly dilute the other owners. The lease line well, the spacing for the unit lease line well is those 4 sections, and that's where the oil is coming from. Section 19 is special because Section 19 is the owners of the wells in Section 19 extend beyond Section 19, and that's why you have to protect those owners because they own wells that extend beyond Section 19. But the oil itself is coming from those 4 sections and should be divvied up accordingly, 25% to each section.
Okay, sorry for partially interrupting there. So your proposed allocation is an attempt to make sure that neither the parties on 18, 13, and 24, or the parties over in 20, in either case, you're trying to make sure that neither set of owners is harmed by the production that's coming off of the USA well, and potentially impacting the wells, the laydown wells on 19 and 20.
That's correct.
I may have another couple questions in a moment.
Mr. Garris, you testified that the Cleveland well is not a lease line well, and so I'm a little worried about that. Can you provide the document that shows that it is not a lease line well as part of, I guess, the supplement? But
I can't.
do you know for sure that the Cleveland well is not a lease line well?
Here's what I know about it, is that I've written 2 letters to them saying I don't own any land in Section 20.
Yeah.
I'm not entitled to anything. But when I go to the lease, or the well file, I have a page that I photocopied out. And I can't tell you what page this is because it's,
So-
it was from the Cleveland Trust well file that I watched actually yesterday. And I can supply this, and it shows that it's located approximately, would it be about half of 20 acres? I don't know how many thousand feet that is to the west of the lease line. I know that the map shows it as a lease line where the directional well is drilled, but according to the well proposal, that's not what was proposed to them. And I would submit that for your examination right now.
Any objection to this?
Well, a little bit, I guess. Taking a single page from a well file could be very misleading. I mean, to the extent that you're going to include that, I think you would need to incorporate into the record the entirety of the well file to see, if plans have changed or things like that. So,
Okay, let's go that route. Let's supplement the record with the
Yeah.
filing. Okay, so we won't do any reviewing right now then.
And that whole Cleveland Trust file, well file, will be made part of this record.
and I guess I should probably clarify. I'm assuming that he's talking about the Club Mullen Trust 15395 20A 32 1HS
Correct.
well, which is the lease line well.
Correct.
Okay.
So I guess this is for Mr. Garris and Petro Hunt, but the oil coming off the Cleveland Trust well is being paid out. The royalties are being paid out somehow. Do you know if you're receiving royalties off the Cleveland Trust well, and can you provide those documents?
I can provide you copies of a letter that I did on December 29, 2025, which was reaction to a proposed division order. And I basically said, we don't own anything in Section 20. And then on February 6, I again wrote to indicate that Petro Hunt has rejected our proposal. They ignored me in terms of what the statutes say. And then after that, the Garris Law Firm Trust is, if I am receiving money from the Clevmone Trust, I don't know it because they would have been sending checks perhaps in January or February of this year, but we only get the check. We don't get the statement of which wells they're coming from, even though the law requires that we get that information.
I guess Petro Hunt is the operator of the Clevmone Trust well. Is that correct, Mr. Noel?
Yeah, that's correct.
And could you guys supply data showing how that well has been paid out?
Yes.
And if I would propose that the Petro Hunt provide the Garris Family Trust payouts for both wells, the USA well and the Clevmone Trust, from all time, from 2019 up until today.
Any objection to that? Petro Hunt?
I assume we probably already have provided that data on the USA well. I mean, you need,
No, we can provide that.
Yeah, if the Garris Trust is willing to include its payment information as part of the record, then
No problem.
Jason, you testified that oil comes from Section 19 from the USA well. Yet you show an increase in production from all wells that span across both Section 19 and 20. How do you know that that oil stops at the section line that's coming from Section 20 into 19? And how would you tell that? Meaning that, the base spacing unit wells, those that are in Section 19 and 20, cross both Section 19 and 20. And so how would you know, when you testified, you indicated that it's coming from 19, but those wells span both Section 19 and 20. So I guess how do you know that the oil stops at the oil that's being produced from the well bores in Section 19 that come to where's the surface? The surface looks like it's in Section 20 for those stops at the section line. Or does it not stop at the section line? Is it,
We know the USA 1HS lease line well, the fracture will be contained within, the 4 square miles of its spacing unit. The delta attributed to the laydown wells is a result of the work, drilling, and completion of the USA 1HS lease line well. Yeah, we did not pump any tracers, so we could not definitively tell you, but just given the general knowledge of the hydraulics of the work, the reason there is a change in the base unit wells was a result of the USA 1HS lease line well, and the USA 1HS lease line well is more or less draining disproportionate share from Section 19.
mm-hmm. Do the wells that are producing in the base spacing unit, do they produce from both Section 19 and Section 20?
The wells in the base unit wells produce from Section 19 and 20.
Okay. I'm struggling with the word harm, just so everybody's aware. When I look at this production, it actually increases it because reservoir pressure is occurring. A repressurization of the reservoir is occurring. So how do you see harm occurring when the average increase is 24% from the first 90 days? I guess of course I don't have any long-term data, just the first 90 days that you show. Is that harm, or is that a positive impact?
The wells demonstrated a positive impact, but any sort of large change, both positive and negative, suggests that these wells are produced from a common source of supply and competing for the same barrels in the same reservoir.
Mm-hmm.
So there's this competition. We can't know where the barrels are going to go, but we know both wells are competing for those barrels. And so harm in the sense is that hey, these wells can compete for these barrels, and so all the owners of the wells should be protected.
Jason, can you or have you provided similar engineering exercise on the Clip Moen well that you did on Exhibit 5, or if you haven't, could you?
I could, yes.
Okay. And then, I guess this question is for Continental Lawrence. Does Continental believe the production from the base spacing unit well stops at the section line between section 19 and section 20?
Can you repeat the question?
So you have a base spacing unit, a 1,280 acre spacing unit, section 19 and section 20. It includes both of those sections. And does Continental believe, from an engineering perspective, that the production stops at the section line on that USA 1 well for section 19 and 20? So essentially, the production in those base spacing unit wells, all of those 7 that I guess are shown on Exhibit 5, stops at the spacing line, at the section line between 19 and 20.
Respectfully, Mr. Director, I'm a lawyer. I'm not an engineer. We weren't allowed to call an engineer today, so I can't answer that question.
Okay, well, I gotta look at my questions. I think I'm good, thanks.
Rich? No.
Okay, a couple things. So, I'm sorry. Go ahead.
Mr. Examiner, if I may just briefly redirect with Mr. Stengel.
Sure.
Okay. Mr. Stengel, I wanted to ask you, when I asked you initially about your qualifications, you'd indicated that you'd previously testified before the commission.
That's correct.
And have you done so on multiple occasions?
Yes.
And you, in fact, did previously testify in case 29902, which is sort of the predecessor to this case relating to allocation. Is that correct?
Yes.
Okay. And Mr. Garris asked that the record in that case be incorporated, and Petrohunt did not object. I just want to briefly touch on some of the statements or conclusions that NDIC had in that case. And Mr. Stengel, is it your experience that the Industrial Commission has significant experience and expertise in making determinations with respect to correlative rights?
Yes.
Okay. I want to take a look at some statements that they made and conclusions in the order in that case. And one of the things that they said was
I'm
that
going to object. This is way beyond what was covered in testimony from the commission staff. I mean, now he's going to have him reading out of a commission
it's not.
Okay, I'm going to allow it, and I'm going to give you an opportunity to cross on his redirect.
Sure. So just a couple things I want to look at what the commission determined and concluded with respect to allocation of production from the USA well previously. They stated that all 1,208 acre spacing unit wells.
Are we talking about the order that was determined to be irregular by the Supreme
Can
Court?
just let him ask the question.
Yes. For different reason. So anyway, what they stated was that all 1,280 acre spacing unit wells. I'm looking at paragraph 36, page 8, and halfway down on 36, where it says all 1,280 acre spacing unit wells in the sections 19 and 20 base spacing unit will be affected by the lease line 2,560 acre spacing unit well. Would you agree with that?
Yes.
Okay. And then they went on to state that since both negative and positive impacts in section 19 are shared by section 20, the allocation of production from the lease line USA well should be shared as well. Would you agree with that?
Yes.
And is that consistent with your testimony
It is.
and the data that you found?
Yes.
Okay. And just a couple more things. If you go down to the next paragraph, paragraph 37, sentence down in that, the commission further determined and concluded if production from the lease line horizontal well is not allocated to section 20, section 20's correlative rights would be harmed. Would you agree with that conclusion that the commission made?
Yes.
Okay. Are you aware of any technical information or data that disputes that?
No.
Okay. And finally, they said Section 19 would receive all benefits from the lease line horizontal well, while Section 20 would not. And Section 20 would suffer all the harm the lease line horizontal well could cause to production of the adjacent wells in the base spacing unit. Would you agree with that statement of the commission?
Yes,
And is that consistent with what you've been testifying to today?
it is.
Okay, I have no further questions.
Okay, I will allow cross limited to that redirect. Attorney Garris.
You recognize that is the USA well an authorized well for the 1280 laydown?
The USA well is authorized via the section line 2560 spacing unit.
So it is not an authorized well for the 1280 laydown, is it?
It is not.
And is the 1280 laydown authorized 12 wells under the rules?
I don't know.
If I were to submit to you that is the number of wells that are authorized, 12 wells, and only 7 of them are being used,
Okay.
why hasn't the operator prepared and used one of his authorized wells to parallel the lease line well if he felt it was offensive?
I can't speak for the operator.
And has the operator of the 1280 acre spacing posed any objection whatsoever to the operation of his 1280 acre spacing unit?
Could you repeat the question?
He has the ability, does he not, to drill a parallel well if he felt oil was being drained improperly from his 1280 acre spacing unit?
I can't speak for them.
It's just probabilities. If he's authorized 12 wells, he's got 5 more that he can drill. Obviously, as long as he stays 150 feet away from the section line, he can drill another parallel line that would be running perpendicular to the 7 existing, couldn't he?
I can't speak for them.
What is the new correlative right that has been wronged by the creation of the USA well? Mr. Mann has gotten you to say what the North Dakota Industrial Commission may have said in their dismissed order. But what is the correlative right that is being protected that wasn't recognized when the spacing units were originally created?
We drilled a new well.
Say that again.
A new well was drilled.
But they knew that there was going to be 2 wells drilled, and that was done consistent with the pre-existing spacing units correlative rights that were protected by an order that's 10 years old. So it's a new correlative right that was wronged by the actual drilling of the USA well.
I don't believe anybody's being harmed right now. We drilled a new well and we pulled in all the appropriate owners.
Nobody's not being harmed, then they should leave the orders alone. Because we're not asking for any modification of these orders anyway. And the orders.
Which orders are you
require
talking about?
The 2009 order that's relating to the 180 acre spacing unit, and the 2560 that was done in 2019. Those 2 orders both say you pay it to the landowners in that spacing unit.
I'm testifying that the owners of the wells in section 19 extend past section 19. And to protect the owners of the wells in section 19, you have to pull in all of them, which includes owners in section 20.
All production from an authorized well for that spacing unit. Where are you getting the right to allocate money from an unauthorized well in that spacing unit? That is not in that spacing unit.
I'm gonna object. There's no unauthorized well. There's no foundation for that. I don't unauthorized well that.
I want to ask again, limit your cross to the redirect.
I have no further questions.
Attorney Bender?
I'll try to be very brief. Jason, you were asked let's strike that. If I go to your Exhibit 5, your Exhibit 5 indicates that there was a net 24% increase in production from the 7 wells that were drilled on the 1280 after the USA well was drilled. Is that correct?
Yes.
And that's the same information that you presented back in, I think, 2022 when this case was heard before the commission. Is that correct?
Yes.
And there's a lot more information out there. There's information back to 2010 when these wells on the 1280 were initially drilled. Is that correct?
Yes.
And there's been a lot of production information that's available since that case was heard. Is that correct?
Yes.
And you chose not to present that information. You took the same snapshot that you presented to the commission back in 2022 to support your case today, even though there was all this other information out there. Is that correct?
Yes.
No further questions.
Okay.
I'm gonna, I guess, ask if there's any opposition to the commission taking notice of or taking at least administrative notice of the production and completion records for the wells in the laydown 1280 and the USA well and any adjacent lease line spacing units that have been drilled to that laydown spacing unit 19 and 20.
Any opposition?
No objection from Petromont.
What time periods?
All the wells.
All time?
Yes.
No objection.
Attorney Bender, did you hear?
I'm sorry, I was talking to my client.
So I'm asking if there's any objection to the commission taking administrative notice of all of the existing wells in the laydown and any of the offsetting lease line spacing unit wells that have been drilled in the area, their production and completion information.
So basically, well files and production?
Correct.
No objection.
Okay.
Mr. Examiner, I was just advised by my client that our engineering witness can be on a plane and be here at 1:45.
Any objection, Attorney Mann?
Yeah, I would object. I mean, the hearing's done. I mean, I've got a number of other hearings for a number of other clients that, you know, I don't want them to have to be punished or miss their hearings or not have their cases heard on cases, you know, where they've got timing issues and things like that. So if, you know, the decision's been made, and I don't think it's appropriate to kind of punish those other applicants, you know, for them not having their witness prepared.
Okay, I'm gonna.
I'm going to object to the remark that our witness wasn't prepared. I mean, we didn't get notice, and that's the reason why he isn't here.
Your objection is noted. I need to discuss this with commission staff. We'll take a 5-minute break. Okay, we are back on the record. We're still on case number 32666, but it's my understanding that Continental has withdrawn its request for a personal appearance of a witness. So at this point in time,
May I just point out his
Yes.
he was unable to make the flight. Yeah.
that's fine. Yep. So to clean this up, we have a number of specific requests for supplemental exhibits. Is April 1st long enough to submit them? That's 1 week.
Just trying to see what they are.
And here's my position on that. I've asked for response post hearing briefing by April 10th, which Attorney Bender, I'll also extend that right to you.
Thank you.
If we extend the supplements to April 8th, that could be difficult to incorporate stuff into the briefing. So I think April 1st is better if we can do it.
I just want to look at my list and kind of reorient myself with what was being asked to make sure we can meet the time frame. I don't think there was anything in there that we couldn't get by April 1st. April 1st would be sufficient.
Okay. So the record will remain open in this case until April 1st for the specific requests. Now, anything outside of that that is submitted will be subject to objection by the parties and review by the commission. Then also, as I just said, we will accept post-hearing briefing on the issues until by the end of the day. We're expecting by the end of the day, April 10th. And like I said, that applies to Continental as well. And unless there's something further, that concludes our hearing for case number 32. I'm sorry, go ahead.
I did not testify, but I would like my testimony in the form of acclamation be regarded as my testimony as to our ownership of mineral interests in Section 19.
Everything you said today will be a part of the record.
Very good.
We have an objection that we'd like to present today, please.
Okay, let me reopen the record then. Please come up and state your name and what your interest is in this case.
Well, I can't. So my name is Matthew Berry. I'm a mineral right owner, and I'm here with an interest on property for my mother, Rebecca Kobatish. I just had oral surgery recently, so my speech is a little slurred. So my son's going to read my presentation for me. This is my son, Austin Berry. I've got something I'd like to say when he's done, so I'll resume that right now, please.
All right. Before I get started, I'd like to clarify for the record two spellings. First, the spelling of my grandmother's last name. It's Kobatish, Kobitisch. And my last name, which is Verity, Varady. Presentation to the North Dakota Industrial Commission regarding objection to operator conduct and emergency stay, Dunn County Block TR20A, TR20B, TR20C, TR20D, and TR28. Date March 25th, 2026. Subject 1, opening statement. Dual industry expert and the next generation. Commissioners, my name is Matthew Verity. I stand before you as a technical professional with a dual industry background rooted in forensic precision, systemic accountability, and corporate compliance. With me today is my son, Austin, representing the next generation of our family stewardship. I'm here representing my mother's interests, pursuant to a limited power of attorney so as to protect her mineral interests. Her name is Rebecca Kobatish, but she goes by Becky. I have prepared full copies of this statement and the supporting evidence of systemic bypass. These are available for the Commission's record and an additional copy for those others present today. The foundation of this claim. I am here today because my mother, Rebecca Kobatish, requested that I object to the issuance of any new permitting or amendments today on her behalf to protect her mineral estate. This land is our blood. My grandfather, Jack Kobatish, was born on this very homestead. When he eventually sold the surface to the Rice family, he did so with the explicit legal intent to retain 100% of the mineral rights for his children and grandchildren. I stand here to protect the unified interest of the four primary heirs of Jack's legacy, Rebecca, William, Michael, and Catherine. The conduct I have uncovered, the simultaneous mysterious dropping of wells for all four separate legal entities, is unlawful, according to the recent North Dakota precedent, and a direct violation of the United States. And a direct violation of the United States and North Dakota constitutions. My mother and others relating to this interest never received notice of previous proceedings relating to the same interest and have since been dropped from payment without any notice or explanation. I am including the recent Garris decision from the North Dakota Supreme Court, which addresses how this situation should be treated. Subject to ground 1, the burden of due diligence and unified bypass. Under North Dakota law, due diligence is the operator's #1 priority and mandatory burden. The fragmented evidence. I hold in my hands and brought copies for the Commission, division orders from 2017 and 2018, and non-consecutive pay stubs ranging from 2018 to the present day. These operators successfully located the four heirs, Rebecca, William, Michael, and Catherine, previously, yet active producing wells were dropped from the division orders while they kept every straw in my pool active and producing. These four interest holders were not provided notice of why their payments stopped or how their rights have been affected, while the operators continued to produce and make themselves money. The legal stinger. To lose four separate legal entities after years of successful payment is demonstrable bad faith bypass by the primary statutory duty. Under the doctrine of collateral estoppel, these operators are legally barred from denying they knew our identity because they delivered the division orders with their position of ownership, including the four heirs. Subject 3, Ground 2. The Garris precedent, an unconscionable hardship. This case is a mirror image of the Garris v. NDIC 2026 ND 25. These legal parallels are so precise that if this matter moves from this commission to a district court, we anticipate summary judgment before a district court. A decade of hardship. For years, these four heirs have endured systemic financial harm, while the operators enrich themselves. While these operators use super platforms to take every straw in the heirs pool and strain our reservoir, they systemically squeezed our family out of every rightful income. The human cost. This is not just a ledger error, it is a life and death risk. Their heir William is currently fighting cancer, and his descendant Nick is also facing terminal cancer. Simultaneously, their heir Michael is battling chronic pulmonary disorder. While these operators were losing our addresses and holding back millions in royalties, their heirs have been fighting for their lives without the financial protection of their grandfather, Jack intended for them. This bypass is not just illegal, it is unconscionable. My mother's checks were depleted by thousands to a staggering $200 while these operators were extracting millions from the soil Jack Cobbetish was born on. Subject 4, Ground 3, MFN violations in full production value. I am applying a forensic standard to remedy these fragmented records for all four parties. The Rice family meters, we have closely monitored the Rice family meters and surface activity. We know the exact flow rates and pressures being pulled from the common pool. There is millions in revenue owed on these wells from past production. The audit mandate. We demand an immediate global forensic audit for Rebecca, William, Michael, and Catherine to bridge the gaps in these non-consecutive stubs and identify the production volume and molecular grade of every straw in my pool from 2016 to the present, using the Rice meters as the baseline. More importantly for today, this commission cannot move forward under Garris because of the failures of notice and due process. Full production value. Because the operators are bad faith trespassers, we demand the full 100% production value of every barrel strained from our tracks, with zero deductions for their operating costs subject to the demanded audit. Subject 5. Emergency remedies. The treat of punitive judgment. Due to the systemic gross negligence displayed against this 100-year-old estate, we ask this commission to deny any further action relating to these units until these issues can be addressed. Garris applies here and would void any order issued by the commission if entered. It would be a waste of time and resources to approve anything today. Subject 6, closing statement. The operators found us in 17, they found us in 18. Due diligence is their burden, yet they chose to drop our wells and keep pocketing oil and gas revenues while keeping what is owed my mother and the other three heirs relating to these interests. We are the holders of a federal homestead legacy. The legal weight of the Garris case, if this commission does not issue an immediate stay today, it will further damage their heirs and likely other parties, resulting in additional litigation and hardship for the parties involved. Respectfully submitted, Matthew Barry, attorney in fact for Rebecca Cobbetish.
So I've been sitting here listening to Petro, especially with their testimony, and it's my understanding that Petro has 20 or a minimum of 9 pumps I counted on track 20 today, on record. You guys have pumps on track 20 and you're not paying me. So for that matter, after hearing that, I move for no boots on the ground, and I want physical proof, and I want to impose a $2,000 a day fine until I have my audit. The real test here is upon you, commissioners. Do you have the integrity and ethics to govern yourselves accordingly by the own laws you wrote? 10 pumps. My grandfather's blood is in every drop of that oil. He was born on that homestead, and they're stealing my family's legacy, and I'm appalled and disgusted. I'm a 10-year mining expert. I have so much experience in this. I know how assays are done. I know how it moves from the ground to the bank at the molecular level. I know what I'm missing. I'm missing tens, if not hundreds of millions of dollars from these guys. The time starts now. $2,000 a day must be imposed on these operators for their criminal trespass. I want physical proof, because if I catch them, I'm going to district court and I'm moving for treble damages, exemplary, and punitive damages. That's all I have to say. Govern yourselves accordingly. You wrote the laws.
Thank you. The request for a fine is denied.
You denied my request for what?
A fine?
Okay.
Any comment on?
My commissioner, that you've already been admonished by the Supreme Court under Garris, and I will further come after you as well.
Any comments on the letter or?
On a shutting today. No boots on the ground.
Okay.
Nobody works. Nobody pumps until I have proof.
Okay. Well, that request is also denied.
Okay. Supreme Court will smash you and admonish you again.
Okay. Enough, sir.
You really want to spend that kind of time and money?
Okay.
It's your decision. You're the one that gets admonished.
Thank you.
better do it right.
Thank you.
Govern yourselves accordingly.
Any
by
comment?
law, Commissioner.
Any comment? Okay. If there's an objection to the letter, please submit it in writing.
That's fine.
Is that okay? You have I'm giving you the right to comment.
See you in court. District Court, boys.
I guess
Go for it.
I don't know where track 20 is located, but it appears from the documentation that the interests are for a different operator, not Petrohunt, and that
I
the
asked for a global audit. That means everybody with a straw in my hole. I
Let
want
him
the numbers.
speak.
it appears that the tracks identified in the exhibit that were offered are located all in 147.95 section 30, which is nowhere near these lands, these sections. I believe it's in a different county. I think what's been asked and what's been offered is not relevant in any way, shape, or form to these proceedings. So I'd object to including it in the record for that reason.
Okay. Your comment and objection are noted. I will admit the letter and his testimony. And if there's nothing further, then, as I said, so April 1st for supplements, April 10th for post-hearing briefings, and that will conclude our hearing for case number 32666. Okay, at this time, we'll jump back to the first case on the docket.
Mr. Examiner, if I could just have just a couple minutes to kind of get my other kind of exhibits and cases put
Why don't we take another 5-minute break then?
Okay, yeah, thank you.
You're going to get
Okay, we are back on the record. Actually, at this time, we are going to take a lunch break until 1 p.m. We are now off the record. Thank you. We are back on the record, and we will resume with case number 32642. Application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the Bulmos and/or snow cover Bonkin pools to establish a stand-up 1280-acre spacing unit described as sections 18 and 19, Township 147 North, Range 101 West, McKenzie County, North Dakota, and authorize 2 horizontal wells to be drilled on such unit or grant as other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company LP. I have 3 witnesses for this case, and as well as the next 3 Burlington Resources cases, and it'll be Mark Salvi, Adam Mullins, and Will Carlisle.
Mr. Salvi.
Are they all come on screen?
Is he on mute?
Hey, Mark, I don't know if you can hear me. You guys might be muted in the conference room, or are they muted? Yeah, it shows him as muted. No, I think they're in a conference room, and Mark's just on there personally to share exhibits, if that makes sense. Yeah, I think is that I can't see the room, but
Mr. Salvi?
Yes, can you hear me?
Yes. Do you solemnly swear or affirm under the penalties of perjury and the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes.
Mark, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, Mark Salvi. I'm employed as a staff land negotiator by Burlington.
Oh, he froze.
Hey, Mark, you kind of froze on us here. I don't know if you can kind of repeat that.
Yeah, let me. Yes, I do.
All right.
Yes, I'm a staff land negotiator. Sorry, I'm getting a lot of feedback.
So we caught part of that, Mark. Got your name, your position, and your staff land negotiator with Burlington Resources. Is that correct?
Yes.
And then we didn't catch your business address. Just want to give us that again.
Yes, it's 925 North Eldridge Parkway, Houston, Texas 77079.
All right. And Mark, have you previously testified before the commission?
Yes, I have.
And have you had your qualifications received as that of an expert?
Yes, I have.
And are you familiar with the land matters associated with the requested spacing units?
Yes, I am.
Okay, I'd move the testimony of Mr. Salvi be received as that of an expert.
Motion granted.
And Mark, let's start with L1 in this case. Can you identify the spacing unit you're requesting?
Yes, Exhibit L1 is the locator map showing the proposed spacing unit in 147-101, McKenzie County, North Dakota, sections 18 and 19.
Okay. And then moving on to the next Exhibit L2, what's working interest in that proposed spacing unit?
ConocoPhillips has approximately 50% working interest in the proposed spacing unit, and the rest is unleased federal acreage.
I have no further questions on offer the land exhibits.
Exhibits are admitted. Any questions from the staff? Mr. Mullins,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, I do.
Adam, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
My name is Adam Mullins. I'm a staff geoscientist with ConocoPhillips at 925 North Eldridge, Houston, Texas 77079.
Okay. And Adam, have you previously testified before the commission?
Yes, I have.
And have you had your qualifications received as that of an expert?
Yes,
And are you familiar with the geology underlying the proposed spacing units?
I am. Yes.
Okay, I'd move the testimony of Mr. Mullins be received as that of an expert.
Motion granted.
And Adam, let's start with Exhibit G1, if you can describe the structure underlying this proposed spacing unit.
Yes, so Exhibit G1 is a structure map of the Upper Bakken Shale. And within that, you can see the 1280 acre DSU outlined here with a type log noted in section 18 that'll be shown in Exhibit G2.
Okay. And then let's go ahead and look at G2. What are you showing us on that type log?
The type log, as you can see, identifies the notable formations in the area, as well as we've got 2 Bakken pools that cover this particular area. That would be the bull moose and the snow cover. The language defining those are noted, as well as where they are located within the type log, as well as the Middle Bakken target, which will be the only interval targeted for this DSU.
Sure. So then moving on to G3, how would you propose to develop the spacing unit?
Our intent is to develop it with 2 4-mile U-turn or horseshoe wells, as shown here in Exhibit G3, with a proposed pad in the south.
Okay. I guess that's all the questions I have for Mr. Mullins, and I'd offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? Mr. Carlisle,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, I do.
Will, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Yeah, my name is Will Carlisle. I work for ConocoPhillips as a reservoir engineer. Our business address is 925 North Eldridge Parkway, Houston, Texas, 77079.
And Will, have you previously testified before this commission?
Yes, I have.
Have you had your qualifications received as that of an expert?
Yes, I have.
And are you familiar with the engineering matters associated with the proposed spacing units?
Yes, I am.
Okay, I'd move the testimony of Mr. Carlisle be received as that of an expert.
Motion granted.
And Will, if you can go ahead and look at E1 and summarize the reservoir data for us.
Yeah, so what we're looking at here are reservoir and fluid data for a 1280 acre spacing unit. I guess what's a little different than some of our other ones is the U-turn or 4-mile laterals in that spacing unit. We're anticipating to be able to produce around 650,000 barrels cumulative out of each well. So the recovery factor from each well is relatively high, more so than what you would see from a straight trajectory well. We're estimating a recovery factor of around 11.6%. But the other petrophysical properties, API gravity, GOR, pretty standard, lower gas oil ratio area around 750 scuffs per barrel.
Okay. Then moving on to E2, what would the economics look like for the proposed wells?
Yeah, we anticipate these wells to cost around $10 to $11 million each. At a moderate, price assumptions, we anticipate to generate a positive rate of return for all working interest parties.
Okay. And Will, in your opinion, if the commission were to approve this 1280 for that type of development, in your opinion, would that protect all our rights, prevent waste, and prevent the drilling of unnecessary wells?
Yes, I do believe so.
Okay. I have no further questions. That offer the engineering exhibits and gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff? That concludes our hearing for case number 32642. Case number 32643. Application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the North Branch and or Snow Cover Bakken pools to establish an overlapping stand-up 1920 acre spacing unit described as sections 1, 12, 13, Township 147 North, Range 102 West, Kansas County, North Dakota, and authorize 4 horizontal wells to be drilled on such unit or granting such other relief as may be appropriate. All interested parties please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company LP, and I have the same three witnesses in this case.
They're still under oath.
And Mark, let's go ahead and start with your Exhibit L1 again, and if you could identify the spacing unit you're requesting here.
Yes, Exhibit L1 is the locator map showing the proposed spacing unit to 3-section DSU comprised of sections 1, 12, and 13 in 147 North, 102 West, McKenzie County, North Dakota.
And then moving on to L2, what's the working interest in that unit?
The ConocoPhillips has approximately 66.6% working interest in this DSU, and other working interest owners comprise the other third.
Okay. That's all the questions I have. We're off of the land exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
Okay, Adam, let's look at G1 for this case and describe the structure underlying the spacing unit.
Yes, Exhibit G1, Upper Bakken Shale structure map underlying the proposed 1920 acre DSU with the type log noted there in section 12. The structure here is continuous across the area.
Okay, and then moving on to your type log there, what do you have shown on that exhibit?
Exhibit G2 identifies the notable formations within the area. In addition, the Middle Bakken target is highlighted, as well as the Bakken pools, which were previously mentioned at the start of this case number. So that would be the North Branch and Snow Cover Bakken pool, the top and base, which share the same definitions.
Okay, and then moving on to G3, how would you propose to develop the spacing unit?
Our proposal is to develop this 1920 acre DSU with 4 3-mile laterals as shown here, with a conceptual pad location in the southern end of the DSU.
Okay, I have no further questions that offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
Okay. Will, let's look at your E1 for this case. How would you propose to drill and complete the wells on the spacing unit?
Yeah, so what you're seeing in this exhibit is a 15K wellbore schematic. We would anticipate to be able to drill this well as a 3-string well design. It would be completed with a 3-mile cemented 4.5-inch liner. We do a plug and perf completion of approximately 75 stages.
Okay, and then on E2, what's the reservoir data for this?
Yeah, so you're looking at similar petrophysical properties in general. The main difference between prior exhibits that we shared was a change in the estimated recovery per well and the recovery factor. So in this case, with a 3-mile well, we anticipate to produce around 510,000 barrels cumulative from that well, with that would equate to an oil recovery factor of around 6%.
Okay, and then looking at E3, what would the economics look like?
Yeah, so the economics for 15K well, we anticipate that to be drilled between $9 and $10 million, assuming, again, some moderate price assumptions with the same recovery factors previously stated. We would anticipate to generate a rate of return of 29%, so profitable for all working interest parties.
Okay. So in your opinion, if the spacing unit's approved for that development, would that prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes, I do believe so.
I have no further questions for engineering exhibits and gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Yeah, when's your planned development date for this pad?
We're still working on our long-term development plan for this, so I do not have a date to give you at this time.
Is it in 2026 or 2027?
No, it is not.
Okay, so thank you. Do you guys have any other unleased federal minerals in this unit?
I'll give this to Mark for that question.
The federal minerals in this DSU are already leased.
Okay, thank you.
That concludes our hearing for case number 32643. Case number 32644, application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the trailside Bakken pools to establish an overlapping stand-up 1920 acre spacing unit described as sections 1930 and 31, Township 147 North, Range 100 West, Kansas County, North Dakota, and authorize 4 horizontal wells to be drilled in such unit or grant such other relief as may be appropriate. All interested parties please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company, LP. Same 3 witnesses will testify in this case as well.
They're still under oath.
And again, Mark, looking at L1, what is the spacing you're requesting here?
Yeah, L1's the locator map showing the proposed spacing unit comprising of sections 19, 30, and 31 and 147 North, 100 West, McKenzie County, North Dakota.
And then moving on to L2, what's the working interest look like in that spacing unit?
Conoco has approximately 71.7% working interest in this DSU. There's approximately 6.4% unleased federal, and then other working interest owners comprise the remaining 21.8%.
Okay. No further questions, but offer the land exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Adam, let's look at G1. Can you describe for us the structure underlying this spacing unit?
Yes, Exhibit G1 shows the Upper Bakken Shale structure map, which shows continuous Upper Bakken pool here. It also notes the type log. I will point out that this type log is not located within the DSU. It is the closest well with a full coverage of the Bakken pool, so that's why it was selected for this particular application.
Sure. Let's go ahead and look at that type log then. Describe for us what you're showing in that exhibit.
So on the left, it notes the formations that we've been looking at in the previous cases. We're also middle Bakken target, as with the previous cases. This will be the only target that or interval that we will be targeting laterals. The top of the trail side and base of the trail side Bakken pool is denoted here with the black dashed lines.
Okay. And then finally on G3, why don't you describe for us how you would propose to develop the spacing unit?
Similar to the previous case we just reviewed, this will be developed with 4 3-mile laterals with a conceptual pad at this stage at the southern end of the DSU.
Okay. No further questions and offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Will, looking at E1, how would you drill and complete these wells?
Yeah, so we're looking at a similar wellbore schematic as shown previously, 3-mile lateral with a 4.5-inch cemented liner with a plug and perf completion that would comprise of approximately 75 stages.
And then moving on to E2, just briefly summarize the reservoir data under this spacing unit.
Yes, very similar reservoir and fluid data as in the prior spacing exhibit. We have a 510 barrel of oil expected recovery, which would equate to an oil recovery factor of around 6% per well.
Okay. And then on E3, how about the economics? How do they look here?
Yeah, with an anticipated well cost between $9 and $10 million, we would expect this project or per well to generate a positive rate of return around 29%.
Okay. In your opinion, if this were to be approved, would that prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes, I do believe so.
Okay. I have no further questions that offer the engineering exhibits in the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
When's the planned development date for this unit?
Similar as to the prior case, we're still evaluating our timing and timeline of the development in this area. And
Is it before the end of 2027?
no, it is not.
Okay.
Not currently, at least.
Thank you.
Concludes our hearing for case number 32644. Case number 32645, application of Burlington Resources Oil and Gas Company LP for an order amending the applicable orders for the trailside and or Rough Rider Bakken pools to establish an overlapping stand-up 2560-acre spacing unit described as sections 6, 7, 18, and 19, Township 146 North, Range 100 West, Mackenzie County, North Dakota, and authorize 4 horizontal wells to be drilled on such unit. Grant such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Burlington Resources Oil and Gas Company, LP, and once again, same 3 witnesses.
Still under oath.
And again, Mark, for this one, let's look at L1 and describe the spacing unit you're asking for.
Yes, this is the locator map for the spacing unit proposed. This is directly south of the spacing unit proposed in the last case. This one is comprised of section 6, 7, 18, and 19, and 146 North, 100 West, Mackenzie County, North Dakota.
Okay. And then on L2, what's the working interest in the spacing unit?
ConocoPhillips has a 50% working interest in this proposed DSU, and the remainder is unleased federal acreage.
I have no further questions. I'd offer the land exhibits.
Exhibits are admitted. Any questions from the staff?
Have you nominated those lands for lease yet?
Not yet. So these sections 6 and 18 were previously leased. Those existing leases have expired and they need to be renominated. We plan to meet with the BLM later this year.
And if you are not able to get those leased, does that prevent Conoco from developing these lands?
That's correct.
Thank you.
You can proceed.
All right, Adam, looking at G1, can you describe the structure underlying the spacing unit?
Sure. Exhibit G1 shows the Upper Bakken Shale structure map as on previous cases. The Bakken pool in this area is continuous across the proposed 2560-acre DSU.
Okay.
Type log is also noted on this map as well.
Yeah, and then looking at G2, just briefly describe what you're showing on that type log.
Notable formations shown on the left side within the Bakken pool. The top of the Rough Rider and Trailside Bakken pools are noted, as well as the base of those 2 various pools are shown as well on this type log,
Okay.
as well as the Middle Bakken target.
Sure. And then moving on to G3, excuse me, how would you develop the spacing unit?
We propose developing this 2560-acre DSU with 4 4-mile laterals with a potential pad location in the southern end of the DSU.
Okay. I have no further questions. I'd offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right. Will, looking at E1, how would you propose to drill and complete the wells here?
Yeah, we would plan to drill and complete these with a 4-mile long cemented 4.5-inch liner. This would again be a plug and perf completion with approximately 100 stages.
Okay. And then E2, I think we're pretty close to the last case, is similar looking reservoir here or not?
Yeah, very similar. Only difference being the extended lateral of this one over the prior. So we would anticipate this well to recover approximately 650 barrels of oil, which would equate to an oil recovery factor of 6%.
Okay. And then with the longer laterals, E3, what are you looking at for economics?
Yeah, so assuming gross well costs between $10 and $11 million, we would anticipate positive rate of return approximately 35%.
And then in your opinion, Will, would establishment of the spacing unit prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes, I would.
Okay. I have no further questions. I'd offer the engineering exhibits and gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff? That concludes our hearing for case number 32645. Case number 32210, application of Marathon Oil Company. This case has been continued to our April hearings. Concludes our hearing for case number 32210. Case number 32211, application of Marathon Oil Company. This case has been continued to our April hearings. Concludes our hearing for case number 32211. Case number 32646, application of Hesbagen Investments 2 LLC for an order amending the applicable orders for the Rainbow Bach and Pool, Williams County, North Dakota to 1. Establish an overlapping stand-up 2560 acre spacing unit described as sections 15, 22, 27, and 34, Township 158 North, Range 98 West, and authorize 4 horizontal wells to be drilled in such unit. 2. Establish an overlapping stand-up 2560 acre spacing unit described as sections 14, 23, 26, and 35, Township 158 North, Range 98 West, and authorize 1 horizontal well to be drilled on such unit. Or 3. Granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Hess Pocket Investments 2 LLC. I have 3 witnesses for this case: Derek Abrahamson, Will Yancey, and Matthew Dupree.
Mr. Abrahamson.
Do we have their conference room? They're probably in the Chevron conference room. So yeah, so that Shantae, she's gonna be running exhibits and not testifying. I think the rest of the group is probably in one of the conference rooms. There's nobody else in there. Let's see.
You're connected to her meeting? Her teams. Okay, cool.
Oh, all right, great.
Mr. Abrahamson.
Yes, sir. Can you hear us?
Could you guys turn the YouTube off on your end? We're getting feedback here.
Yeah, give us a second, Wayne, please.
Yep.
Just turn the volume down.
We're still getting it, Derek.
Yeah, we're hearing it ourselves. Okay.
So Derek Abrahamson is the first witness in this case. I don't think he's been sworn in yet.
No one has.
Okay.
Is it off now? Can you hear us now? Is it better?
No, we're still getting there. I mean, can you shut, like, if you're muted, shut yours off?
Yeah, we're trying over here.
Minute break. Okay, this time we'll take a 5-minute break.
Yeah, we're gonna just go off the record and take a break, Derek, till we get this figured out.
Okay, we're actually back on the record right now. Less than 5 minutes. Mr. Abrahamson.
Yes, sir.
Do solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter, any subsequent matter today, will be true and correct to the best of your knowledge and belief?
I do.
Derek, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Sure thing. My name is Derek Abrahamson. I'm employed as a land representative by Chevron USA Incorporated, which conducts business under Hess Corp. The business address is 1500 Louisiana Street, Houston, Texas, 77002.
And Derek, have you previously testified before this commission?
I have.
Yeah, have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the land matters associated with the proposed spacing units?
Yes, I am.
All right. I'd move the testimony of Mr. Abrahamson be received as that of an expert.
Motion granted.
And Derek, let's begin with exhibit number 1. If I could have you identify the spacing units you're asking for in this case.
Exhibit 1 is the location map showing Township 158 North, Range 98 West in Williams County. The blue outlines represent the 4 existing 1280 stand-up DSUs, being sections 15 and 22. sections 14 and 23, sections 27 and 34, and sections 26 and 35. The green dashed outline represents the requested overlapping 2560 stand-up DSUs. First one being sections 15, 22, 27, and 34, and the other requested overlapping 2560 stand-up DSU being section 14, 23, 26, and 35.
And then moving on to E2, I guess we'll call that Western 2560. What's the working interest in that one?
In proposed Bayer DSU, in blue is the Hess operated GN Ring, where Hess's working interest is 68.47%, and the remaining owners with a 31.53%, and that's in the blue. In green, to the south of that, is the Hess operated Go Hill DSU. Hess's working interest is 77.45, and the remaining owners have a 22.55% working interest. And the combined working interest of the proposed stand-up 2560, Hess would own 72.96%, and the remaining owners with 27.04%.
Okay. And then the next one, what's the working interest in that one?
So the land plan on this one in blue shows to the north the Hess operated Gianna Vinder DSU. Hess's working interest is 67.78%, and the remaining owners with 32.22%. In green is the Hess operated Gaucher MWTR DSU. Hess's working interest is 87.5%, and remaining owners with 12.5%. And the combined working interest of the proposed Go Bindi 2560 stand-up DSU, Hess owns 77.63%, and the remaining owners with 22.37%.
Okay. I have no further questions on for the land exhibits.
Exhibits are admitted. Any questions from the staff? Mr. Yancey,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter and the subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes.
Will, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
My name is Will Yancey. I'm employed as a development geologist by Chevron USA Incorporated, which conducts business under Hess Corporation. The business address is 1500 Louisiana Street, Houston, Texas 77002.
And Will, have you previously testified before the commission?
Yes.
Have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the geology underlying the proposed spacing units?
Yes.
All right, I'd move the testimony of Mr. Yancey be received as that of an expert.
Motion granted.
And Will, let's look at Exhibit 4. Can you describe the structure underlying these spacing units and then kind of identify the cross-section points as well?
Yes. Exhibit number 4 shows the location of the existing 1280 DSU outlines in solid blue. 4 1280 DSUs, and the requested 2560 DSU outlines in dotted green with the existing wells marked. The top middle Bakken structure map is displayed in true vertical depth subsea with 50-foot contour intervals, illustrating a south-southwest tip of the formation within the area of interest. And the purple line, A to A prime, indicates the well locations used to construct the cross-section shown in exhibit number 5.
Okay, and let's move on to exhibit number 5. What are you showing on that cross-section exhibit?
Exhibit number 5 is a stratigraphic cross-section flattened on the top of the Bakken, showing that the targeted formations are present and continuous throughout the region.
Okay. I have no further questions that offer exhibits 4 and 5.
Exhibits are admitted. Any questions from the staff? Mr. Dupree,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Matthew, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
My name is Matthew Dupree, D-U-P-R-E-E. Business address is 1500 Louisiana Street, Houston, Texas 77002. I'm employed as a reservoir engineer by Chevron USA, which conducts business as Hess Corporation.
And Matthew, have you previously testified before this commission?
I have.
Have you had your qualifications received as that of an expert?
Yes,
And are you familiar with the engineering matters associated with these spacing units?
I am.
Okay, I'd move the testimony of Mr. Dupree be received as that of an expert.
Motion green.
And Matthew, let's look at Exhibit 6. Can you just describe for us how you would develop each of these two proposed 2560s?
Yes, sir. So Exhibit 6 shows both proposed 2560 developments, section 15, 22, 27, and 34, the western one. And the other is 14, 23, 26, and 35, which is eastern. The highlighted dash green lines show the proposed 4-mile wells to be drilled from the pad location denoted in blue on the map.
Sure.
Yeah, perfect.
Then moving on to Exhibit number 7, can you kind of summarize the reservoir data and then tell us what the economics would look like?
Yes, sir. So Exhibit 7 shows the reservoir and economic summary for a single 4-mile Middle Bakken well in the Rainbow Field. The expected EUR for these wells is around 845 MSTB, 1,000 barrels, with a 3.4% recovery factor. Economics will run at $62 per barrel, WTI, flat and 100% working interest. Expected NPV for these 4-mile wells is about 12.5 million with an ROR of 67%.
Okay. And Matthew, in your opinion, if the commission approves these two 2560s for the development you described, would that protect prerogative rights and also prevent waste and prevent the drilling of unnecessary wells?
It would, yes.
I have no further questions that offer Exhibit 6 and 7 in the gas capture plan affidavit.
Exhibits are admitted. Any questions from staff?
When's the planned development date for these?
This is to be spud March 2027.
Is it plan that you're going to have a new pad drill?
It would be a new pad, yes.
I guess 6 wells in the south, the 5 4-milers, and then the 2-miler.
Let me see. Yeah. Yes. Yeah.
And the 2-milers in the north, I guess, are those they're on a new pad from the north or an existing pad?
That would be a new pad, and that's later in the development plan. We just wanted to show that this acreage was going to be developed.
Okay. Thank you.
That concludes our hearing for case number 32646. Case number 32647, application of Hess Bakken Investments 2 LLC for an order amending the applicable orders for the Sorkness Bakken Pool to establish an overlapping 2560 acre spacing unit described as sections 26, 27, 34, and 35, Township 157 North, Range 93 West, Montreal County, North Dakota, and authorize one horizontal well to be drilled in such unit or grant such other relief as may be appropriate. All Mr. Parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, bringing this case on behalf of Hess Bakken Investments 2 LLC. We're going to have Derek Abrahamson again and Matthew Dupree, but I believe Aaron Rodriguez will be testifying on geology this time.
Mr. Abrahamson is still under oath.
Derek, let's look at exhibit number 1. Can you identify the proposed spacing unit?
Exhibit 1 is the location map depicting Township 157 North, Range 93 West in Montreal County. The blue outlines represent the 2 existing 1280 laydown DSUs, one being section 26 and 27, and the south one being sections 34 and 35. And the red dashed outline represents the requested overlapping 2560 DSU being sections 26, 27, 34, and 35.
Okay. And then on exhibit 2, what's the working interest look like here?
In blue is the Hess operated Ian Van Berkom DSU. Hess's working interest is 66.53%. Remaining owners with 33.47%. In green to the south in sections 34 and 35 is the Hess-operated Ian Sable DSU. Hess's working interest is 58.13, and the remaining owners with a 41.87% working interest. And the combined working interest of the proposed Ian Lee DSU will be Hess with 62.24% working interest, and the remaining owners with 37.76% working interest.
I have no further questions. I'd offer the land exhibits.
Exhibits are admitted. Any questions from the staff? Mr. Rodriguez,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, I do.
Aaron, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, my name is Aaron Rodriguez. I'm employed as a geologist by Chevron USA Inc., which conducts business under Hess Corporation. The business address is 1500 Louisiana Street, Houston, Texas, 77002.
And Aaron, have you previously testified before the commission?
Yes, I have.
And had your qualifications received as that of an expert?
Yes, I have.
And you're familiar with the geology underlying the proposed spacing unit?
Yes, I am.
All right, I'd move the testimony of Mr. Rodriguez be received as that of an expert.
Motion granted.
And Aaron, looking at exhibit number 3, could you describe for us the structure underlying the spacing unit?
Yes, exhibit number 3 shows the location of the existing 1280 DSU outlines in solid blue and the requested 2560 DSU outline in dotted red with the existing wells marked. The top middle Bakken structure map is displayed in true vertical depth sub-C with 50-foot contour intervals, illustrating a southwest dip of the formation within the area of interest. The line A to A prime indicates the well locations used to construct the cross-section that is going to be shown in the next exhibit, exhibit number 4.
Okay, let's move to that then. Exhibit 4, what are you showing on that cross-section?
Exhibit 4 is a stratigraphic cross-section flattened on the top of the Bakken, showing that the targeted formations are present and continuous throughout the region.
All right, I have no further questions. I'd offer exhibits 3 and 4.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Matthew, looking at exhibit 5, how would you intend to develop this spacing unit?
So exhibit 5 shows the proposed 2560 development for sections 26, 27, 34, and 35. The highlighted dashed green line shows the proposed 4-mile U-turn well to be drilled from the pad location denoted in blue in the top middle of the visual.
Okay. And Matthew, just briefly, so you're showing 200, looks like 200 feet on the west there. That mean you're not planning to kind of complete the well through that U or that curve?
That would be correct.
Okay. And then the well, it's mostly centered, but not, perfectly symmetrical. Would you still anticipate that, recovery from each of those lay down 1280s, would be similar with respect to this well?
I would.
Okay. Let's move on then to exhibit number 6. Why don't you take us through the reservoir data and then summarize for us, tell us what the economics would look like as well.
Yeah, so exhibit 6 shows the reservoir and economic summary for a single 4-mile middle Bakken well. The expected EUR is about 1.1 million barrels with 2.6% recovery. The economics were run at $62 per barrel oil WTI, flat and 100% working interest. The expected NPV for this well is 14.1 million with a rate of return of 62%.
So Matthew, in your opinion, if the commission approves the 2560 to allow for this longer lateral, I'll call it a U-turn well, in your opinion, would that prevent waste, protect correlative rights, and prevent the drilling of unnecessary wells?
Yes.
Okay. I have no further questions at this time. I'd offer exhibits 5, 6, and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Looking at Exhibit 5. We'll call them the parallel laterals. One is 520 from the section line, the other 680. You had said that you don't plan to complete the curved portion of this well, so will all portions be that 520 and 680 from the section line?
Yes. We do plan to complete anything that's more than 500 feet away from the section line to the west. So there might be some curvature, and I'm not sure if it'll be exactly 520 feet. So yeah, we would have to make sure that we stay off of the lease line in the middle there. So yeah, that would be the plan.
So just to make sure I understand, you don't plan to complete any portion of the well closer than 500 foot from the section line?
Correct.
Okay, thank you.
Matthew, you generally, I'm assuming you generally understand the commission's usual setback policy regarding perpendicular to the spacing unit boundary. Are you familiar with that?
Yes, I do.
Do you intend to comply with that for this as well?
Yes.
I don't believe it looks like it'd be a problem if you stay 200 feet off, but just wanted to confirm. What's your general interwell distance on the wells on 34 and 35, the existing wells?
34 and 35. Let me.
So they're the wells to the south.
Yeah, the Sable wells.
Yep.
Let's see. Sorry, give me 1 second. So those are about 900, 875 foot spaced from each other. And the southern stick from the U-turn would be about 900 feet from the Ian Sable H1.
So you'll be about 900 feet north of the existing well and about 680 feet off the section lines, if I heard you
correct.
Right. And then when you move to the north, what kind of interwell distance? I mean, it looks like you have a wider gap between the two legs on the U-turn than between the other portions of the. What I'm getting at is north of your northern leg, that gap to that next well looks smaller than the gap between the U-turn wells. You want to elaborate on what's going on?
Yeah, so there's a 1,200 foot minimum spacing in order for our drilling to be able to turn to create a U. In between the U-turns themselves, there's about 900 foot spacing there.
So you've got an internal kind of restriction of 1,200 feet between legs on the U.
Correct.
If you weren't developing this with U-turns, would you be spacing closer to that 900 foot, or is that your minimum distance between legs?
So previously, the previous development before we decided to do U-turns, the only difference was that we had one well that went straight down the lease line from this development. So there really was no difference in spacing between the previous development with 2 miles and U-turn development besides one well.
So you plan to put, I'm gonna go from the north because it's easier to describe. You plan to put one well, looks like a couple hundred feet off of the, probably 500 feet off the north line, and another one 1,200 feet off of that, and then one 900 feet off of that. If you had drilled each of these legs with single laterals, would that have been the spacing? Or would you have evenly spaced them?
Not identical, but similar. They would be more evenly spaced.
Okay. At this time, do you plan to develop the common section line between the, or which right in the middle of the 2560?
At this time, no.
And I guess maybe last question, the existing well across 27 and 26, do you plan to continue producing that, or is that going to be plugged and abandoned?
At this point, there's no plan to plug and abandon that well, and we intend to continue to produce it.
Okay, thank you.
I have another question. Do you plan to develop all 3 U-turn wells at the same time?
They would be developed at the same time, yes.
And when's your anticipated spud date?
So for the first well in this batch would be January of 2027 through March. So we drill all 3 of these.
Thank you.
That concludes our hearing for case number 32647. Case number 32568, on a motion of the commission to review the pilot injection project for enhanced oil recovery authorized under order number 30288, authorizing Hess Bakken Investments 2 LLC to continue the pilot injection project in the Big Butte Bakken pool, utilizing the EN Ortloff number 156-94-2635H-4 well, the EN Ortloff number 156-94-26335H-5 well, the EN Ortloff number 156-94-2635H-6 well, and the EN Ortloff number 156-94-2635H-7 well, located in a spacing unit comprised of sections 26 and 35, Township 156 North, Range 94 West, Montreal County, North Dakota. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case. On behalf of Hess Bakken Investments 2 LLC, I will note that we did file a motion to continue this case with the commission, requesting that it be continued to the December docket. And the reason for it's laid out in the motion, but essentially, in the order of creating the pilot project or approving the pilot project, that 288, I think it was, it required the commission to redocket this at the end of the project, essentially, so that Hess would have the opportunity to come and provide some data and kind of conclusions on, how the project went. The project's not quite done. They're anticipating it should be done towards the end of this fall, and that they should have the ability to put together, the information that the commission wants to see and come up with, conclusions, answering the questions that the commission had asked for. So that's the reason why we are requesting it to be out till December. I mean, we're continuing to provide data pursuant to what the order requires already, but as far as kind of like a summary of the project and that data, it would be more appropriate to do it in December.
Okay. This case will be continued to our December 2026 hearings. That concludes the hearing for case number 32568. Case number 32648, application of White Rock Oil and Gas LLC. This case has been continued to our hearings on Friday, March 27th.
Mr. Examiner, if I may, so case 32648 and 32649, those were both going to be continued to the Friday docket. It's my understanding that White Rock has been communicating with another operator, Prima, who had previously opposed the 32648 case and trying to get a resolution. And at this point, White Rock is going to request that these 2 cases be continued to the next regular docket, to the April docket.
Okay. I'll call both then. Case number 32648 and case number 32649, both of which are applications of White Rock Oil and Gas LLC, are continued to the April hearings. So that concludes our hearings for case numbers 32648 and 32649. Case number 32650, application of Devon Energy Williston LLC for an order amending the applicable orders for the nameless Foreman Butte and/or Glass Bluff Bakken pools to establish 2 overlapping laydown 1,600-acre spacing units described as the west half of Section 27 and all of Sections 28 and 29, Township 151 North, range 102 west, and the west half of section 34, and all of sections 32 and 33, township 151 north, range 102 west, Mackenzie County, North Dakota, and authorize 4 horizontal wells to be drilled on each such unit or branches of relief as may be appropriate. Mr. Party, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Devon Energy Williston, LLC. I have 3 witnesses, Katie Adams, Drew Kremen, and Mark Sharp, and I believe they should be all here.
Ms. Adams.
Hi there, good afternoon. Can you all hear me?
Yep, Ms. Adams.
Yes,
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Katie, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Katie Adams. I'm employed by Devon Energy as a senior staff landman, and my business address is 333 West Sheridan Avenue, Oklahoma City, Oklahoma 73102.
And Katie, have you previously testified before the commission?
Yes, I have.
Have you had your qualifications received as that of an expert?
I have.
And are you familiar with the land matters associated with the proposed spacing units?
Yes, I am.
All right. I'd move the testimony of Ms. Adams be received as that of an expert.
Motion granted.
And Katie, let's start with L1. If you could identify, the area as well as the proposed spacing units you're asking for.
Yes, on Exhibit L1, this is our regional locator map highlighting McKenzie County. And the diagram below shows Township 151 North, Range 102 West, where these proposed spacings are located. The first in the north is comprised of the west half of Section 27 and all of Sections 28 and 29. And the spacing in the south is comprised of the west half of Section 33 and all of Sections Section 34 and all of Sections 32 and 33. And again, these are in 151 North, Range 102 West.
Mm-hmm. And then moving on to L2, the proposed spacing units overlap some existing stand-up 1280s. Can you take us through the working interest in those 1280s?
Yes, so this map shows the existing spacing units. Devon is the operator of all 3 of these units, and they are stand-up 1280-acre units. From left to right, we have first the GELD spacing unit comprised of Sections 29 and 32, and Devon owns approximately 71% interest in this unit. In the middle, we have the Safely Trust spacing unit comprised of Sections 28 and 33, where Devon owns about 92%. And then on the right, we have the Albert spacing unit comprised of Sections 27 and 34, where Devon owns about 97% working interest.
Mm-hmm. Let's move on to L3 then. So due to kind of existing development with some existing wells, these wells won't completely encompass all 3 the sections. It'll be 2.5. So with that being said, Katie, how would you intend to have the production from the wells on those spacing units allocated?
Yeah, so this map shows those base spacing units again, and then additionally we have the proposed overlapping 1,600-acre spacing unit in the north outlined in that bold line, and our plan would be to allocate production from the overlapping 1,600-acre spacing units proportionately to the underlying 1,280-acre base DSUs. So, for example, the GELD DSU is contributing 640 acres out of the 1,600-acre overlapping spacing unit, being 40%. And that 40% total would be shared with all of the GELD DSU owners. So effectively, 20% would be allocated to Section 29, and 32% or 20% would also be allocated to Section 32. The same would apply to the other base DSUs. It's 40% as well in the Safely Trust DSU. And then the Albert DSU is contributing less. They are contributing 320 acres out of the 1,600-acre proposed DSU, which makes up 20% of the total. And that 20% would be shared proportionately with all of the Albert DSU owners. In other words, 10% would go to section 27, or 5% in the west half and 5% in the east half, and the remaining 10% to section 34.
And Katie, Mark will maybe elaborate a little bit on this, but is the reason you're doing this method of allocation to ensure that all of the owners of interest are going to be receiving their just and equitable share of production, and that their correlative rights will be protected? Is that the purpose?
Yes, that's correct.
So then that's how it would work for that northern 1600. Moving on to L4, looks like similar concept on how you would handle allocation with that southern 1600. You want to take us through that?
Yes, this is the exact same thing. So stop me if I'm being repetitive, but the same concept. We plan to allocate production from the overlapping 1600 acre spacing unit proportionately to those underlying base DSUs. So again, the GEL DSU is getting 40% of the total that will be shared amongst all of the owners in the GEL DSU. That's a pooled unit. And then the Safely Trust DSU is contributing 40%. So those owners will be sharing that 40% evenly. And then the Albert DSU is contributing 320 acres out of the 1600, being 20%. So again, that 20% total will be shared evenly amongst all of the owners in the Albert DSU.
Sure. And then let's move on to the next exhibit, L5. And that just essentially kind of summarize how, once you have production going from, both of those 1600s, how everybody would, kind of be treated the same, so to speak.
Yeah, so on Exhibit L5, this shows both of the proposed spacing units depicted as A and B on the map, along with the allocation totals that I just walked through. The chart at the bottom is an example of how interest would be calculated using the allocation percentages and ownership in the underlying pooled units. So just to kind of walk through as an example, if we're looking at Unit A on the map, starting with the first spacing unit, that spacing unit A, section 29 is making up 40% of the overlapping DSU. So we multiply that 40% by Devon's pooled 71% interest in the underlying GEL DSU, and that yields the proportionately reduced interest for that particular DSU. And we do the same math for section 28 and section 27. Devon owns in all three of these underlying DSUs, so we add them together to get our total working interest in the proposed overlapping 1600 acre DSU. So this ownership calculation example can be applied to any owner because of those underlying pooled units. This is just showing Devon's interest as an example.
Sure.
And then the same applies for B, and you'll notice that the interest is exactly the same, and that's essentially because we are splitting the pooled base units, splitting the pooled DSUs in half.
Sure. And maybe this seems obvious. I apologize if it does, Katie, but this allocation is just for like the new wells on each of those proposed 1600s, correct?
That's correct.
So those existing wells in, those stand-up 1280s would continue to be paid, on their 1280 basis?
That's correct.
Yeah. I have no further questions. I'd offer the land exhibits.
Exhibits are admitted. Any questions from the staff?
Katie, along the lines of the last question that Wade asked you, the wells get paid out based on an existing 1280, but they also continue to pay out on that 1280, right? So like their production is allocated to all of 27 and 34. Those
That's
existing wells on the east of 27 and 34.
Yes.
Okay, thank you.
Thank you.
Mr. Creeman.
Good afternoon.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Drew, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
My name is Drew Creeman. I'm a senior geologist at Devon Energy. The address of Devon is 333 West Sheridan Avenue, Oklahoma City, Oklahoma, 73102.
And Drew, you previously testified before the commission.
I have, yes.
Have you had your qualifications received as that of an expert?
Yes,
And are you familiar with the geology underlying the proposed spacing units?
I am, yes.
Okay. I'd move the testimony of Mr. Freeman be received as that of an expert.
Motion granted.
And Drew, let's look at G1. Can you describe the structure underlying the spacing units?
Within this exhibit here, we're looking at the top of Bakken structure in subsea TVD depths. So the white smooth or the black smooth lines are going to be the top of the structure on the Bakken, which in general is dipping from west to east, so getting deeper to the east. Here we can see the wellbores in green, and then the red star is the type well for this area, the mirror check 134-1C.
Okay. And then let's move on to G2 then. Tell us what you've shown on the type log.
On the type log here in this exhibit, we want to share the middle Bakken is the target here. It's at 28 feet in thickness, and just wanted to share here the representative formation.
All right. I have no further questions that offer the geology exhibits.
Exhibits are admitted. Any questions from the staff?
Just confirming on your exhibit G1, the short horizontal laterals in 32 and 33, those are Madison targets, correct?
That is correct, yeah.
And the target on all the existing wells is Middle Bakken? Or are there
Middle Bakken. Yes, that is correct.
All Middle Bakken or both exist?
So for the proposed units and the proposed wells, we're targeting Middle Bakken.
I'm sorry, I was asking about the existing Bakken pool wells. Are they all Middle Bakken targets, or is there a Three Forks targeting here?
They're Middle Bakken wells.
Okay, thank you.
Mr. Shute.
Yes, sir.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Mark, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, I'm Mark Schutt, an advising reservoir engineer. I work for Devon Energy. Our address is 333 West Sheridan Avenue, Oklahoma City, Oklahoma, 73102.
And Mark, have you previously testified before the commission?
Yes, I have.
And have you had qualifications received as that of an expert?
Yes.
And are you familiar with the engineering matters associated with the proposed spacing units?
Yes, I am.
I would move the testimony of Mr. Schutt be received as that of an expert.
Motion granted.
And Mark, let's look at E1. How would you develop these spacing units?
Okay, we plan on developing the spacing units. We have two pads on the eastern side of this map, kind of the red boxes. We'll drill we're proposing 4 new Bakken wells from each of those pads. They're in green, so 4 on top, 4 in the north, 4 in the south, so a total of 8. They'll all be Bakken wells kind of marked in green. In the spacing units, 2 overlapping spacing units are marked in red. Both are each are 1,600 acres.
Mm-hmm. Moving on then to E2, how would you drill and complete each of these wells?
This is just a typical well design for us. So again, 2.5 mile lateral. We'll have surface casing, 9 5/8 inch surface casing set at about 2,200 feet. Intermediate casing will be 7 inch set at about 10,500. And then a cemented liner, which is 4.5 inch set at about 23,000 feet. The completion will be a standard completion for us, so about 1,000 pounds per foot and about 200 feet stage spacing.
Okay. Moving on to E3, can you describe the reservoir characteristics?
Yes, so this is based on a 1,600 acre development area. The main things to point out, net pays about 28 feet, porosities about 6%, middle Bakken water saturation is about 55%. That gives us an estimated oil in place of about 6.6 million barrels. The EUR per well for each of these proposed wells is about 440,000 barrels. That gives us an estimated recovery factor per well of about 6.6%.
Okay. And then moving on to E4, what do the economics look like?
Okay, we're planning on an initial rate of 1,500 barrels a day. Again, the EUR 440 MBO, EUR for the gas 663 million cubic feet for an equivalent EUR of 551 MBOE. And then the economics, we ran it at $60 per barrel oil. Gas is $3.50. The gross CapEx per well, about $7.4 million. Gives us an NPV of about $2.3 million per well and a rate of return of 37%, payout about 2.3 years.
Okay. And then moving on to E5. Now, Mark, you understand that when the commission establishes spacing units, that they, in order to do so, that they must protect the correlative rights of all owners. You understand that, correct?
Yes, that's right.
And I think, a component of that or part of that was, some of what Katie had put together with respect to, allocation, those exhibits and testimony. But with your exhibit number 5, can you kind of walk us through what you're showing on this exhibit and just explain how that protects the correlative rights of all owners?
Yes, so I'll be going through kind of the 7 marked small tables, and I'll step through each one of them. They all kind of build on each other. So if there are any questions or if I'm misexplaining something, please let me know, and I'll spend more time on it. So the first part, table 1, we have each of the units kind of spelled out. The GELD, which is refer to Unit A, Safely Trust, Unit B, and then the Albert, which is Unit C. So part 2, we have the current parent EUR. So there's one well in the GELD unit. Its EUR is 376,000 barrels. Unit B, there's one well, current well. Its EUR is 406. And then in the Albert DSU, there are 4 producing wells, and their total EUR is about 1.3 million barrels. So next we'll go to 3, that's the hypothetical parent EUR. So what we're assuming here is 5 well spacing, 352,000 barrels per well. That's our 442.5 mile well, taken from 2.2 miles down to 2 miles. That takes it from 440 to 352. In each of the units, 5 wells at 352 gives us 1.76 million barrels per unit. So that's the theoretical EUR for fully developed, to fully develop each one of these units. Okay, section 4, we're going to take the 1.76 from the previous table and subtract the current parent EUR, table 2. So when we subtract those two numbers, that's remaining undeveloped parent EUR reserves, the remaining reserves to get out. So unit A, we have 1.4 million barrels, 1.4 for unit B, and about 500,000, or about 500,000 barrels in unit C. So now we're going to count up sticks. We're going to estimate future development sticks, 2 mile, to fully develop the units. We're going to develop with a total of 10. There'll be 4 in unit A, 4 in unit B, and 2 in Unit C, and that equates to Katie's allocation, so 40%, 40%, 20%. So in 6, we have the modeled EUR. So we'll have 4 sticks for Unit A multiplied by that same base 2-mile EUR of 352. That gets us 1.4 million barrels. That's the same for B. And then C is half of that, since it'll be half the sticks. It'll be 2 instead of 4 sticks. So finally, part 7, 2-mile model total EUR. That's taking the current parent EUR from table 2 and adding it to the table 6. So I'll go over the first one. Unit A, 376,000 barrels plus 1.4 million gets you the 1.784 million barrels. So when you total each of these units up, the total modeled EUR after development, fully developed, is very similar.
Okay. So, Mark, does that data then confirm for you, as long as you allocate, as Katie indicated, this supports or confirms, in your opinion, that the correlative rights of all owners will be protected with this development plan?
Yes, I think so. The numbers are very close and reasonable.
Okay. And then in addition to that, if you're drilling these longer laterals with this sort of plan, is that also, in your opinion, going to prevent waste and prevent the drilling of unnecessary wells?
Yes, it does.
Okay. And Mark, I was going to ask Katie this, and it slipped my mind, and I don't know if you know or if we need to go back to her, but it is my understanding that when you're, with respect to your development on these lands, is it very near term, and you'd be needing an expedited order?
Yes, we these are very near on our drilling schedule. We would like to get these approved, and so we can start work as soon as possible.
Just as a frame of reference, and Mr. Graham, maybe if I could recall Katie, if you don't know Mark, like how soon are we talking about? Is it like in a matter of months or like sooner than that?
Yeah, Katie, would you mind stepping in?
Yeah, of course. So appreciate you asking the question, Wade. We currently have a spudder rig scheduled for late May, and the main rig following in August. And if things go smoothly, that could potentially accelerate. In order to stay on track with that timeline, construction work on the pad really needs to begin mid-April. And in order to start construction, as you'll know, we have to have a permit. So I know it's a really tight turnaround, but respectfully, we would be requesting orders to be issued prior to April 15th in order for us to meet our development timeline.
Okay. That's all the questions I had, Mr. Examiner. I don't know if I offered the engineering exhibits yet. If not, I'd offer those in the gas capture affidavit as well.
Exhibits are admitted. Any questions from the staff?
Mark, I guess starting with your exhibit E1, the wells that you're proposing to develop in each of the 1,600 acre spacing units, the completion interval you plan for those wells, where do you plan to land your 7-inch or have productivity start on the easternmost edge of that?
We're planning on the northernmost well will start approximately 150 feet off the unit line. So we will drill under around the that Alfred or Albert parent well pictured there. The other 7 wells we plan on drilling, starting perforating roughly 500 feet on the west side of that parent well, and then at the toe we'll shoot around 150 feet from the western line.
Okay, so you, just to make sure I heard you right, your planned perforation will be on the order of approximately 500 feet to the west of the existing westernmost Albert well.
Approximately, yeah, it's except for the northernmost one. It's the Albert 2734 1H. The Albert well is kind of in the middle of the section.
Yeah, but you plan to.
Yeah.
Most of the rest of your laterals will perf approximately 500 feet to the west of that wellbore.
Yes.
Okay. And just note, I should have probably asked the question of you. There is one Albert well that is a Three Forks well. That's the middle one of those easternmost wells.
That's right. That's right. I'd say, we've been planning 500. We might scoot it a little bit closer. I'd say 300 to 500 feet from that parent well.
And the reasoning for that is concerned depletion, or what's the reasoning for the offset?
Yeah, it's just depletion.
Looking at your E5, table 2, I guess, the current parent EURs, A and B look like they're projecting in the 375-400 range, but the 4 wells on C end up, closer to 300 per?
Yes, we have. I have the actual numbers here on a different screen, but they range from, I think the highest is 429, and that's the well going kind of down the middle of the unit, and the worst well is at Three Forks well. I have it at 193.
And are the other 2 Middle Bakken wells similar to each other?
Yeah, one's at 357, one's at 320.
Okay. And then your table 3 there, the hypothetical parent EUR. Can you go through how you came up with the 1760 on that again?
Yeah, absolutely. So we're planning on drilling 4 new wells, kind of in that upper unit. There's already 1 well in each of those units. So I'm assuming 5 wells would be our base development plan, 5 total wells. I took our 440, which is our estimated EUR for those 2.5-mile wells, and then I converted it to a 2-mile EUR. So that's how I got the 352. So 5 base sticks plus 350 or times 352 for each of those 6 EURs gets you to the 1.8 million barrels hypothetical total EUR.
And the 5 sticks that you're using, that would be based on the laydown development you're proposing, or if you
is
horizontal stand-up wells?
You could kind of say, well, this table, it's all based on stand-up wells. I converted everything to 2-mile stand-up to try to make it less confusing for me, anyway. And so when I say 5 wells, you could look at it either way, stand-up or lay down. I'm just saying the way I think of it, there's already 1 well in each DSU. We're going to add 4, so that's a total of 5.
Okay, so it kind of works out either way, whether you look at it as a hypothetical 5 wells total in the stand-up 1280s, or if you take your laydown development and break it up. Okay.
Yeah, you could look at it either way.
And I guess looking at table 7, the final table there, you do end up having more total EUR coming off of tract C, or the existing Albert 1280.
That's right. I think it's mainly because there's three pretty highly densely drilled wells on the eastern side of the Albert section. We're not planning on drilling at that sort of density. You can kind of see what happened. The middle well is just quite a bit worse than the others. And I'm sure it didn't make money.
So that density that we see on the east half of C is, I guess, sounds like it's too dense for economic wellbores.
That's right. Yeah. From what we're modeling anyway.
Okay, thank you.
Yep, you're welcome.
Also looking at Exhibit 5, you have a table down in the right-hand corner. I just want to make sure I understand what this is showing. So are you saying here that 10 2-mile stand-up wells is equivalent to 8 2.5-mile laydown wells in this scenario? And so by using this laydown spacing, you end up needing 2 less wells, correct?
Yes, that's right.
Thank you.
That concludes our hearing for case number 32650. Case number 32651, application of Devon Energy Williston LLC for an order amending the applicable orders for the Camp Bakken pool to establish 2 overlapping laid-down 2240-acre spacing units described as the east half of section 17 and all of sections 14, 15, and 16, Township 152 North, Range 101 West, and the east half of section 20 and all of sections 21, 22, and 23, Township 152 North, Range 101 West, McKenzie County, North Dakota, and authorize 5 horizontal wells to be drilled on each such unit, or grant such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Devon Energy Williston LLC, and same 3 witnesses for this case.
They're still under oath.
And Katie, again, L1 on this one, identify the area and the spacing units you're asking for.
Yes, Exhibit L1 is a regional locator map zooming into McKenzie County, showing our proposed 2 overlapping 2,240-acre spacing units. The first comprised of the east half of section 17 and all of sections 14, 15, and 16. And the second comprised of the east half of section 20 and all of sections 21, 22, and 23. This is all in Township 152 North and 101 West.
Sure. And moving on to L2 then, again, we have similar issue and concept as the last case, but we're overlapping existing stand-ups with the laydowns. Can you identify those in the working interest?
Yes, so same concept. We do have 4 existing stand-up 1280-acre spacing units, all operated by Devon. From left to right, we have the Dale spacing unit comprised of sections 17 and 20, where Devon owns about 57% working interest. Then we have the Abelman State spacing unit comprised of sections 16 and 21, where Devon owns about 55% working interest. Next in green, we have the Hilly spacing unit comprised of sections 15 and 22, where Devon owns about 60% working interest. And then lastly, we have the Abelman DSU comprised of sections 14 and 23, where Devon owns about 53.6% working interest.
Okay. And then moving on to L3, again, we have sort of a same issue where existing development dictates that, we don't have a full section on the west end. So walk us through with this one again, kind of how you'd allocate production from the wells.
Yes, so again, Devon plans to allocate production from the overlapping 2,240-acre spacing unit proportionately to the underlying pooled 1,280-acre base DSUs. So just kind of walking through the fractions here. The Dale DSU will, we will not be including the east half, or I apologize, the west half of that base DSU in our development plans. So we are contributing 320 out of the 2,240 acre overlapping spacing unit, which comes out to be a little over 14% of the total. And that 14% will be shared proportionately with all of the owners in the Dale DSU. And then moving on to the Ableman State, the Hilly, and the Ableman DSUs, each of those will contribute 640 acres to the total overlapping DSU, and that comes out to a little over 28% for each of those. And in all three of those cases, that 28.57% will be shared equally amongst the owners in each of those DSUs. So that comes out to about 14.285% allocated to each of those sections. That's 16, 21, 15, 22, and 14, 23.
Okay. And then L4, I mean, just take us through that. Same concept, though.
Yes, same concept. Production from the overlapping 2,240 acre spacing unit will be allocated proportionately to the underlying pooled 1,280 acre base DSUs. Again, in the Dale DSU, we're contributing 320 acres out of the total 2,240 acre overlapping spacing unit, which is about 14.28%. That 14.28% will be shared amongst all of the Dale DSU owners equally. Another way to think about that is there'll be 7.14% in section 17, and then 3.57% in the west half of section 20 and 3.57% in the east half of section 20, in total being 7.14% to section 20. Same concept for the remaining tracts contributed in the Ableman State, the Hilly, and the Ableman DSUs. Those will each be contributing 640 acres out of the total. So each of those will be allocated about 28.57%. And that total will be shared amongst all of the tracks in those base DSUs.
Okay. And then looking at L5, just kind of summarize for us how it would look once, it's all developed.
Yeah, so Exhibit L5 shows both of the overlapping 2,240 acre spacing units. The first depicted as A and the one in the south depicted as B. And the chart below, again, just walks through an example of how ownership is calculated using the allocation percentages and the ownership in the underlying pooled base DSUs that we discussed. So for example, Unit A, if you look at starting with Section 14, Section 14 is part of the Ableman DSU comprised of Section 14 and 23. That contributes 640 acres out of the total, being about 28.57%. We multiply that percentage times Devon's interest, pooled interest in the underlying Ableman DSU, which is 54%, and that yields the proportionately reduced Devon working interest for that tract. So we go through the same steps for all of the other tracts contributed to Unit A and total them together to get about 56% working interest in the overlapping 2,240 acre DSU. We'll do the same thing for Unit B, and again, this will be the same interest totals because we are essentially splitting these base DSUs in half.
Yeah, and again, Katie, the reason you're allocating in this manner, that's to ensure that all owners receive their just and equitable share of production.
Yes, and that is correct, and I think I mentioned it previously, but not on this one. So this ownership example would work for any owner, whether they're a mineral owner or a working interest owner, due to the underlying pooled units. So the same calculation steps would apply.
Sure, and that's to ensure that their crowd of rights would be protected.
That's correct.
Okay, and then once again, just same as the previous case, we've got a similar issue where on the west half of 17 and 20, you've got, some existing wells that, that you can't cross. But, those wells would stay, on their same allocation and production. So all of the owners in 17 and 20 would share in that production from those existing wells on the west half of 17 and 20.
Yes, that's correct.
I have no further questions after the land exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right. Drew, let's look at G1. Can you describe the structure underlying the spacing units?
Yeah, so the structure on top of the Bakken is deepening from west to the east. As you can see the contours as those lines get deeper to the east. Again, we're looking at the within the red outline here in our type log, which is the Williams 2536 1H, is there in that very southeastern corner highlighted there.
Yep. So let's look at the next exhibit, G2. What are you showing us on that type log?
Similar type log showing triple combo, which is the gamma ray in the first track, resistivity in the second track, and then bulk density in the third track. And here we can see the thickness of the reservoir, the middle Bakken at 36 feet, highlighted by the blue arrow.
Okay. I have no further questions after the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right. Mark, let's look at E1. How would you propose to develop these two 2240s?
Okay, we'll have 2 pads on the eastern side. We'll be drilling 5 wells from the northern pad and 5 wells from the southern pad. These wells will be about 3.5 miles long. They're all Bakken wells, and all the parent wells are Bakken wells also.
Okay. And then on E2, how would you propose to drill and complete the wells?
Again, this is a typical wellbore design for us. So surface casing 9 5/8 set at 2200, intermediate 7-inch set at 10,500, and then cemented liner, which would be 4.5 set at 28,000 feet, 1,000 pounds per foot completion, about 200-foot stage spacing.
Okay. And then looking at E3, describe for us the reservoir characteristics on these spacing units.
Okay, spacing units 2240 acres. Net pay is 36 feet. Porosity 7%, water saturation 48%, gives us an estimated oil in place of about 14 million barrels. The EUR for each of these wells is about 786,000 barrels, again, 3.5 miles. That gives us an estimated recovery factor per well of about 5.5%.
Okay. And then how about the economics for these spacing units on E4?
At the initial rate will be almost 2,600 barrels a day is what we're modeling. EUR oil again is 786. EUR gas is about 2.5 BCF. EUR equivalent is about 1.2 MBOE or MMBOE. For the economics, oil price $60 flat, gas price $3.50 per MCF. $10 million to drill and complete, so total capex will give us an NPV10 of about $5.7 million, 46% rate of return, and a payout of about 2.2 years.
Okay. And then on E5, again, Mark, same as last time, in order to get these units approved, we've got to demonstrate the correlative rights will be protected. We kind of did that again with Katie, but can you kind of walk us through here that same exercise on these two 2240s?
Yes, so we have 4 units this time. The Dale unit, which is A, Abelman State, which is B, the Hilly, which is C, and the Abelman, which is D. The current parent EUR, in the Dale unit, we have 2 wells. The total EUR is about 1.2 million barrels. Unit B, we also have 2 wells. Total EUR is about little over 800,000 barrels. We have one well in the Hill unit, about 500,000 barrels, and we have one well in the far eastern Abelman unit, which is about 647,000 barrels. So the hypothetical parent EUR, we're going to use 6 total wells this time. So we have the 5 new proposed wells plus roughly 1 parent well in each DSU will give us 6 total. We convert the base EUR, which is 786,000 barrels per well. We convert that down to a 2-mile, which will take us to 449 barrels for an equivalent 2-mile well. So we'll have 6 of those in each unit. 6 times the 449 gives us about 2.7 million barrels per unit. That's the hypothetical total parent developed EUR for each unit. Going to number 4, we have the remaining undeveloped parent unit reserves. That's simply going to be 3 minus 2. So those are the undeveloped reserves that are yet to be recovered. So now we'll look at equivalent 2-mile sticks. Using Katie's allocation, in the Dale unit, we'll have 2.5 sticks. B unit will have 5, C unit will have 5, and D unit will have 5. So that equates to about 14% of the sticks in unit A, and then about 29% in each of B, C, and D, for a total of 100%, or a total of 17.5 sticks. Next, we'll go to the modeled undeveloped unit reserves. So those are our hypothetical sticks or equivalent sticks. So in A, we have 2.5 sticks multiplied by the 449,000 barrels per well, gives us the 1.1 million barrels modeled undeveloped reserves. And then unit B, C, and C are the same. That'll be 5 sticks, hypothetical sticks, 2-mile, times that EUR, which is 449, gives us the 2.2 million barrels. So 7, that's 2-mile modeled total EUR per unit. So in A, we have the 1179, that's from table 2, added to table 6. That's 1123, gives us a total of 2.3 million barrels. Now we'll go over to B. We'll take the 814 from 2 plus table 6 table. That's 2.2. That'll give us 3.1 million barrels. And then the same for C and D. Just taking table 2 plus table 6 gives you that total. That kind of summarizes the future development based on, of course, we're planning on drilling 3.5-mile wells, but this is all converted to 2-mile stand-up sticks, stand-up units.
So, in your opinion, Mark, then would the correlative rights of all owners be protected with the development and allocation method that we previously described? Excuse me.
Yes, I think it will be within reason.
Mm-hmm. And the data that you provided here supports that or confirms that in your mind?
Yes, in my mind it does.
And then additionally, this plan of development, in your opinion, would that prevent waste and prevent the drilling of unnecessary wells?
Yes, it will.
Okay. I have no further questions. I'd offer the engineering exhibits and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Mark, on your exhibit 5, I guess. I guess I'll start with table 2. The Dale unit, its 2 existing wells, which are not to be included in the new spacing unit or spacing units, or that acreage isn't to be included. Those look like they're producing or projecting somewhere along the lines of a 600 barrel or 600 per well EUR.
Yes, that's roughly right.
If I go over to track B, which also has 2 wells in it, those look like they're on the order of 400 per well.
Yes.
Is there any reason why those 2 wells in B seem to be underperforming the other stand-up wells drilled in each of the tracks?
Yes, that's a good point. I need to explain that a little bit. The 2 wells in the Dale unit, one of them was drilled in 2024. It's making about 100 barrels a day. It's worth about $4 million to us on a gross basis. And the other well, the parent well, was refracked at the same time. So it was refracked in 2024. It's currently making about 200 barrels a day. It's worth about $5 million gross to us. We do not want to risk damaging those wells in any way, risking the reserves on those wells in any way. So that's why we chose not to drill through those wells. The other wells, the other parent wells in the Abelman State, in B, C, and D, those are parent wells that I guess one started producing in 2010, 2012, 2011. Those each are making roughly 20, 30 barrels a day. So their value is significantly less. So we will risk, those well bores when drilling through them, but the risk, I guess the value is much less on those wells compared to the ones in the Dale unit.
Which one of the Dale unit wells is the original well bore?
The original one, so there's 2 wells in that unit. It's the one on the eastern side.
The one with the curve at the southern end?
Yeah, that's right.
And then, sorry if I missed part of the explanation, but is there a reason the Abelman wells are only going around 400 EUR instead of up in the 500-600 range that the other wells seem to be projecting?
Yeah, they're older wells, so smaller completions. That's the main reason. Smaller completions, wider stage spacing. I'm not sure if they're plug and perf or not. I kind of doubt they were, but just very basic reason, older completions.
Okay. And at this time, you don't have any additional development plans for the west half of 17 and 20 or the A unit?
Not at this time for the Dale unit. Those wells are still producing a lot of oil, so we prefer to kind of stay away from those. In the future, it wouldn't surprise me at all if that was further developed. But for right now, we have no plans.
Okay, because I'm currently looking at table 7 on your exhibit, and that Dale unit looks like it projects 2,300. The other ones are up in the 2,750 to 2,800, and that looks like it appears to be about your 449 or 450 barrel 2 mile stick EUR projection short of the other ones.
That's right. Yeah, I think there is some undeveloped reserves that could be captured in the future in that half DSU.
Okay. And I guess in the southern spacing unit here, the southernmost wells, I think you might have touched on this already in your other answer, but it looks like you plan to cut those short of the existing Dale curve.
Yes, and that's the same reason. We just don't want to risk damaging that wellbore. It's too valuable to us.
How far off do you plan to short those wells?
It'll be similar to the other one. So roughly, 500 feet, somewhere in that range.
Okay. I guess I probably should have asked this in the previous case, but your plan for all the existing wells that you plan to cross, do you intend to continue producing them at this point?
We do intend to. We have had problems cleaning them out, but the intention is to, right now, the intention is to clean them out and try to get them back online.
And if that's a problem, you would consider plugging and abandoning them?
Yes.
Okay. Okay, thank you.
Yep, you're welcome.
On E5, again, I just want to make sure I understand this correctly and to highlight it. So that bottom right table is showing that with this 3.5 mile development with 10 wells versus if you developed with stand-up 2 mile wells, it would require 17.5 wells.
Yes, that's right.
Thank you.
That concludes our hearing for case number 32651. Case number 32652, application of Devon Energy Williston LLC. This case has been dismissed. That concludes our hearing for case number 32652. Case number 32653, application of Devon Energy Williston LLC. This case has been dismissed. That concludes our hearing for case number 32653. Case number 32654, application of Devon Energy Williston LLC for an order amending the applicable orders for the Painted Woods Bakken Pool to establish 2 overlapping laydown 1920 acre spacing units described as sections 4, 5, and 6, and sections 7, 8, and 9, Township 133 North, Range 103 West, Williams County, North Dakota, and authorize 5 horizontal wells to be drilled on each such unit. For granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Devon Energy Williston LLC. I'm going to have 3 witnesses testify in this case. It'll be Brian Carlson, Sarah Jan Kuska, and Scott Caldwell. And just a heads up, Mr. Examiner, Devon also has an additional case that 370 that was on the supplemental docket that we'd requested to get bumped up and heard after this one. And those same 3 witnesses will be testifying in that case as well. So.
I'll call that next.
Okay.
Okay, Mr. Carlson.
Yes.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter and any subsequent matter today, which true and correct to the best of your knowledge and belief?
I do.
Brian, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
My name is Brian Carlson. I'm employed as landman by Devon Energy, 333 West Sheridan Avenue, Oklahoma City, Oklahoma, 73102.
And Brian, have you previously testified before the commission?
I have.
Have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the land matters associated with the proposed spacing units?
I am.
I would move the testimony of Mr. Carlson be received as that of an expert.
Motion granted.
And Brian, let's look at L1. If you can describe the area we're looking at and identify the spacing units.
Yes, on Exhibit L1 is our regional locator map, zooming into the 2 spacing units that we refer to as the Chevelle, which is comprised of sections 4, 5, and 6 of 153 North, 103 West, and the Coronet spacing unit comprised of section 7, 8, and 9, 153 North, 103 West.
Okay. And looking at L2, Brian, can you take us through the working interest in those, the 3 stand-up 1280s that are being overlapped?
Yes, on L2, it shows existing spacing units. I'll start from the left and go to the right. In the red spacing unit, the hard scrabble 5, comprised of sections 6 and 7, where Devon has approximately 91% working interest. In the middle, the hard scrabble 9, comprised of sections 5 and 8. Devon has approximately 68% working interest. And on the east end, comprised of sections 4 and 9, and on the hard scrabble 8, where Devon has 86% working interest.
All right, and then moving on to L3, Brian, the that northern 1920, what would be your working interest there?
Yes, on the northern 1920, our working interest would be approximately 83.73%.
Okay, and then L4, that southern 1920.
And on L4, very similar working interest would be at 83.73% working interest.
Okay. I have no further questions. I'd offer the land exhibits.
Exhibits are admitted. Any questions from the staff?
Brian,
yes.
I guess looking at your, I'll go with L2. Since each of the proposed 1920s doesn't encompass the entirety of the lands in the 1280s, how do you anticipate allocating production from the proposed 1920 wells?
We'll allocate to the base spacing units. So yeah, basically they'll be shared across all 6 sections equally.
So
between the
production from 4, 5, and 6 would be allocated to 4, 5, and 6, and then half of that allocated oil would be then dispersed between the corresponding section in each of the 1280s.
That is correct.
And then vice versa.
Yep.
Okay, thank you.
Ms. Jankuska.
Good afternoon.
Do solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Sarah, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
My name is Sarah Jankuska. I'm a geologist working for Devon Energy at 333 West Sheridan Ave, Oklahoma City, Oklahoma.
And Sarah, have you previously testified before the commission?
I have.
Have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the geology underlying the proposed spacing units?
Yes, I am.
Yeah, I'd move the testimony of Ms. Jankuska be received as that of an expert.
Motion granted.
And Sarah, let's start with G1. Can you describe the structure underlying these spacing units?
Yes, this is a structure of the Upper Bakken with 10-foot contours labeled on there. We have producing wells in the area, or drilled wells in the area, are also on the exhibit. We have a gentle dip down to the southeast, and then the type log on the next exhibit we'll see it's highlighted up there in the north, that Abe 30313H.
Sure. And then move on to G2 if you would, and tell us what you're showing on that type log.
So this is just our standard gamma log on the left, our resistivity in the middle, and then our porosity logs on the right. We have our different tops labeled from the Upper Bakken down to the Nisku, and we'll be targeting the Middle Bakken here.
Okay. And that's all the questions I have. I would offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? Mr. Caldwell.
Yes, sir.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Scott, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes. My name is Scott Caldwell, employed with Devon Energy as a reservoir engineer, and work address is 333 West Sheridan Avenue, Oklahoma City, Oklahoma, 73102.
And Scott, have you previously testified before the commission?
Yes.
And have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the engineering matters associated with the spacing units?
Yes.
I would move the testimony of Mr. Caldwell be received as that of an expert.
Motion granted.
And Scott, let's look at your E1. How would you propose to develop each of these two 1920s?
Yes. So referencing E1, I'm laying out the proposed directional well plot, which has the proposed 1920 spacing units with the proposed Middle Bakken wells in blue, which will be 3 milers. Right now planned with surface locations in the west in section 6 and 7, and be drilling to the east with 5 wells planned in each DSU. And in this DSU, we do have 3 existing producers that we've talked about going from north-south, and we will plan to drill these wells. Right now, the plan is to have 2 rigs, 1 on each pad, to drill these wells. First pad starting around December of 27 and the second around February of 28. And to complete these well bores completions, we will complete them just like normal. Nothing as we complete across the crossing wells. We won't adjust anything. We'll complete them like we normally will. Plan would be to bring the crossers back online once we complete the completion and bring the new wells online.
Okay. Looking at E2, what would the wells that you're proposing, how would they be drilled and completed?
Yeah, so this is a typical 15K wellbore schematic where we'll run surface casing 9 5/8 to estimated 2,200 feet. Then we'll run an intermediate casing 7-inch to around 11,000 feet, and then a cemented 4.5-inch liner to TD, which would be estimated around 26,500 feet. And we will plan to be 150 feet off section line for first production, and then our normal 1,000 pounds per foot and 24 barrels per foot completion design, which for this would we'd be looking at an estimated 75 stages for this completion.
Okay, and let's go to E3 then. Can you summarize the reservoir characteristics here?
Yes, so producing zone Middle Bakken with an estimated TVD of just under 10,700 feet, net pay of 28 feet, porosity of 6.7%, and a water saturation of 50%.
Okay, and then the economics, sorry, E4.
Yes, so looking at the economics, we'll start off with these are all based on a single well type curve for the reserve basis. The type curve is built off of initial rate of 1,550 barrels of oil per day with a 67% decline rate, with a 1,200 SCF per barrel initial GOR, which would result in a EUR of 643 MBOs and 1,088 MBOEs. And then tying that into the economics, this was run at an oil price of $60 flat and a gas price of $3.50 flat, with a well capital of $8.4 million, working interest of 100, revenue at 79, delivering an NPV10 of $3.6 million with an internal rate of return of 49% to pay out in 2.2 years.
Okay. Scott, in your opinion, if the commission were to approve these two 1920s, would that prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes.
Okay. I have no further questions on offer engineering, exhibits, and gas capture plan affidavit.
Exhibits are admitted. Any questions from staff?
Scott, just a couple things real quick. The existing well bores, you plan to continue producing them?
Yes, we will plan to bring those back online once we complete the new wells and bring those on.
Okay. And then you're looking at E1 versus G1. The lateral or the well bore in section 4 and 9, are there two existing legs on that, or is one of them abandoned? What's the deal going on there?
So let's see.
G1 indicates there's two legs. That's what it looks like on my map, but your E1 only has one of the two.
I believe one of them was abandoned.
Yes, I am just showing the producing wellbore, so I think that is correct. There was an abandoned lateral there.
Okay. Were both of those Middle Bakken targets, or was one of them Three Forks target?
They were both Middle Bakken.
Okay. And I guess the other two wells, the one at 5 and 8 and 6 and 7, also Middle Bakken target?
Yes.
Yes.
Okay, thank you.
That concludes our hearing for case number 32654. And I'll jump ahead to the supplement. Call case number 32370. Application of Devon Energy Williston LLC for an order amending the applicable orders for the Sugar Beet Bakken Pool to establish an overlapping laydown 1280-acre spacing unit described as section 17 and 18, Township 152 North, Range 103 West, Williams County, North Dakota, and authorize 5 horizontal wells to be drilled on such unit or grant such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Devon Energy Williston LLC, and same three witnesses here.
They're still under oath.
All right. Brian, let's look at L1. Can you identify the spacing unit you're requesting?
Yes, this is the regional locator map zooming into the 1,280-acre laydown spacing unit comprised of sections 17 and 18, 152 North, 103 West.
And then Exhibit L2, what's your working interest look like in that spacing unit?
Our interest in that spacing unit is approximately 50.45%.
Okay. I have no further questions. That offer the line exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Sarah, looking at G1, can you describe the structure underlying this spacing unit?
Yep. So we have a structure on top of the Middle Bakken. Again, we have 10-foot contour intervals displayed, and we have a gentle dip down to the southeast here as well. I also have all existing well bores displayed on this map, and then highlighting the Anderson 6-1 type log with the logs displayed in the next exhibit.
Okay. And let's move on to that then G2. What are you showing in the well log?
So we have our standard gamma ray in the left, our resistivity in the middle, and then our porosity logs on the right. And then we have the tops from the upper Bakken down to the Nisku as well, and then TBD is labeled. We will also be drilling Middle Bakken here.
All right. I have no further questions. I'd offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Scott, let's look at E1. What do you anticipate at this time development looking like on this 1280?
Yes, currently the plan as laid out here is to drill this with 2 4-mile U-turn wells. Those U-turns will currently start with a surface off of our Finn pad to the northwest, identified on the map. And then we will drill these wells, 4 wells per section spacing. The plan will be to drill the one slot, and on both of these wells, the apex of our curve, we're going to keep it within the 500 foot from the section line, and then we will keep the perforations at the bottom hole 150 from the section line. What we're showing on the map is existing Middle Bakken wells in the black solid line. We do not have any existing Three Forks wells in this DSU or really in this area. And of course, the proposed Middle Bakken wells are in blue.
Okay. And Scott, let's move on to E2. This 1280, it sort of fits kind of a development pattern on some spacing that you'd recently brought to the commission, and just maybe walk us through kind of how this area all fits together with the 1280 that you're requesting.
Yes. Yeah. So on this map, it's a similar setup as far as what's shown on the map. The black solids are existing Middle Bakken. What we've outlined in green are the two DSUs that we brought forward last December 17th for spacing. And then what we're showing in our red is the DSU that we're discussing today. And then in the blue outlines are the other DSUs offsetting that kind of complete our development of this area. So what we're laying out is a plan where we were able to drill two 4-mile DSUs, two 3-mile DSUs, and then this section 17 and 18 as a 2-mile, which we're planning to develop with 4-mile U-turns. And this is it's a nice DSU in the fact that it's kind of rare where you don't have any existing production. So for a U-turn, we're definitely excited about that opportunity. And so this will allow us to develop this as efficient as we can across the board.
And you described a little bit, when you're talking about development, but how would the wells be drilled and completed? Exhibit E3.
Yes. So this is looking at a typical one of our 4-mile 20K lateral 3-string Middle Bakken casing designs. And so for that, we'll set surface casing 9 5/8 around 2,200 foot. Similar setup with our intermediate 7-inch casing around 11,500, and then we'll continue to run a cemented 4.5-inch liner at estimated 32,000 foot measured depth, and then we'll do our normal completion, or typical completion, which is about 1,000 pounds per foot and 24 barrels per foot. And with our stage spacing and the lateral length, we'll have about almost 100 stages for this completion.
Sure. Moving on then to the Exhibit E4, summarize the reservoir characteristics for us.
Yeah, so just to reiterate, this will be a Middle Bakken producing zone with a TVD of 10,928 feet, net pay of 26 feet, 6.5% porosity, and 45% water saturation.
And then how about the economics, E5?
Starting off with the basis for the reserves, we'll have a type curve with initial rate of 2,200 barrels of oil per day with a 68% initial decline, which would deliver an EUR of 894,000 barrels of oil and an EUR of 1.4 million barrels of oil equivalent. For the economics, we continue to run this with a $60 flat oil, a $3.50 flat gas with a $10.467 million well cost, which would deliver an NPV10 of $7,706,000, an internal rate of return of 49%, paying out in 2 years.
So, Scott, in your opinion, if the commission were to approve the 1280 to allow for that development, would that prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes.
No further questions. I'd offer the engineering exhibits and the gas capture affidavit.
Exhibits are admitted. Any questions from the staff?
Scott, using Exhibit E1, kind of just some general questions, but has Devon had a step out similar to this in which they've drilled a U-shaped lateral yet?
So, kind of tackling that first part of that question on the step outs, we have drilled step outs as large as 8,500 foot on some Missouri wells over. So on the step out basis, we have drilled larger step outs than this. For U-turns, we in the Williston have not drilled a U-turn yet. We have several that we've got planned coming up. We're anxiously trying to get our first one underneath us. So we've drilled larger step outs, but we have not drilled a U-turn yet.
Okay. Any concerns from modeling as far as torque and drag and getting completion down to depth and so on?
Well, we're still kind of working through a lot of that, I'd say, analysis on the torque and drag, but, you know, kind of related to the just, you know, breaking it up on the drilling aspect. You know, I guess our biggest concern would be, you know, obviously getting casing down. We really haven't ran into any issues getting casing down in any of our wells up to this point. There's things that we can do to mitigate that are drilling wise, we feel pretty confident about. On the completions, yeah, the biggest probably concern on the completions on these longer laterals, particularly, it would be just, you know, getting drilled out to bottom. So we definitely need to investigate that a little bit more. On a U-turn basis, we do have several U-turns in the company, just in a different basin. So we have a lot of data set there. And then of course our team, they're working with the other operators in the Williston Basin that have done several of these. So we're kind of pulling all that plan together to make sure that, you know, we have the best plan go forward. And so right now from them, this is we feel good about it, but we just have not executed one yet.
Is it Devon's current plan to drill both of the laterals batch drill style, or are you going to drill one of them, evaluate, and decide from there?
I think our current plan would to drill both consecutively. I think part of that is, you know, we are mindful of, we will have other tests before this one that'll give us a good feel for, you know, a step out with a U-turn. We will have tests before this that'll be 4 mile plus laterals. So I think we'll get a good data point there. So when we come to this one, we'll really be looking forward to being able to minimize and be efficient. And since we're coming off that existing pad, we would definitely want to drill these at the same time and be able to bring them on so that we're able to, you know, minimize the capital, you know, any additional capital spend, and then just downtime on production from that fin pad.
What's your current spud timing?
So right now, we don't have it officially on the schedule. We're trying to work it in. We're targeting 2028, and just really that's giving us time to see a couple of our other U-turn projects that we do have scheduled to be executed and get just those initial results. So right now, like, we're targeting 2028.
This kind of, again, I understand, so a generic question, but based on what you're stating, gathering information from your other U-shaped drilling, is there a possibility that from that information that Devon may decide to drill this in a different manner?
I think there's always so there's risk, you know, there's definitely risk here. There's a lot of risk with other pads we do. So we definitely look at alternatives. What's a fail case look like if something does pop up like that would determine that, you know, we would need to pivot. I think right now, as talking through that, you know, we feel really good about the northernmost U-turn, which would be the 1 slot and the 3 slot. So the 1 slot drilling into the 3 slot is the bottom hole, has the smaller step out. So I think what we feel really good about. The other one's just a little bit longer. If we saw something on that first one that gave us some pause, we still have the opportunity where we could drill 3 or 2 more, just standalone east-west 10K. Those are still economic for us. So right now, the plan that we're laying out is the one that delivers the best value, but there is still an economic option to go another route if we do determine that there's more risk than what we originally thought.
Okay, thank you.
You're welcome.
Scott, along the lines of what, at least partially along the lines of what David's questioning just was, the actual capture application is for 5 additional wells on the 1280. Your plan at this time is the 2 wells. Are you asking for the 5 wells to remain in place, or
would you anticipate just needing the 2 wells on the spacing unit?
I think, yeah, kind of tying along with what we were just kind of discussing, the 5 wells originally kind of gives us a little bit of flexibility just based on timing. Assuming that we were drilling originally, the plan was, to drill just 2 mile wells instead of the U-turn. And so 5 wells gives us an opportunity to pivot if, the price changes or costs change. And, we see that, hey, we really can drill 5 at this point and get the value that we want. 4 is kind of the base case for us. But with the U-turns, 4 is kind of the optimal in this DSU for us. I would say short answer to that is I wouldn't recommend pivoting, because just for the reason we were talking about, like, as we're still evaluating this is the option we want to go with and we're planning for. But if we did need to pivot, that would still give us the option to go to 4 or 5.
So typically, if we don't have a development scenario along those lines, we would only issue the order for the number of wells being proposed in the application and in the materials we were presented. Do you want to supplement the record with what it might look like on a 5 well pattern if that kind of pivot does seem to be needed?
I can definitely do that. If it allows us to continue to have that option.
I think that'd be recommended.
Okay.
And then just a couple quick questions on your plan for the completion. You indicated, I think, in your original testimony, you were going to stay 500 feet off of the easternmost section line when you were drilling the curves, correct?
Yes.
Do you anticipate stimulating around the entire curve portion?
Current plan is to stimulate the entire curve, yes.
Okay. And will you do anything specifically in that area where the 2 well bores would effectively cross over each other's blank a stage to avoid directly impacting the other well bore?
We are looking into that. I don't think right now, I wouldn't say that we're necessarily going to eliminate stages. I think what we're kind of considering is do we need to modify some of our architecture and or reduce some of the size on some of those stages. But it would only be, it may be 1 stage or 2 stage. It's not going to be a large portion of the curve and the crossing.
Okay. I guess one last question. I think there's 2 existing 1920s that were previously established that included those lands to the north, looking at your E2. I think they included 6, 7, and 18, and 5, 8, and 17. I'm assuming at this point you want those terminated?
Yes, that was our older development plan prior to this update that we're showing today.
Okay, thank you.
Wade, is April 1st long enough to supplement the record?
Yeah, Scott. So, the development map that would show, how it might look, if you had to go with, the more traditional laterals and up to 5. Is April 1st enough time to get that put together?
Yes, yeah, for sure, definitely.
Yep.
Okay. The record will remain open in this case until April 1st. That concludes our hearing for case number 32370. Moving back to the main docket. Case number 32655. Application of Whiting Oil and Gas Corp. for an order amending the applicable orders for the Mondack Bakken Pool to establish 3 overlapping laydown 19-20-acre spacing units described as sections 1, 2, and 3, section 4, 5, and 6, sections 10, 11, and 12, Township 147 North, Range 1 to 3 West, Mackenzie County, North Dakota, and authorized 4 horizontal wells to be drilled in each such unit, regarding such other relief as may be appropriate. I will note that the spacing unit consisting of sections 1, 2, and 3, 10, 11, and 12, Township 147 North, Range 1 to 3 West has been withdrawn from this application. All interested parties, please come forward.
Yeah, thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Whiting Oil and Gas Corp. Three witnesses: Greg Sandberg, John Prim, Tyler Smith.
Mr. Sandberg,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, I do.
Greg, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Greg Sandberg. I'm a landman with Whiting Oil and Gas Corp. And 1001 Fannin, Suite 1500, Houston, Texas, 77002.
And Greg, have you previously testified before the commission?
Yes, I have.
Had your qualifications received as that of an expert?
Yes, they were.
And are you familiar with the land matters associated with the proposed spacing?
Yes, I am.
Okay, I'd move the testimony of Mr. Sandberg be received as that of an expert.
Motion granted.
Greg, let's look at L1. Can you identify the spacing unit for us?
Yeah, the spacing unit there is sections 4, 5, and 6, Township 147 North, Range 103 West.
Okay. And then on L2, what's your working interest?
L2 there, we've got a 95.41% working interest.
Okay. I have no further questions off the land exhibits.
Mr. Admitted. Any questions from the staff? Mr. Prim,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes.
John, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Yeah, my name is John Prim. I'm a geologist for Cord Energy, parent company of Whiting Oil and Gas. Business address 1001 Fannin Street, Suite 1500, Houston, Texas 77002.
And John, have you previously testified before the commission?
Yes,
Have you had any qualifications received as that of an expert?
I have.
And are you familiar with the geology underlying the proposed spacing?
Yes.
Okay, I'd move the testimony of Mr. Prim be received as that of an expert.
Motion granted.
And John, let's look at G1. Can you describe the structure underlying the spacing unit?
Yep, G1 is showing Upper Bakken structure map underlying the proposed spacing unit, showing that the Bakken formation is present across the area of interest and is dipping off to the east, approximately from 8325 subsea TVD to negative 8400 subsea TVD.
All right. And then G2, what do you show on the ISOPAC?
G2 centered over the same area. It's showing the middle Bakken thickness in contour intervals 2 feet, showing an approximate average thickness of 24 feet across the proposed spacing unit.
And finally, moving on to G3, take us through the type log.
Yeah, G3 is a triple combo of the Conoco Federal 6-1. It's a type log located approximately 3 miles to the east of the proposed spacing unit outlined on the previous maps, and it's highlighting the reservoir properties we expect to encounter underlying that proposed spacing unit.
Okay. I have no further questions that offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? Mr. Smith,
Third.
you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, sir.
Tyler, can I have you state your name, tell us by whom you're employed in what capacity, and give us your business address?
Yep. Tyler Smith, development engineer for Cord Energy, who is the parent company of Whiting Oil and Gas. Cord's headquarters are at 1001 Fannin Street, Suite 1500, Houston, Texas 77002.
And Tyler, have you previously testified before the commission?
Yes, I have.
You had your qualifications received as that of an expert?
Yes, I have.
And are you familiar with the engineering matters associated with the proposed spacing?
Yes, I am.
Right. I'd move the testimony of Mr. Smith be received as that of an expert.
Motion granted.
And Tyler, looking at E1, how would you develop this spacing unit?
So E1 shows kind of Whiting's plans to develop that 1920 acre unit that consists of 4 3-mile laydown Bakken wells.
Okay. And then moving on to E2, what can you summarize the reservoir data and then take us through the economics?
Yep. So on E2, you can see the reservoir and economic properties on a per well basis. The top table shows the reservoir property used in the analysis. Looking at the middle table, you can see the OOIP to be about 2.45 million barrels per 640 section there. Each well yielding an EUR of around 400,000 barrels. In the table on the bottom, you can see capital investment of around $9 million with a rate of return of positive 28%. all which exceeds Whiting internal metrics.
Okay. So, Tyler, in your opinion, if the commission approves the spacing, would that prevent waves, protect relative rights, prevent the drilling of unnecessary wells?
Yes, sir.
I have no further questions that offer the engineering exhibits.
Exhibits are admitted. Any questions from the staff?
Tyler, on E1, do you have a surface location proposed?
Yeah, we're still in the prelim scouting plans, but most likely on the west side of Section 6. That keeps us off of the U.S. Forest Service. There's an area that we think is pretty suitable for that location.
The wells are going to be batch drilled?
Yes, sir.
And what's your spud?
Don't have a current spud date, but it is on our 4 to 5 year plan right now.
Okay, thank you.
That concludes our hearing for case number 32655. Case number 32656, application of Whiting Oil and Gas Corp. This case has been dismissed. That concludes our hearing for case number 32656. Case number 32657, application of Enerplus Resources USA Corp. for an order amending the applicable orders for the Little Knife Bakken Pool to establish an overlapping stand-up 2560 acre spacing unit described to sections 3, 10, 15, and 22, Township 145 North, Range 97 West, Dunn County, North Dakota, and authorize 4 horizontal wells to be drilled on such unit, regarding such other relief as may be appropriate. All interested parties please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Enerplus Resources USA Corp. Mr. Examiner, I believe we're going to have Prince Eckby testifying land, but John Prim and Tyler Smith again on geology and engineering.
Mr. Eckby.
Yes, sir.
Do you solemnly swear affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, sir.
Prince, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, Prince Eckby, employed by Cord Energy, the parent company of Enerplus Resources USA Corp. Business address is 1001 Fannin Street, Suite 1500, Houston, Texas, 77002.
And Prince, have you previously testified before the commission?
Yes, sir.
Have you had your qualifications received as that of an expert?
Yes, I have.
Are you familiar with the land matters associated with the proposed spacing?
Yes, sir.
Okay, I'd move the testimony of Mr. Eckby be received as that of an expert.
Motion grant.
And Prince, let's look at L1. Can you identify the spacing unit you're asking for?
Yeah, L1 is the regional locator map located in Dunn County there, Township 145, Range 97 West, and sections 3, 10, 15, and 22.
Okay. And then moving on to L2, what's your working interest in that spacing unit?
Yeah, the Enerplus working interest is shown there. It's 87.64%. All other parties have a 12.36%.
And then on L3, just have a breakdown of those underlying spacing units.
Yeah, located in section 3 and 10 there, the underlying 1280, Enerplus has 98.98%, all other parties with 1%. And then southern section there, the 1280, section 15 and 22, Enerplus has 76.29%. The all other parties are 23.71%.
Sure. I have no further questions on off the line exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, John, let's look at G1. Describe the structure underlying this spacing unit.
Yep, so G1's over Bakken structure map. It's subsea DVD contours of 25 feet. It's showing that the Bakken formation is dipping off to the north-northeast from approximately negative 84.75 to negative 85.50.
Okay. And then G2, just briefly describe the isopac.
Yep. G2 is isopac showing that the average middle Bakken thickness is approximately 28 feet thick over the proposed spacing unit.
Okay. And then finally, the type log, what are you showing? G3.
Yep, G3 is type log Lin 2-1H triple combo showing the reservoir properties underlying the proposed spacing unit.
Okay, I have no further questions that offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
Tyler, let's look at E1. How would you propose to develop this 2560?
Yeah, so E1 shows interpost plans to develop that 2560, which consists of four 4-mile stand-up Bakken wells, as well as an additional two 2-mile stand-up Bakken wells in the southern 1280 unit. All wells will be drilled from a new pad location on the south end there.
Okay. And then looking at E2, what can you summarize the reservoir data and then the economics?
Yep, so here we're looking at the 4-mile economics. So in the middle one, you can see the OIP to be 5.4 million barrels per 640 with the EUR of around 978 MBO. And then with an investment of around $11 million and a rate of return of 85%. And I think it might be important to note as well that that Southern 1280 was approved with case number 34665 in the past.
Okay. So Tyler, in your opinion, if the spacing is established for this type of development, would that prevent waste, protect correlative rights, prevent the drilling of unnecessary wells?
Yes, it will.
No further questions. That offer the engineering exhibits and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Tyler, looking at your E1.
Yes, sir.
You have 4 existing middle Bakken laterals on the northern 1280, correct?
Yep.
And only one to the south.
Correct.
I'm not quite making out your legend very well here between colors.
So we have, so I don't know if you can see it, but there's pink. The light pink is the additional 2-mile wellbores that we're proposing in that southern 1280. The reason being is to protect the rights between the north and the south end to make those equivalent.
So you plan to put 2 additional 1,280 acre wells on 15 and 22?
Yes, sir, that's correct.
And do you intend to do that when you drill the proposed 2560s?
Yes, sir, they'll all be drilled together.
On that south end, I guess second 4-mile lateral from the west looks like it's almost right on top of the existing middle Bakken well. Is that how you plan to locate them?
No, it's probably just an inaccurate kind of display of the picture. It will be near it, not on top of it, but it will not be right on top. We'll bend it around a little bit.
Okay. And all of the proposed wells, the 4-mile wells as well as those 2-mile wells you plan to drill will all be middle Bakken targeted?
Yes, sir.
So you'll end up with something like 8 wellbores on the northern 1280 and 7 on the southern?
Let's see, 7 and then 1, 2, 3, 4, 5, 6. That's correct. And the reason being that southern one has cumed 330,000 plus barrels of oil, so we think we can still capture that resource there with the limited number on the south being one less.
Could you provide an exhibit kind of detailing what the EUR for the existing wellbores happens to be, as well as what you're projecting for the 2 new 1280s and each of the 4-mile laterals?
Yep, I can do that. I also have cumes today if you'd rather hear those now, but we can definitely provide the exhibits as well to make it easier for you guys to understand.
Yeah, provide that on the exhibit.
Yeah, that's no problem.
Okay. I guess, do you end up in a similar density to other spacing units in the area if you get up to this density?
I can speak for in the past This was acquired from Enerplus and is very similar to what Enerplus used to do in the area.
Do you anticipate a significant amount of, I'm not asking interference per se, but with the existing wellbores that have been drilled on that northern end, when you drill your 4 mile laterals to the north there, are you going to have depletion problems?
I think depletion will be present, but I don't foresee any issues drilling or completing those wells, if that's what you're asking.
Okay, thank you.
Wait, is April 1st long enough again to supplement the record?
Yeah, Tyler, can we get that by April 1st to have it filed by then?
Yeah, that's no problem.
Okay.
Okay, the record will remain open in this case until April 1st. That concludes hearing for case number 32657. Case number 32658, application of Enerplus Resources USA Corp. for an order amending the applicable orders for the Baker Bakken Pool to establish an overlapping 2560 acre spacing unit described as sections 25 and 36. Township 153 North, Range 101 West, and sections 30 and 31. Township 153 North, Range 100 West, Kenzie and Williams Counties, North Dakota, and authorize one horizontal well to be drilled on such unit and grant such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Enerplus Resources USA Corp. And I think we're back to Greg, John, and Tyler.
They're still under oath.
Okay. Greg, looking at L1, can you identify the spacing unit?
Yes, sir. Locator map there on L1 showing the spacing unit 153-101, sections 25 and 36, and 153-100, sections 30 and 31.
And then L2, what's your working interest in that spacing unit?
L2, we have about a 53.3% working interest in that section line unit.
Okay. And then briefly on L3, just take us through the breakdown of those underlying spacing units.
Yes, sir. The state up there of 25 and 36 has about a 29% working interest. The two laydowns, the northern one being 29 and 30, is 66.46%. And that southern laydown of sections 31 and 32 is 88.16% interest.
Okay. I have no further questions that offer the line exhibits.
Exhibits are admitted. Any questions from the staff?
Greg, being as you're currently, and I guess I'll look at L3.
Yes, sir.
Your proposed spacing unit doesn't contemplate taking in the entirety of the 1280s on the eastern side of this 2560. Can you elaborate on how you would anticipate allocating the oil from the well on the 2560?
Absolutely. Yes, we would plan on allocating the production to that east half of the proposed unit to both of the laydowns, so that sections 29 and 32 would share production as would sections 30 and 31.
So when you did that, you distribute about a quarter each, 25% to each of the sections in the spacing unit, and then you would anticipate distributing that 25% to 30 and 31 to the remaining section in each of its 1280s.
That's correct. Yeah, we're going to allocate to that red box and that purple box there, roughly 25% each.
And then it would be dispersed to the other section based on the acreage.
That's correct.
Okay, thank you.
Absolutely.
You can proceed.
John, looking at G1, can you describe the structure underlying the spacing unit?
Yep, G1 is showing the upper Bakken structure, subsea TBD contours showing it dipping off to the east of approximately 100 feet across the proposed spacing unit.
Okay. And G2, describe the isopack for us.
Yep, so G2 is middle Bakken thickness, showing a general consistent thickness across proposed spacing unit of about 34 feet thick.
Okay, and on G3, what are you showing on type log?
Yep, G3 is the type log Linvig 1-35, just to the west of the proposed spacing unit. I left off the resistivity curve here. Apologies about that, but we showed the density, porosity, and the gamma ray there on this curve. Apologies about that.
Okay. I have no further questions that offer geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Tyler. Looking at E1, how would you develop this spacing unit?
Yeah, so E1 shows Interplus plans to develop that 2560 acre unit 2 mile section line well from south to north from an existing pad location there shown in section 4.
Okay. And then on E2, what summarize the reservoir data and then the economics?
Yeah, again, you can see the reservoir properties on that top table. Or looking at the middle table, you can see the OIP of 6.1 million barrels per 640 with a well EUR of around 450,000 barrels. And then an investment of 7.35 million and a PIR10 of around 0.24, which exceeds Interplus internal metrics.
Okay. Tyler, in your opinion, if the commission approves the overlapping spacing unit, is that going to prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes.
No further questions that offer the engineering exhibits and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Looking at Exhibit E1, do you plan to drill down the section line or will you be offset?
The current plan is to be right down the section line.
Okay, thank you.
Concludes our hearing for case number 32658. Case number 32659, application of Interplus Resources USA Corp. for an order amending the applicable orders for the Little Muddy Bakken Pool to establish an overlapping 2560 acre spacing unit described as sections 17, 20, 29, and 32. Township 158 North, Range 101 West, Williams County, North Dakota, and authorize 4 horizontal wells to be drilled on such unit. Granted of the relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Interplus Resources USA Corp. I believe we're going to have Cassidy Barr on this one, along with John Prim and Eva Tomova Medina.
Ms. Barr.
Yes, sir.
You solemnly swear affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief.
I do.
Cassidy, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
My name is Cassidy Barr. I'm a landman for Ford Energy. The business address is 1001 Fannin Street, Suite 1500, Houston, Texas, 77002.
And Cassidy, have you previously testified before the commission?
I have.
And have your qualifications received as that of an expert?
Yes, sir.
All right. And are you familiar with the land matters associated with the proposed spacing?
Yes, I am.
All right. I'd move the testimony of Ms. Barr be received as that of an expert.
Motion granted.
And Cassidy, let's look at L1. Can you identify the spacing unit you're requesting?
Exhibit L1 is a regional locator map of the lands associated with the proposed spacing. The red box represents the 2560 acre proposal and outlines section 17, 20, 29, and 32 in Township 158, Range 101 West.
Okay. And then looking at L2, what's your working interest there?
Interplus has a working interest of 64.3% working interest.
Okay. And then on L3, what's just the breakdown of those underlying spacing?
The red dashed box outlines section 17 and 20, where we have a 72.9% working interest. The purple box shows that we have an interest of 55.7%.
Okay. I have no further questions that offer the land exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, John, let's look at G1. Describe the structure underlying this spacing unit.
Yep, G1 is showing our upper Bakken structure in 25-foot increment subsea TVD, showing that it's the Bakken formation dipping off to the south-southeast across our proposed spacing unit there.
All right, and then on G2, just briefly, take us through the ice pack.
Yep, middle Bakken isopack showing that there's slight thickening to the north, but approximate average thickness of 43 across the proposed spacing unit.
Okay, and then the type log.
Yep, G3 is type log Wolverton 1-4 off to the southeast, approximately a mile from the spacing unit, showing triple combo centered over the middle Bakken reservoir.
No further questions that offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? Ms. Tomova Medina,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, I do.
Eva, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, sir. My name is Eva Tomova Medina, and I'm a development engineer at Cord Energy. Our address is 1001 Fanning Street, Suite 1500, Houston, Texas 77002.
And Eva, have you previously testified before the commission?
Yes, I have.
Have you had your qualifications received as that of an expert?
Yes, I have.
And are you familiar with the engineering matters associated with this proposed spacing?
Yes, I am.
Okay. I'd move the testimony of Ms. Tomova Medina be received as that of an expert.
Motion granted.
And Eva, looking at E1, how would you intend to develop this spacing unit?
Yes, so on U1, we're showing the proposed 2560 unit in the red box and the 4 proposed 4-mile wells there in purple. We're scouting a proposed surface location there on the south indicated by the gray box.
All right. And then moving on to E2, can you summarize the reservoir data for us and take us through the economics?
Yes, so here we're expecting about 530 MBO per well with a rate of return of just around 22%.
Okay. And Eva, in your opinion, would establishment of the spacing unit to allow this development protect relative rights, prevent waste, prevent the drilling of unnecessary wells?
Yes, I believe so.
Okay. I have no further questions that offer the engineering exhibits and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff? Concludes our hearing for case number 32659. Case number 32660, application of Enterplus Resources USA Corp. For an order amending the applicable orders for the Climax Bakken Pool to establish 2 overlapping laydown 19-20-acre spacing units described as sections 13, 14, and 15, and sections 22, 23, and 24, Township 158 North, Range 102 West, Williams County, North Dakota, and authorize 4 horizontal wells to be drilled in each such unit. Granted other relief as may be appropriate. All ownership parties please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Enterplus Resources USA Corp. We're going to have Ben Plank on this one, along with John and Eva.
Mr. Plank.
Yes, sir.
Do solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Ben, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, sir. My name is Ben Plank. I'm employed by Cord Energy, parent company to Enterplus Resources USA Corp. Address is 1001 Fannin Street, Suite 1500, Houston, Texas 77002.
And Ben, have you previously testified before the commission?
I have.
Have you had your qualifications received as that of an expert?
They were.
And are you familiar with the land matters associated with the proposed spacing?
Yes, sir.
Okay, I'd move the testimony of Mr. Plank be received as that of an expert.
Motion granted.
And Ben, let's look at L1. Can you identify the proposed spacing units here?
Sure, yeah. L1 is just a regional locator map. Shows the general location of the 2 proposed 19-20 acre units located in Williams County.
Okay. And then on L2, what's your working interest in each of those?
Yeah, so in the unit to the north, depicted in the orange dash line, our working interest is, well, I guess consistently it's 70.7 0.16% in both proposed 1920 units.
Sure. And then L3, just have a breakdown there of the working interest in those underlying units.
Yeah, so that illustrates our 3 stand-up 1280 base units underlying the proposed 1920 spacing units. Sections 1522, highlighted in yellow, is operated by Enerplus at 100% working interest. Sections 1423, also operated by Enerplus at 80.78% working interest. And then 1324, depicted in green, is operated by Enerplus just under 30% working interest.
All right. I have no further questions that are for the land exhibits.
Exhibits are admitted. Any questions from the staff?
Ben, I guess, so being as the entirety of the underlying 1280s being overlapped isn't being included in 1920 or in an individual 1920, can you elaborate on how you plan to allocate for the 1920s?
Yes, sir. We would allocate to the base units. So as you can see, they're originally spaced and drilled as 1280, stand-up 1280s. So we would allocate proportionally to the base units.
So, say the northern 1920 of 13, 14, and 15, you would allocate 1/3 to 13, 1/3 to 14, and 1/3 to 15, and then that would be divided and spread out to the remainder of the underlying spacing unit. So they'd end up with 6 each.
Yes, sir.
And then I guess, did you indicate that Enerplus operates the 13 and 24 spacing unit?
Correct.
Was that a recent transfer of operatorship?
No, it was originally drilled by Hess, and we acquired it. Enerplus acquired it back in 2022.
Bear with me 1 second.
Sure.
Actually, go ahead and proceed. I might have questions later.
You can proceed. Okay. John, let's look at G1. Describe the structure underlying these spacing units.
Yep, G1 showing the upper Bakken structure map, subsea DVD as well, showing that the Bakken formation is dipping off to the south-southeast across this area.
And then on G2, what just show us the isopack?
Yep, G2's middle Bakken isopack showing relatively consistent thickness of 43 feet thick across both proposed space units.
And then on G3, what are you showing the type log there?
G3 is our type log, the Pasternak 33-13, showing triple combo centered over our reservoir interval from the middle Bakken there.
Okay. I have no further questions for the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right. Eva, looking at E1, how would you develop these two 1920s?
Yes, sir. So in red, we're showing the northern 1920, and in blue is the box is the southern 1920. 4 wells per 1920, crossing the parents with pads on the east side of the DSUs.
And then Eva on E2, just briefly summarize the reservoir data and tell us what the economics would look like.
Yeah, so here we're looking at an estimated per well EOR of 391 MBO with a rate of return just under 20%.
Okay. And Eva, in your opinion, would establishment of the two 1920s that can prevent waste, protect relative rights, prevent de-drilling unnecessary wells?
Yes, sir.
I have no further questions that are for the engineering exhibits and gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff? That concludes our hearing for case number 32660. Case number 32661. Application of Oasis Petroleum North America LLC for an order amending the applicable orders for the Hart Butte Bakken Pool to establish two overlapping stand-up 1920 acre spacing units described as sections 23, 26, and 35, and sections 24, 25, and 36, Township 148 North, Range 92 West, Dunn County, North Dakota, and authorize 4 horizontal wells to be drilled in each such unit, or granting such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, bringing this case on behalf of Oasis Petroleum North America LLC. I think we're going to have Keith Swiderski, Ben Dotson, and Caitlin McNeely here.
Mr. Swiderski.
Yes, sir.
Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge or belief?
I do.
Keith, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
Yes, my name is Keith Swiderski. I'm a senior staff landman with Cord Energy, a parent company to Oasis Petroleum North America. And our business address is 1001 Fannin Street, Suite 1500, Houston, Texas, 77002.
And Keith, have you previously testified before the commission?
Yes, sir, I have.
Have you had your qualifications received as that of an expert?
Yes, sir, I have.
And are you familiar with the land matters associated with the proposed spacing?
I am.
All right. I'd move the testimony of Mr. Swiderski be received as that of an expert.
Motion granted. And
Keith, let's look at L1. Can you identify the two spacing units you're asking for?
Yes, sir. So L1 being the regional locator map. These are two stand-up 1920s located in 14892. One of them being sections 23, 26, and 35, and the other being sections 24, 25, and 36.
Okay. And then I guess the western spacing unit, L2, what's your working interest there?
Yes, sir. We own a 62.55% working interest.
All right. And then L3, the breakdown on that one?
Yes, sir. So for the western spacing unit, it's made up of two underlying 1280 spacing units, one being the laydown 1280 in sections 23 and 24, which we own a 56.41% working interest, and the other being the stand-up 1280 being sections 26 and 35, in which we own a 65.63% working interest.
Okay. And then L4, the other 1920, what's your working interest?
Yes, sir. On that one, we own a 83.39% working interest.
And then on L5, just that breakdown.
Yeah. Yes, sir. So L5, still the same, lay down 1280 to the north, section 23 and 24 with a 56.41% working interest. And then the stand-up 1280 and 25 and 36 with a 96.88% working interest.
All right. I have no further questions that offer the land exhibits.
Exhibits are admitted. Any questions from the staff?
Keith, as the proposed 1920s will not encompass the entirety of one of the spacing units being overlapped, how do you anticipate doing your allocation?
So we tend to allocate 1/3 to the underlying northern one, which is 23 and 24, and then 2/3 to the two stand-up 1280s.
So, if I could, you'll end up the proceeds from any wells on 23, 26, and 35 would be allocated 1/3 to each of those spaces or each of those sections.
It would be 1/3 to the 23 and 24 DSU, and then 2/3 to the 26 and 35 1280.
Right, but bear with me here because I want to make sure it's clear. Or I might have to ask for a supplemental exhibit real quick.
Sure.
The wells actually drilled on 23, 26, or 35 would distribute 1/3 of their oil would be allocated to each of the sections 23, 26, and 35 within that spacing unit. But where you have the original spacing unit of 23 and 24, that 1/3 would be distributed 1/6 each to 23 and 24, and then vice versa on the other spacing unit.
Yes, sir, that's correct.
Okay, thank you.
Mr. Dotson,
Yes, sir.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes, sir.
Ben, can I have you state your name, tell us by whom you're employed, what capacity, and give us your business address?
Ben Dotson is my name. Geologist. I'm employed by Oasis Petroleum North America, LLC, a subsidiary of Cord Energy. And our address is 1001 Fannin Street, Suite 1500, Houston, Texas, 77002.
And Ben, have you previously testified before the commission?
Yes, sir.
Have you had your qualifications received as that of an expert?
Yes, sir.
And are you familiar with the geology underlying the proposed spacing?
Yes, sir.
All right, and move the testimony of Mr. Dotson be received as that of an expert.
Motion granted.
And Ben, looking at G1, can you describe the structure underlying the spacing unit?
Yeah, we have the first map is the Upper Bakken structure map in 25-foot contour intervals. And as you can see that it is dipping from the southeast to the northwest. And within our acreage, within the DSUs, the average is about 7,975 feet TVDSS, or negative TVDSS. And then our pilot or type log is the Young Bear, which is to the south of the DSUs with the yellow dot.
Yep. Okay, then moving on to G2, just take us through that ice pack map.
This is an isopack thickness map of the Middle Bakken Formation in 2-foot contours, and it is thickening to the southwest. The average thickness over these DSUs is roughly 33 feet, and again, the type log well is to the south.
All right, and then on G3, what do you show on that type log?
The type log is the Young Bear 1, which is a triple combo type log that is representative to the geologic and reservoir characteristics of the DSU shown.
All right, I have no further questions that are for the geology exhibits.
Exhibits are admitted. Any questions from the staff? Ms. McNeely,
Yes.
do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
Yes.
Caitlin, can I have you state your name, tell us by whom you're employed, in what capacity, and give us your business address?
I'm Caitlin McNeely. I'm a development engineer employed by Oasis Petroleum, a subsidiary of Cord Energy. I'm located at 1001 Fannin Street, Suite 1500, Houston, Texas, 77002.
And Caitlin, have you previously testified before the commission?
I have.
Have you had your qualifications received as that of an expert?
Yes.
And are you familiar with the engineering matters associated with these spacing units?
Yes.
All right, I'd move the testimony of Ms. McNeely be received as that of an expert.
Motion granted.
And let's go to E1, Caitlin. How would you develop these two 1920s?
Yes, as you can see from this diagram here, outlined in red are the two proposed 3-mile units. We plan to drill north to south from a pad planned off spacing in section 13. It would be from a single pad. And in purple are the proposed Middle Bakken wells. There's 4 in each unit.
Okay. And let's go to E2 then. Can you summarize the reservoir data and what the economics would look like?
Yep, so the reservoir parameters shown here fall within the expected range for Middle Bakken development in this area. And as discussed, we're proposing 4 by 3-mile wells in each unit and expect to recover about 769 MBO with an investment around 9.2 million per well and a discounted PRR10 of 0.97 at $70 oil.
Okay. Caitlin, in your opinion, if the commission establishes these spacing units, would that prevent waste, protect relative rights, prevent the drilling of unnecessary wells?
Yes.
Okay. I have no further questions that offer the engineering exhibits and the gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff? Concludes the hearing for case number 32661. Case number 32662, application of Oasis Petroleum North America LLC. This case has been dismissed. That concludes the hearing for case number 32662. Case number 32663, application of Oasis Petroleum North America LLC. This case has been continued to our April hearings. Concludes hearing for case number 32663. Case number 32664, application of Oasis Petroleum North America LLC. This case has been continued to our April hearings. Concludes the hearing for case number 32664. Case number 32665. Application of Oasis Petroleum North America LLC for an order amending the applicable orders for the Foothills and or Leaf Mountain Bakken Pools, Burke County, North Dakota to 1. Establish an overlapping stand-up 1920 acre spacing and described as sections 24, 25, and 36, Township 161 North, Range 93 West, and authorize 3 horizontal wells to be drilled on such unit. 2. Establish an overlapping stand-up 25, 60 acre spacing and described as sections 14, 23, 26, and 35, Township 161 North, Range 93 West, and authorize 3 horizontal wells to be drilled on such unit. Or 3. Grant such other relief as may be appropriate. All interested parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, PO Box 2798, Bismarck, North Dakota, appearing in this case on behalf of Oasis Petroleum North America LLC. And we're going to have Keith, John, and Eva on this one.
They're all still under oath.
All right. Keith, still got L1. Can you identify the 2 spacing units you're requesting here?
Yes, sir. So the original locator map, these are located in 16193, sections 14, 23, 25, 26, and 35. That's the stand-up 2560. And then sections 24, 25, and 36, stand-up 1920.
All right. And then on L2, that 2560, what's your working interest there?
Yes, sir. Our working interest will be at 38.67%.
Okay. And then on L3, like the breakdown underlying that 2560.
Yes, sir. To the for the northern in 14 and 23, the northern stand-up 1280, we have a 77.34% working interest, and then the 2 standalone 640s being 26, section 26 and section 35, we have 0% working interest.
Okay. And then L4, the 1920. What are you looking at for working interest there?
Yes, sir. In the stand-up 1920, we own a 80.57% working interest.
Okay. And then the breakdown on that one, what's that look like? L5.
Yes, sir. It's made up of 2 underlying DSUs, one being a stand-up 1280 in section 24 and 25, in which we own a 80.86% working interest, and the other being a standalone 640, being sections 36, in which we own 80% working interest.
Okay. I have no further questions on off the line exhibits.
The exhibits are admitted. Any questions from the staff?
Looking at, I don't know that any of the exhibits really show this, but sections 2 and 11, 16193, was this development will be left as a 1280?
Yes, ma'am. That's our understanding. That is from what we understand, that is a Phoenix operated, or will be a Phoenix operated DSU, and we've spoken with them about our plans, and they're in support of our 4-mile spacing.
Are you able to submit like an email from Phoenix or some sort of something in writing that expresses their approval of this spacing?
Yes, ma'am. I think we can do that.
Thank you.
You can proceed.
Okay. John Suggett, G1, can you describe the structure underlying the spacing unit?
Yep, G1 shows that the upper Bakken, or the Bakken Formation, is present across this area of interest, and it's showing it dipping off to the southwest across the spacing units from approximately negative 6050 sub-CTVD to negative 6350 sub-CTVD.
Okay, and then G2 takes through that ice pack.
Yes, G2 showing that the middle Bakken is thickening approximately 4 feet west across the proposed spacing units from about 50 feet in the east to 54 in the west, for an average of approximately 52 feet across the proposed spacing units.
All right, and then on G3, John, what are you showing on the type log?
Yep, G3 is our type log, the OAS 31-161-92H, just to the east of our easternmost proposed spacing unit. It's a triple combo log centered over the middle Bakken reservoir interval there.
Okay, I have no further questions. I would offer the geology exhibits.
Exhibits are admitted. Any questions from the staff? You can proceed.
All right, Eva, let's look at E1. How would you intend to develop both the 2560 and the 1920?
Yes, sir. So in red is shown the proposed 2560 unit with the 3 4-mile well bores and pad on the north side, and in blue we have the 1920 unit also with the 3-mile sticks in this case, and proposed surface location on the north side.
Okay. Then Eva, looking at E2, can you just summarize for us the reservoir data and the economics?
Yes, sir. So this is the economics for the 4-mile wells, expected well EURs 535 MBO, and rate of return just under 30%.
Sure. And then looking at E3, just highlighting any differences, for the 1920.
So for the 1920, as expected, the well EUR is lower at 404 MBO per well, and rate of return of just under 20%.
Even in your opinion, if the commission were to approve each of these, both the 2560 as well as that 1920, in your opinion, is that going to protect related rights, prevent waste, prevent the drilling of unnecessary wells?
Yes, sir, I believe so.
Okay. I have no further questions that offer the engineering exhibits and gas capture plan affidavit.
Exhibits are admitted. Any questions from the staff?
Eva, looking at your E1,
Yes, sir.
your proposed 3-mile development over on the 2560 spacing unit. Do you intend to leave that gap between the eastern and westernmost wells on the southern 1280?
We'll likely steer that a little bit further to the east. So we'll minimize the gap for sure and make sure that the spacing between those outer 2 wells is equivalent in the southern part.
So you'd intend to get roughly equivalent spacing across that southern 1280?
Yes, I apologize. I should have shown the little kink on both of these.
Would your plan be something similar for the 1920 as well, the southern part of that?
Yes. Yep. The middle well bore would likely have a little shift in the last mile towards the west.
And I'm assuming you anticipate continuing to produce the existing wells, or do you plan to plug and abandon any of them?
Like as we do every time, we're planning on bringing them back on, but if there's any issues or reasons not to, then that plan might change at that time. Apologies for the background.
Okay, thank you.
Eva, when do you plan to develop these lands?
So they're currently after 2028 on our drilling plans.
Okay, thank you.
Wait, is April 1st long enough to supplement the record?
Yeah, probably. And Keith, can you reach out to Phoenix and have a discussion with them and get a response prior to April 1st?
Yes, sir.
Okay.
The record will remain open in this case until April 1st. That concludes the hearing for case number 32665. Notwithstanding the time, we're going to proceed. Case number 32383. Application of Oasis Petroleum North America LLC for an order suspending and after hearing revoking permits issued to Spotted Hawk Development LLC for the drilling of the Moose 66 MB well, Moose 67 TF well, Moose 68 MB well, Moose 62 MB well, Moose 63 TF well, Moose 64 MB well, and Moose 65 TF well, all on a spacing unit for the Deepwater Creek Bay Bakken Pool consisting of sections 1, 2, and 3, Township 150 North, Range 91 West, McLean County, North Dakota. Or granted to the relief as may be appropriate. All inter parties, please come forward.
Thank you, Mr. Examiner. Wade Mann, P.O. Box 2798, Bismarck, North Dakota, appearing on this case on behalf of Oasis Petroleum North America LLC. And Mr. Examiner, it's my understanding that we received notice like late yesterday that those permits that are identified in this case have now they've now been withdrawn, and because of that, there's no longer any need to suspend and revoke them. So we will dismiss that case.
This case has been dismissed. That concludes the hearing for case number 32383.
And Mr. Examiner, Mr. Throne just indicated the previous case for Oasis that a late filed exhibit was requested of Phoenix. They said they'd be willing to go on the record and indicate their support at this time, if that would be.
So that's in case number 32665?
Yes, correct.
Okay. I will open back up case number 32665 and ask Phoenix to come forward. Just identify yourself and I'll swear you in.
My name is Justin Arnn. I'm the Chief Land and Title Officer for Phoenix. Sorry. My name is Justin Arnn. I'm the Chief Land and Title Officer for Phoenix Operating and Phoenix Energy.
Okay. Please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
Okay. You can proceed.
I guess I can just ask you the question.
Sure.
Mr. Arnn, I think you heard the request from NDIC staff that if the 2560 consisting of 1423, 2635 is approved, there was some concern about what would happen to sections 2 and 11. I think Mr. Swiderski indicated that there's been communications with Phoenix, and it was his understanding that Phoenix is supportive of Oasis 2,560 acre spacing unit. Is that correct?
That's correct.
Okay.
Yeah, Phoenix is the majority working interest owner in that what's currently at 1280. If we had developers at 1280, we'd be more than comfortable doing that. We may have other plans for it down the road, but we do support the applicant's application for the 2560.
Okay.
Thank you. I have no further questions.
Then I'll close the record then in case number 32665 and
okay,
terminate that hearing at this point. Moving to the supplement, case number 32461, application of Whiting Oil and Gas Corp. This case has been dismissed. That concludes our hearing for case number 32461. Case number 32477, application of Oasis Petroleum North America LLC. This case has been dismissed. That concludes our hearing for case number 32477. Case number 32394, application of Phoenix Operating LLC. This case has been continued to our hearings on Friday, March 27th.
Tom, hearing that one?
Yeah,
324.
Okay, I have here. Okay. I correct myself. Case number 32394, application of Phoenix Operating LLC for an order amending the applicable orders for the Strandall Bakken Pool to establish a stand-up 2560 acre space unit described as sections 3, 10, 15, and 22, Township 157 North, Range 103 West, Williams County, North Dakota, and authorize 5 horizontal wells to be drilled in such unit or grant such other relief as may be appropriate. All interested parties, please come forward.
Yes, Mr. Chairman. Tom Throne, P.O. Box 1056 in Sheridan, Wyoming. I'm appearing on the applicant. We have 3 witnesses, all present. Tom Crook will be land. Topher Lewis will be geology. And Eric Shivy will be the engineering. And there will be a couple of cases that we can hear together, and I'll tell you that when we get to that point.
Mr. Crook, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief?
I do.
And let me take 30 seconds to get a copy of this. Okay, Tom, would you please state your name and address for the record?
Tom Crook, 4643 South Ulster Street, Denver, Colorado, Suite 1510-80237.
And for whom do you work in what capacity?
Phoenix Energy, Senior Landman.
And have you been accepted as an expert witness in petroleum land matters in the past?
I have.
And are you personally familiar with all the lands that we're discussing today and all of the applications?
I am.
Okay, starting for case 32394, would you
Excuse me,
start
Mr.
by
Drainthron,
explaining?
do you want to offer him as an expert witness?
Oh, yeah, I'm sorry. Yeah, I offer Mr. Cook as an expert
Okay,
witness.
that motion's granted.
Thank you, sir. Moving to Exhibit L1, please describe the contents of that exhibit.
Sure. L1 is a locator map showing our proposed 2,560 acre stand-up unit, which we call Wild Bill, outlined in red, in sections 3, 10, 15, and 22 of 157 North, 103 West in Williams County.
Okay, moving on to Exhibit L2, please describe the contents of that exhibit.
L2 shows our proposed Wild Bill unit in relation to another unit that we are proposing that will be heard later.
Okay, and moving on to Exhibit L3, please explain the contents of it.
Sure. L3 shows the composition of Wild Bill to be 100% fee acreage. It also shows only 3 wells exist within the unit. All are plugged and abandoned.
Okay, and then moving on to Exhibit L4, please discuss the working interest.
Yeah, and L4 shows that Phoenix has over 2/3 of the working interest in the proposed unit, with 22% still unleased, and we will work to get as much of that as we can.
And does Phoenix intend to cooperate with all the other working interest owners in developing this proposed spacing unit?
We do.
Okay, and did you also execute the gas capture affidavit attached to Exhibit E4?
Yes, I did.
I would ask that Exhibits L1 through L4 and E4 be admitted into the record.
Exhibits are admitted. Any questions from the staff?
Tom, do you guys have plans for gas takeaway in the area? If so, what are they?
Yeah, thank you, Nathan. We're looking into the Kinder Morgan Red Bank system that ties into their Watford City plan, and we always have the backup plan of valence units if necessary.
Thanks.
Mr. Lewis, please raise your right hand. You solemnly swear or affirm under the penalties of perjury the testimony you're about to give in this matter or any subsequent matter today will be true and correct to the best of your knowledge and belief.
Yes, I do.
Mr. Lewis, would you please state your name and address for the record?
Topher Lewis. Address is 4643 South Ulster Street, Suite 1510, Denver, Colorado, 80237.
And for whom are you employed and in what capacity?
Phoenix Energy as a geologist.
And have you previously been accepted as an expert witness in petroleum geology?
Yes, I have.
And are you personally familiar with all the lands that we are discussing today in all applications?
Yes, I am.
I would ask that Mr. Lewis be admitted as an expert witness in these matters.
Motion granted.
Starting with Exhibit G1, would you please describe the cross-section?
Yes.
Structure map, excuse me.
Sure. G1 is a structure map on the Upper Bakken Shale, subsurface TVD with a contour interval of 20 feet. The structure in this area is plunging to the southeast. The red outline is our proposed 2560 spacing unit, and the gold line is a 3-well cross-section, and in that highlighting the type well that we reference in the next exhibit, which is the middle of the 3 wells.
Okay, and moving on to Exhibit G2, please describe the cross-section as well as the reservoir properties that are at the bottom of G2.
Yeah, G2, the upper portion is a 3-well cross-section, plotting curves from a common triple combo log suite gamma ray resistivity porosity. Black lines represent the tops that we use for our generalized stratigraphy in the area, and they illustrate that the Bakken system is present here on the subsurface. And our target for all of these is the middle Bakken. I can see in the diagram that the top's got a little bit shifted on the left, but we are going to be targeting the middle Bakken here. And then the lower portion is a table of reservoir properties from the Manger 1-14 that we'll be using for the reservoir engineering exhibits that follow.
I would ask that Exhibits G1 and G2 be admitted into the record.
Exhibits are admitted. Any questions from the staff?
Topher, you pointed it out on G2, but the middle Bakken target indicator on the exhibit is in the wrong spot.
Correct.
Do you, I believe historically you've presented that you intend to target the lower portion of the middle Bakken? Is that correct?
Middle to lower portion of the middle Bakken. We find that steering in the lower part gives us a little bit better ROP.
So that would be where you would intend to target in this case?
Yes, the middle lower part of the middle Bakken.
Okay, thank you.
Mr. Shivy, please raise your right hand. Do solemnly swear affirmative penalties of perjury and testimony about to give in this matter, or any subsequent matter today, will be true and correct to the best of your knowledge and belief.
I do.
Eric, would you please state your name and address for the record?
Yes, my name's Eric Shivey, Shivey, and my business address is 4643 South Ulster Street, Suite 1510, Denver, Colorado 80237.
And for whom do you work in what capacity?
I work for Phoenix Energy. I am Vice President of Reservoir Engineering and Corporate Reserves.
And have you previously been accepted as an expert witness in petroleum engineering by this commission?
Yes, I have.
And are you personally familiar with all the lands that we will be discussing today?
I am.
I would ask that Mr. Shivey be accepted as an expert witness in petroleum engineering.
Motion granted.
Okay, starting with Exhibit E1, would you please describe the typical wellbore diagram that Phoenix uses in these wells?
Yes, this is our 3-string casing design we typically use in the Williston Basin. 9 5/8 surface casing, 7-inch intermediate landed through the middle Bakken, and then drilled with a 6-inch hole and installed 4.5-inch liners cemented in place. We typically complete 4-mile laterals with 105 frac stages.
Okay, using Exhibit 2, please describe Phoenix's proposed development plan for this spacing unit.
Yes, we're applying for 5 4-mile laterals in this DSU, so approximately about 1,050 feet apart. You can see we have a proposed pad location kind of in the south central part of section 22 there. We've identified, and we would plan to batch drill and complete these wells.
Okay, going to Exhibit 3, using reservoir parameters, would you please discuss the well economics anticipated by Phoenix?
Yeah, sure. In the top table, the first couple lines describes our ARPS parameters used to get the oil EUR of 725,000 stock tank barrels of oil per well. EUR is about 870 mmCF per barrel using 1.2 MCF per barrel GOR. That yields a DSU recovery factor of approximately 12.2% from the parameters given by Mr. Lewis on Exhibit G2. Second table is just our reservoir economics. I'm running $70 WTI. That's about the average of the 5-year strip right now. I know you can tell you spots about $90 a barrel. It's fluctuating a lot, but the 5-year strip's been pretty consistent lately. So, and realized oil $3.50 per MCF gas, and then with the deducts, I'm running about $64.35 per barrel at the wellhead. D&C cost for these, each well is about $11.76 million D&C per well. That yields a PV10 8/8 economics of 7.1 million per well, internal rate of return of about 40%, and undiscounted payout of approximately 2 years, just slightly under.
I have no further questions for Mr. Shivey and ask that Exhibits E1, E2, and E3 be admitted into the record.
Exhibits are admitted. Any questions from the staff?
Eric, did you say when you guys plan to develop these lines?
Actually, I did not. We're looking probably this would be the second half of 2027. We're starting to build out our drill schedule beyond Q2 of 2027 right now.
Thank you.
Yes.
That concludes the hearing for case number 32394. Case number 31928, application of Burlington Resources Oil and Gas Company LP. This case has been continued to our April hearings. That concludes the hearing for case number 31928. Case number 31929, application of Burlington Resources Oil and Gas Company LP. This case has been continued to our April hearings. That concludes the hearing for case number 31929. Case number 31930, application of Burlington Resources Oil and Gas Company, LP. This case has been continued to our April hearings. Concludes the hearing for case number 31930. Case number 31977, application of Burlington Resources Oil and Gas Company, LP. This case has been continued to our April hearings. That concludes the hearing for case number 31977. Case number 32377, application of Kraken Operating LLC. This case has been continued to our April hearings. That concludes the hearing for case number 32377. Case number 32301, application of Kraken Operating LLC. This case has been continued to our April hearings. That concludes the hearing for case number 32301. Case number 32396, application of Phoenix Operating LLC for an order amending the applicable orders for the Sheep Butte Bonk and Pool to 1, extend the field outline to include sections 15 and 22, Township 148 North, Range 103 West, within the Sheep Butte Bonk and Pool. 2, establish a stand-up 2560 acre spacing unit described as sections 3, 10, 15, and 22, Township 148 North, Range 103 West, Mackenzie County, North Dakota, and authorize 4 horizontal wells to be drilled in such unit. According to the releases may be appropriate. All interested parties, please come forward.
Mr. Chairman, Tom Throne appearing on behalf of Phoenix Operating. Pursuant to the discussion earlier this morning, by about 10 o'clock or so, Phoenix Operating filed a written motion for continuance of 32396 as well as 32397, and it should be in the file.
Okay, so case numbers 32396 and 32397, which is also an application of Phoenix Operating LLC, are both continued to our April hearings. That concludes the hearings for case numbers 32396 and 32397. Case number 32378, application of Kraken Operating LLC. This case has been continued to our April hearings. That concludes the hearing for case number 32378. Case number 32581, application of Phoenix Operating LLC for an order amending the applicable orders for the Cathmere and Winter Butte Bonk and Pools to establish a stand-up 2560 acre spacing unit comprising sections 5, 8, 17, and 20, Township 149 North, Range 103 West, Mackenzie County, North Dakota, authorizing up to 5 horizontal wells to be drilled in said unit and or such other relief as may be appropriate. All interested parties, please come forward.
Mr. Chairman, Tom Throne, P.O. Box 1056 in Sheridan, Wyoming. I would suggest that case 32581 and 32585 be combined. The exhibits are identical except for the land exhibits, and I would propose the easiest and quickest way, given the circumstances, would be to do hearing 32581 and then do the land exhibits for 32585, because all the other exhibits are the same and both of them can be taken care of rather quickly.
Okay. For the purposes of hearings, I will consolidate 2 cases and now call 32585 as well. Application of Phoenix Operating LLC for an order amending the applicable orders for the Yellowstone and Winter Butte Bonk and Pools to establish a stand-up 2560 acre spacing unit comprising sections 6, 7, 18, and 19, Township 149 North, Range 103 West, Mackenzie County, North Dakota, authorizing up to 5 horizontal wells to be drilled in said unit and or such other relief as may be appropriate. You can proceed.
Okay, I have the same 3 witnesses. Mr. Crock.
They are still under oath.
Starting with Exhibit L1, would you please describe the lands that are subject to this application being 32581?
Sure. Exhibit L1 is a locator map showing our proposed 2,560 acre stand-up unit, which we call BOA, outlined in red in sections 5, 8, 17, and 20 of 149 North, 103 West in the grasslands area of Mackenzie County.
Okay, are there any unusual circumstances around this particular spacing unit?
Yes, actually this unit is unusual in that it's comprised entirely of both leased and unleased federal minerals and has very limited access. In fact,
moving to Exhibit L2, you want to discuss that?
Yeah, in fact, in Exhibit L2, we show that there are only 2 roads that provide access to this broad area, and only one of those crosses private surface ownership, which is necessary for constructing a drill pad. And there are federal restrictions on building any additional roads. And Because of these constraints, we believe that the spacing we propose is not only the best way, but the only way to space units in this area in order to protect the correlative rights, prevent waste, and avoid drilling unnecessary wells.
And Exhibit L2 contains another spacing unit that's not subject to this hearing, but will be in the next hearing.
That's actually case 32585.
Okay.
Right next door.
Okay.
But I should note that Phoenix has done a lot of legwork already, paying to nominate all of the unleased fed in the area and establishing relationships with the surface owners and working to secure surface agreements. We haven't yet, but we're working on that with the owners in Section 20.
Okay, moving on to Exhibit L3, would you discuss the working interest ownership?
Sure. Exhibit L3 shows that we own a little over 26% of the working interest in this unit, with over 2/3 of the unit being unleased federal, and about a little over 6% in the hands of other owners at this time.
Has Phoenix nominated the unleased federal acreage for lease?
Yes, we've paid to nominate, in fact, all the unleased federal in this area.
And so why are you spacing this particular unit and the next unit now?
Well, because we intend to bid on the federal acreage when it comes up for lease sale, and should we win that auction, we don't want to have to at that time wait for spacing to be established.
And in the event you drill this particular spacing unit, will Phoenix cooperate with the other working interest owners?
We will.
Okay, then moving to L4, please describe the location of the unleased beds and the acreage that Phoenix owns.
Sure. L4 shows the various areas of unleased fed, which at this point prohibit drilling. There is a bit of leased fed as well, about 1/3, and most of that is in sections 8 and 17.
I have no further questions for Mr. Crock. I would ask that exhibits L1 through L4 be admitted into the record.
Do you want to admit the land exhibits from the other case too?
Yeah, let's admit them for the other case too.
Okay, and those are L1 through L4 as well?
I believe so, yeah, but there are some differences in 32585 on
You
the
want to
land
ask some questions about them?
You want me to ask them now?
Go ahead.
Oh, okay. Tom, move to the exhibits in 32585, if you would, please.
Okay.
And briefly describe Exhibit L1. It's the same kind of exhibit as last time, but a different spacing unit.
It is. This shows the unit that we call Cobra, outlined in red, moving over to sections 6, 7, 18, and 19 in the same 149 north, 103 west.
Okay, then is Exhibit L2 the same as we discussed in the last hearing?
Yes, it is.
Okay, and the same issues exist here as existed in the other spacing unit we discussed in 32581.
Correct.
Okay, moving on to Exhibit L3, which is different
Yes.
than the last one. Please describe those differences and significance.
Sure. L3 breaks down the working interest within the proposed unit, showing that Phoenix has the majority of the working interest with a federal lease that we acquired. As I mentioned previously, we've nominated the unleased federal minerals for lease sale.
And you're spacing them now for the same reasons as last time, so that you can immediately drill if you win the lease.
That is correct.
And in this case, you might drill anyway because of your existing ownership.
Yes.
Describe the ownership in Exhibit L4, please.
Sure. In L4, it shows that over 90% of the The Fed is in the area that we show in white, 2,297 acres, and there are some tracts. There's a tract A that involves 238 acres of leased and unleased fee.
Okay. And if this is approved, will Phoenix likewise cooperate with other working interest owners?
We will.
Okay, now I would like exhibits L1 through L4 of case 32585 admitted into that record.
Exhibits are admitted. Any questions from the staff?
Tom, you indicated in case 32581, due to the federal unleased tracts, that Phoenix won't drill until they determine or until they find out whether they're successful on the bid. However, you could drill currently in the 2560 for case 32585. When is that determination going to be made by Phoenix as to whether or not they'll proceed with drilling the 2560 and 32585 versus waiting for both of these?
I'm not the one to make that decision. I'm not aware of when that or why that decision would be made.
Do you know when you'll have an answer on the nomination for the federal leases?
On the nomination, it's all been nominated by us.
Do you know when you'll get or when the bid is and when their chance is?
No, but we anticipate it would be somewhere between the beginning of 2027 and mid 2027.
So is it in your opinion that the soonest spud date for either of these spacing units would be of 2027?
Yes.
Thank you. Tom, looking at your L4 for 32585, this takes a little bit different form than 32581. The white being federal, you indicate leased and unleased in that area, and same for the red, the fee. Could you provide an L4 that identifies which portion of each is leased versus unleased? So basically, I need 4 colors instead of just 2.
I probably can. I'll let you know. In section 6, we have the entire lease there of 632 acres. In section 7, we have over 394 acres. And in section 18, we have over 158 acres.
We will supply a supplemental exhibit, and we'll call it Exhibit L4A, that will distinguish between leased federal acreage and unleased federal acreage, and the proposed spacing unit.
I would just ask you also include the leased fee and unleased fee separate.
Unleased fee, yeah, we can do that.
Thank you.
You can proceed. Oh, I'm sorry. Go ahead.
Tom, is Phoenix Energy 1 LLC the same as Phoenix Operating? So on L3 on both applications, it's Phoenix Energy 1. Is that a separate fund?
It's one and the same, Nathan. The Phoenix Energy 1 is the current name of the overall company, and Phoenix Operating began as an independent subsidiary, but it's all one company now.
Okay, thank you.
You can proceed.
Okay, call Mr. Topher Lewis. Topher, beginning with G1, first before we go forward, the exhibits that you're going to present, the geologic exhibits are the same for both applications, is that correct?
Yes.
Okay, starting with G1 on either set of exhibits, please describe the structure map.
Sure. G1 for both exhibits, structure map, Upper Buchan Shale subsurface TVD with a contour interval of 20 feet. In this area, the structure is plunging to the northeast. And the red outline in both exhibits, although slightly different, the red outline are proposed 2560 spacing units. And the gold line, identical in both, is a 3-well cross-section, highlighting a type well in the middle that's used in both exhibits for both.
Moving on to exhibit, well, G2, and that would describe the cross section and also the type log that you have labeled on G1 on G2.
Correct. Yeah, G2, the upper portion is a 3-well cross section, plotting curves from a common triple combo, gamma ray resistivity and porosity. And the black lines represent the generalized stratigraphy in the area, illustrating that the middle Bakken system, or the Bakken system, is present in the subsurface. And again, our target in this area is the middle Bakken, and optimally, when we steer, we go for the middle lower portion of the middle Bakken. And then the lower table is a table from the USA 24-4, which is the type well that we use in both exhibits. And those are the reservoir properties that will be used in the engineering exhibits.
I would ask that exhibits G1 and G2 on both applications be admitted into the record.
Exhibits are admitted. Any questions from the staff? You can proceed.
Okay, Eric, move on and briefly describe the exhibits E1 and E2 for the staff.
Yes, E1 is our wellbore diagram. This is identical to what I presented in case 32394 earlier.
Okay, and then talk about the development plan for both proposed spacing units that you've described on exhibit E2.
Yes, this is just showing our planned development of 5 wells, again, spaced approximately 1,050 feet apart internally, and they would be batch drilled and completed.
Okay, and moving on to exhibit E3, describe your anticipated economics.
Yes, this is just, again, the top table describing our anticipated EUR and GOR. It's about 2,000 SCF per barrel GOR in this area. We anticipate EUR per well is about 550 MBO. When you normalize that on a per foot basis, it's about 25 barrels per foot. With 5 wells, that yields a DSU recovery factor of approximately 15.3%. Economics, again, I ran at a flat $70 oil WTI and a $3.50 Henry Hub. That realizes a PV10 of $5.7 million per well, 8/8, and internal rate of return of approximately 39% and a payout of about 1.9 years per well.
Okay, given the land discussion that we had earlier, are you contemplating putting these lands on a drill schedule at some point in time?
Yes, Tom. Like I said in the previous cases, we're planning out for Q3, Q4, 2027 and beyond. And as this would number, these would require FED permits. Short answer is probably Q4 of 2027 at the earliest for spuds.
Assuming the Fed leases are
Correct.
And Phoenix wins.
Correct.
Okay, Mr. Chairman, I would ask that exhibits C1, E2, and E3 be admitted into the record, and I need to ask one more question to Mr. Kroc. Did you execute the gas capture affidavit on E4 for both applications?
I did, yes.
And I would ask that exhibit E4 be admitted into the record.
Exhibits are admitted. Any questions from the staff?
Eric, I believe the land testified to this, but currently you're anticipating drilling these wells from the south to the north. Is that right, with a pad possibly located in section 20?
That's correct. And, I apologize. I made an update to these slides to include that surface location. So if it's acceptable, I can certainly supplement these exhibits for E2 for both 32581 and 32585.
I think your testimony is fine. Thank you.
Tom, is April 1st long enough to supplement the record?
You guys can get it done by April 1st, can't you, in a week? That exhibit with unleased fee and unleased fed?
I'm told yes.
Okay.
I'm told yes.
Okay. The record in these cases will remain open until April 1st. That concludes our hearings for case numbers 32581 and 32585. Case number 32586, application of Phoenix Operating LLC. This case has been continued to our April hearings. That concludes our hearing for case number 32586. Case number 32587, application of Phoenix Operating LLC. This case has been continued to our April hearings. That concludes our hearing for case number 32587. Case number 32588, application of Phoenix Operating LLC. This case has been continued to our April hearings. Concludes the hearing for case number 32588. I will now turn back to the original docket, case that was originally scheduled for the admin docket. Case number 32687, application of Farada Energy LLC for an order amending the applicable orders for the Buford Bakken Pool to authorize up to 4 horizontal wells to be drilled in an approximately 1920 acre spacing unit described in sections 3, 10, and 15. Township 152 North, Range 104 West, Williams and McKenzie Counties, North Dakota, or granting such other relief as may be appropriate. I will note that we have received a letter from Devon, in part supporting it, but not supporting Farada as the operator. And that would allow interested parties to appear. I will note for the record that no parties have appeared. That concludes the hearing for case number 32687, and that concludes our hearings for the day.
Thank you, guys.